All right. Good morning. We are going to begin the public hearing here in Judiciary Wednesday, March 26th. We have over 50 people signed up, so we are going to try to keep the business moving. For your information, if you don't know, when you approach the seat that is directly in front of me, if the microphone is not illuminated, there is a button, red button, that will illuminate the microphone. That also activates the microphone. You get 3 minutes to provide us with your testimony. I will tell you, as someone who has sat here for a long time and also used to come and testify, 3 minutes goes longer than you think if you haven't really practiced your testimony. So if you have it written, we have access to that. You may want to summarize. That would allow you to get it in. At the end of your 3 minutes, there is a sound that will alert you to the fact that your time has elapsed. I will try to be courteous to you and get you to recognize your time has elapsed. The longer you go after I try to do that, the less courteous I will be. For those online, I know it's difficult for you to hear. We will make several attempts and then we'll figure out how to get you to stop so that we can get in the comments or questions that there are. We are not trying to be rude. We are just trying to make sure that everybody has an opportunity to provide us with their testimony. With that, we will begin. And one more comment. If you get past, uh, unfortunately, we're trying to get everyone in. So you will go to the end, and at the end, we will see if you are here, unless there are highly special circumstances, which we know about in advance, or some crazy thing with your computer that comes about. All right. So we will begin with Teresa Kominos. See you there. There you go.
There we go. Good morning, Chairs Winfield and Stastrom, and members of the Joint Committee on the Judiciary. Thank you for allowing my testimony this morning. My name is Teresa Kominos, and I'm here on behalf of Human Rights for Kids. As a brief introduction, Human Rights for Kids is a national nonprofit organization dedicated to the promotion and protection of the human rights of children. Our work centers a human rights framework to highlight and better understand the connection between adverse childhood experiences and childhood trauma, the justice system involvement, and negative life outcomes. Human Rights for Kids is here in support of Senate Bill 1542, raising the minimum age of arrest in juvenile delinquency jurisdiction to 14 years of age. The establishment of a minimum age of prosecution is a human rights issue, and raising the minimum age of prosecution is further affirmation of the ways our laws should recognize that children are fundamentally different than adults and that their brains are not fully developed. Specifically, Article 40 of the UN Convention on the Rights of the Child states that lawmakers must create a minimum age below which children shall be presumed not to have the capacity to infringe the penal law. Further, the UN's Global Study on Children Deprived of Liberty recommends that all UN member states set a minimum age of criminal responsibility no lower than age 14. These policies are based on the understanding that young children developmentally do not have the legal capacity to form criminal intent or the competency to comprehend basic legal principles. Raising the minimum age of jurisdiction would position Connecticut as a leader in states who differentiate the age of jurisdiction based on the offense charged. In Maryland, for example, the minimum age of prosecution is 13 years of age with specific carve-outs to the law for more serious offenses. Nevertheless, no child in Maryland under the age of 10 years old, regardless of the offense, may be criminally prosecuted or adjudicated delinquent. Several other states, including California, New York, Utah, and New Hampshire, have established minimum age of prosecution of either 12 or 13 years of old with carve-outs to the law for specific offenses. Additionally, in Massachusetts, the minimum age of jurisdiction for delinquency proceeding for any offense is 12 years old. In the vast majority of cases, children who come into conflict with the law are contending with early childhood trauma and unmitigated adverse childhood experiences. Studies have shown that approximately 90% of children in the juvenile justice system have experienced at least 2 ACEs, and 48% have experienced at least 4. Raising the minimum age of prosecution is sound policy that is rooted in the research which has shown that diversion of young children away from court and providing them with the proper treatment and trauma-informed services offered by other systems better equipped to address their needs benefits the child, their family, and the community. After similar legislation was passed in Utah, which shifted the focus for younger children from court to diversion and participation in community-based services. 98% of youth who were referred to early intervention diversionary programs were able to complete the program and avoid probation or secure custody. Excluding the youngest children from prosecution leads to better outcomes for youth and increased public safety, and provides children with more direct access to the services needed to address any underlying trauma or negative behavioral health concerns.
Ms. Kominos, your time has elapsed, so we are
Thank you.
going to thank you. We're going to see if there are comments or questions for you from members of the committee. Is there a comment or a question from the members of the committee? Comment or question from members of the committee? Representative Fishbein.
Thank you, Mr. Chairman. Good morning. Thank you for testifying here today. I just walked into the room. I heard your comments at the end, and I believe you're here in support of 1542. Is that correct?
Yes, that is correct.
So, where is the line in your mind of arrest of a juvenile? Because we changed this, I think, 4 years ago. And now what's before us is to change it again. So where's the line?
So maybe when you came in, what I had started with is that we base our framework on international human rights law, and the human rights coalitions have said that 14 should be the minimum age of criminal responsibility. And so my understanding of the bill that's in front of you today is that it would eventually raise the age to 14 years of age, with specific carve-outs for some more serious offenses where a child between the age of 10 and 13 could be charged criminally.
Okay, so I understand that you're appearing here remote. Where are you located today?
In New York.
Okay. Do you have any knowledge about Connecticut law and procedure with regard to juveniles?
So we're a national-based organization. And so my knowledge of Connecticut is just based on our research nationally on each state and the laws in that state. So we produce a state ratings report every year that looks at 12 different categories of the law and how each state treats a child in each of those interactions. And so that is the research I've done into Connecticut on our 12 categories of law.
Okay.
And minimum age is one of those.
Yeah, so I'm just trying to figure out, because I've been to juvenile court, you know, with juveniles. So, and I think you answered the question already. I just wanted to make sure. So you're basing your support on international law and the fact that somebody has decreed that 14, no matter the demographics of the individual, is the appropriate age?
Not completely. So as I was saying, we base our framework on international human rights laws, but also we reframe it in the national context of the US. And so there are a number of states in the US who have adopted very similar laws to this that raise the age for the less serious offenses to 12, 13, 14 years old. And then for more serious offenses, allow carve-outs to the law where children younger can be charged.
So when you say the less serious offenses, I believe under the language that is actually before us, a juvenile or an individual who is under the age of 14 years cannot be arrested for a Class A misdemeanor. Am I reading that correctly?
That was my understanding. So my understanding was that the children under 14 that could be arrested, the carve-outs were for A or B felonies.
Okay. So are you aware of what Class A misdemeanors are in Connecticut?
So I don't want to misspeak. I don't have that kind of knowledge of specific Connecticut criminal provisions off the top of my head. And I will leave that to other members who are testifying today who are going to have better knowledge of that. We're here as a national organization who supports these policies.
Okay. Could you direct me to, on our list, who I should be listening to with regard to that information? Because I always hear, well, somebody else is going to testify, but those people never show up. So who in particular would you like to direct my attention to that's going to testify today?
So I am aware of Christina Coranta from the Connecticut Justice Alliance, and she has very specific knowledge about Connecticut procedures and the state of the law in Connecticut. And so I would, from my understanding, I would direct your attention to her.
Okay. I just, I just want to bring to your attention that there are some significant Class A misdemeanors in the state. Strangulation or suffocation of another individual is a Class A misdemeanor. So what we would have before us is that if one perpetrated that and they were under the age of 14, they could not be arrested. Criminally negligent homicide, 53A 58, is also a Class A misdemeanor. So I understand the level of acumen, and I appreciate your candor with regard to the answers to the questions. And thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us today.
Thank you.
Next, we have Jordy Ohides. Jordy. Okay. Mark Donald. Good morning. You may testify.
Good morning, members of the committee. My name is Mark Donald, President and CEO of Catalyst Connecticut, an organization in Bridgeport that focuses on behavioral health, working with disconnected youth across the range of perspective. So I'm here to speak in general about the Raise the Age bill as well as the JJPOC bill. And I come to it at three different perspectives. One, a personal perspective as a father of two boys. Two, as a professional who's worked as an educator in the Bronx, New Haven, Stanford, and now Bridgeport for over 25 years. I also come to it as somebody who wasn't trained as a public health professional, but now is acting in a public health capacity. Because many of these issues that we're talking about are truly public health issues that impact our young, specifically our Black and brown youth that we're talking about here. And as a father of two teenage boys, I think about the behavior at 13 where, and he'll kill me for saying this, but my 13-year-old would literally get in bed and snuggle, cuddle with his mom as a comfort thing. That's age-appropriate behavior, right? You know what else is age-appropriate behavior? When you're out with your buddies and you start taking risks and you're curious, right? Without thinking about consequences. When I was that age, I liked to play with fire. These days, when people leave fobs in cars and stuff, they do that. However, arrest, and I think the purpose of arrest is what we're talking about when we're talking about Raise the Age. And what are we looking to accomplish with this? The other piece of it is so important in these bills is the concept of restorative justice and restorative practices. Those, we have evidence to support that those issues are so much more impactful in addressing youth crime for future and to end it all. Is it all encompassing? No. Is it completely effective? No. However, we've made a lot of progress in this in Connecticut and how we're approaching things. And one of the things I think about on our end is the mediation program, which is not listed as a diversionary tactic here, but our mediation program in Bridgeport, Bridgeport, Norwalk, Stanford, Torrington, and sometimes Waterbury, is 96% effective in adjudicating cases. Not only is it 96% effective, it's cost effective. The program costs us as an agency about $2,000 to $3,000 per case, which the cases average 3 to 4 people, including victims. we estimate that the court cost would be between 6,000 and 8,000. So worst case scenario on our end, it costs us 3,000. Best case scenario on the court end, it costs 6,000. So each case we mediate is a net save of 3,000. That is all privately funded right now. The other piece that I think is truly important in the JJPOC bill, and I'll wrap it up, is the talk of systems. There's a group of nonprofits
So
who
hold
work
on,
with
hold
these
on,
youth.
hold on. I get that you didn't finish, but I'm going
Got
to,
you.
I'm going to say this
It's
to
early.
everybody. All right. Comment or question, Representative Fishbaugh.
Thank you, Mr. Chairman. Good morning, sir.
Morning.
Good. On the raise the age situation, the language before us would preclude the arresting of a juvenile for anything other than a capital felony, a Class A or B felony. You recognize that?
Yes, sir.
So Class C felonies can't arrest somebody who's 14 years, under 14 years of age. Are you aware of what Class C felonies are?
I'm familiar, yes. Can I speak to every one of them? No.
Okay, and just what is your acumen in this area?
So I'm an educator of young people for 20 years, teacher, principal, including heavily gang-involved young people, middle schoolers in the alternative setting in New Haven, as well as now a nonprofit CEO for 7 years.
Okay, so
So I'm a practitioner, to answer your question.
Sure.
Not a lawyer.
Understood. So one of these Class C felonies that a juvenile would not be able to be arrested for is assault in the second degree with a firearm resulting in serious physical injury. So should this language pass, what is the process that the juvenile would go through if charged with, although really aren't charged because there's no arrest, with or at least is thought to have committed the elements that would account to assault in the second degree with a firearm resulting in serious physical injury? What would happen with that?
Yeah, so in my world, the term all behavior has meaning, right? And for an 11 to 14-year-old who conducts this type of behavior, there's a reason behind that. And I think about one of my young people. He was 11 and he was a registered sex offender before puberty. So what does that tell you about what happened to that young man? That is that clearly it's generational. We've got issues of trauma. We've got issues that we have to address. And I think this is one of the good parts about this bill is there's a needs assessment of each young person. So it's identifying why this young person, is it psychological? Is it psychiatric? Is it something that we can address to prevent happening in the future? And so I think, as a practitioner, that's where I come from. That's where my experience tells me, and that's what the data I've collected as an organization along the way tells me is successful when we think about that.
Okay, so that had nothing to do with what I asked you, but
You asked me what the process was?
yeah, the process. So
you conduct a needs assessment, right?
Okay.
Which can include psychological and psychiatric analysis, right? And then you develop a treatment plan. Now there's a restorative piece of that as well. And what we would do as an organization is we would provide them a mentor, a credible messenger, somebody who has made mistakes in their past and served time. So they're likely to be able to communicate with that young person. Also typically a male for a credible messenger. We would conduct a restorative justice plan. And that's literally where the young person and the victim, if the victim is willing to sit at the table and the victim communicates to that young person the impact on them.
can you indicate to me in the bill, which is 50 and 42, where what you're talking about appears?
I would have to find it, but
I
you know
don't
what?
see-
The needs assessment is the key part,
Okay,
and that's in there. So how each program, and I think that's where I was getting when I ran out of time, is the systems that in place. And we have a group of us who work with young people on a daily basis that have a range of services that we can lean on and develop best practices to address, and then determine through continued data collection what's working and what's not.
Okay, I want to bring you to the actual language that's before us. What it says is that a juvenile that is suspected of committing that crime, which is not necessarily a single incident.
Mhm.
So, I mean, kids and guns is a bad situation,
Terrible thing.
right? So a kid brings a gun into a school and shoots up their classroom, but nobody dies. Okay. That's assault in the second with a firearm causing serious physical injury. Okay. You've got 20 victims. What you're telling me is that that individual could not be arrested. In the process, it's in the bill. Starting at line 59. It says they shall issue a ticket to the child and the child's parent or guardian, referring such child to a juvenile review board, youth service bureau, or other appropriate program or service for management of such child's case. So what's the power of a juvenile review board to, let's say, hold that child outside of the community to prevent additional harm? Do they have that power?
Right. So I think one, my understanding of the bill, again, I'm not a lawyer, is that it's not all encompassing, and this extreme situation that has not happened in the history of the United States for a young person 11 to 14. You know, the hypotheticals that we can deal with, I believe in the bill, there's provisions for an extreme circumstance.
Where are those provisions, sir?
Again, I don't have the bill in front of me. I'm happy to send you the language that is my understanding.
Another Class C felony would be manslaughter in the second degree. So now somebody is dead as a result of an act by a juvenile and they get a ticket. That's the process.
Yeah, I mean, again, I think we can deal in hypotheticals. I would like to lean on the evidence that's happened over the past year, and you know, the God forbid that happens. The needs assessment is key. Perhaps, you know, there's serious psychiatric issues which would require a secure facility, right?
And
Which would not be up to a JRB.
Exactly. JRB does not have that power.
Right.
A court would, but JRB does not.
Right.
So, you know, my concern is I just read about a case in New Jersey. A 14-year-old shot a police officer, shot two police officers, actually. One died. The other one is not dead. And I understand under this language, because you know, if we were to take that and bring that forward to Connecticut, because one of the individuals passed, it would rise to an A or a B felony, so it wouldn't apply. But that's what's going on. And I've got a lot of problem with moving the age again. When we have kids that are going, we have diversionary programs. We have given JRBs a lot of power, well, a lot of authority without power, because I see the revolving door where the JRB says, you know, do this. The kid doesn't do that. You know, probation officer at juvenile court may find out about that situation, and it's a revolving door. It goes right back to the JRB because the juvenile court doesn't have jurisdiction. So, you know, that's what I'm dealing with, boots on the ground here. And I don't see things getting better in this area. So that's my concern.
Yeah, and I understand that. And, you know, my boots on the ground experience with our JRB is we're about 81% successful. Is it 100? No, we're trying to get there. And in terms of revolving door, it's less than a handful of cases that come back to us. And there's two things about the JRB and the way we work with probation. One, when they do come back to us, it's typically a completely different offense, right? So also misdemeanor related currently. So we treat it differently, just like you would with a different illness coming to the doctor. The other piece of it, if it's the same events, they've already had one bite of the apple, so they can't come back to the JRB currently. Again, with the way we look at it is the young person, the needs assessment. We had a young person yesterday where the mother did not want to participate in the JRB. Ultimately, she recognized that that was the best place for her son in terms of staying out of the court system. The other thing is the court system, as it currently operates, backed by data, is like a spider web. Once a young person touches it, they tend to be stuck in it over and over again.
I appreciate that. You know, you said something about you can't come back to the JRB again. I don't see that in this language either. And, you know, there are some Class C felonies that are sex assault, right? So you get a young person who commits a sex assault, and under this bill, it goes to the JRB. And they commit another sex assault the next week. Where's it going? It's going to the JRB. And they commit another sex assault the next week. Where's it going? It's going to the JRB, because the language says they can't be arrested. They can't go to juvenile court. And maybe that kid needs help. I understand. And I had a sex assault 4 case in juvenile court. And through the court, I was able to get that young man some help. But this is this doesn't stop recidivism. But anyway, but thank you for coming here today. Thank you, Mr. Chairman.
Thank you. Senator Gaggar Wilcox.
Thank you so much. Thank you for being here and for your testimony, and for the work that you do. Before I was teaching, I was the director of a violence prevention program myself, and I understand and value the importance of these programs to reduce for violence prevention, right? Starting with preventative strategies to begin with before we start talking about even getting to the point of incarceration. I'm just have questions for you about the context now, given the sort of funding, right, challenges that we're seeing at the state level, at the federal level, and even in terms of philanthropic contributions. What are the challenges you're facing, given that we probably already haven't invested enough in this area? Are you having conversations with other organizations that are doing this work that, again, I want to emphasize is so vital to help prevent, right, creating that pipeline in the first place? And, what conversations are you having around that work with other organizations, and where are those sort of investments going to be coming from in the near future?
Yeah, thank you. And obviously, it's very clear across in every facet that funding is a massive challenge. And as I said, our mediation program is a massive public benefit. For 10 years, it's been privately funded. So I and my colleagues are always on the hunt for private philanthropic dollars to support the needs, to address the needs of young people in a preventative, but also an intervention way. And we have a group that we recently formed of nonprofits across the state. It's OPP, Forge City Works, and Compass Peace Builders in Hartford. It's and ROCA Young Mothers Program. It's CTVIP in New Haven, and Domus in Stanford, and of course us. And we have a range of services to work, and we collaborate constantly. We talk about best practices. Recently, a lot of our conversation is trying not to compete with. So if we can establish programmings, we do this well, you do this well, let's bring you into Bridgeport and you can do it instead of us because you have the expertise, we'll do this part. And so I think when I think about the systems that are talked about in some of these bills, we as a group have an informal system and can help create statewide systems that are efficient, effective, and most importantly, for the investment that we give, will give the most return based on young people we're serving.
I appreciate hearing that, and especially the collaboration across organizations. I'd love to follow up with you more about what that looks like and what the work you're doing.
Be happy
So thank you so
Thank
much
you.
for that.
Thank you, Senator. Representative Howard.
Thank you. Good morning, sir. So Representative Fishbein covered some significant crimes, and I'm in agreement with him that I think there's certain C felonies, not all C felonies, but certain C felonies that would seem to be appropriate. And I think you made the representation that those are very rare. But what about things that aren't rare? Like assault third or breach of peace for schoolyard fights. Those aren't rare with kids under 14, right?
I would say they're relatively frequent.
Right. So under this language, if you have a 12-year-old kid who beats up another kid, you know, typical bully scenario, maybe he's a big 12-year-old kid, and he beats up a kid on the schoolyard, or let's take it out of school, and it's just a playground, local playground, or a park where they live or something. And he beats the kid up, and he goes to JRB. And he successfully completes JRB. You know, which by the way, correct me if I'm wrong, but doesn't JRB somewhat require participation by the parent or guardian and the child?
I mean, the language of the current status
Right.
is that the parent always has the full right. So if they decline participation in JRB as it currently stands, the probation officer typically refers it back to the court.
Okay.
So
we'll
they take their chances in court.
All right. So in order to successfully complete JRB, you need parental or guardian consent and cooperation. Fair?
Correct.
Okay. So that kid does that, and the parent cooperates, and he finishes his community service, restorative justice with that particular kid he beat up, whatever. And 3 weeks later, he beats up another kid. And he comes back to JRB, and we do it again. And then 3 weeks later, we do it again, and we do it again. How many kids need to get beat up before that kid gets arrested? Your opinion?
Yeah, so I think that's a great question. We continue to talk about JRB as the only solution. And that group that I just talked about, Senator Gadkar-Wilcox, we have a range of solutions. And when it comes, again, I just refer to from, again, practitioner as all behavior has meaning, right? And as we dig into a young person that's continually engaging in this behavior, we have to figure out why. And I think, you know, if that's continually happening, I would say the JRB is not the place for them. What I would say is the next one is our Street Safe Bridgeport program, which has the credible messengers. And again, we're analyzing, this is what we do as an organization. We analyze each step, because each step that happens, I consider an organizational failure, right? 81% is not 100% of our JRB. So there's 19% of the kids that we're not doing. That's where I want to concentrate on tightening up those things. So I think, you know, Representative Howard, if this bill were to pass, the way I would like to look at it is let's start looking at those cases that are happening and drill down more and provide the programming that supports these young people, which could include credible messengers. It can include mediation. It could be multifamily therapy, things like that.
Okay. So what I think I'm hearing is that before we arrest a kid under 14, take AB and some C felonies off the table for say breach of peace and assault. Before we arrest that kid, we should exhaust all opportunities to diversion.
That's the route I would take.
Okay. And I don't disagree with you.
Mhm.
Like I'm in agreement about that. But when those routes are exhausted, we've given that kid every opportunity, and he still continues to beat up other kids on the playground. Now what?
I think from a practitioner's perspective, we're still dealing in hypotheticals. I have to, as somebody with my own experience, I would have to dig in to see what is happening with this young person, right? And hold me accountable for it. It sounds like, in my experience, this has been, 25 years, very tough kids, never had SROs in my schools, alternative gang members. You know, in one of the biggest gang areas in the Bronx, Hunts Point, I had members of every gang on the planet, right? We averaged one fight a year, right? So the conditions that we provide are what does it. And so this young person will say, a 13-year-old young man continually does it. Okay, what has been my assessment? Did I do a psychological assessment? Did I do a psychiatric assessment? Did I do a home assessment? What is the trauma history? How am I being trauma responsive? And there's always going to be that one or that two. And my response to that is, can we 96% success in my mediation program? I've got 4% that I'm studying to try and figure out how I can get it. My JRB is 81% successful. I got 19% that I'm studying to figure out how I can get that to 0. And for me, this bill helps us get closer to 100%.
Okay, well, that's where I'm struggling, right? Because I think
Understandable.
getting you closer to 100% would be providing additional resources to diversion, right? Whether it's money, whether it's different programs that are suited for that 19% kids that their JRB is failing. That to me is a solution. Telling kids under 14, if you like, let me ask you this.
Mm-hmm.
If the kid shows up first day at JRB and says, no, I'm not doing what you tell me. Now what?
So at Catalyst, what we're doing is we're following up with the parent and the young person. We're going to the school. We're doing home visits. Still not working. We offer our credible messengers. And our credible messengers, they have so many relationships in the neighborhood. They know histories. They know family histories. They know neighborhood rivalries. And we get to them that way. And that's how we have had some success.
So what happens if a kid says no to all that? What if he says, no, I'm not taking responsibility for my actions. That kid deserved to get beat up. I'm the king of the playground and I'll do what I want. What do you do? What do you do then?
We haven't faced that. And I think this is where I'm struggling with the what ifs and what ifs. And I understand from your perspective that there's always going to be one more. And for me, if we can use the data and accountability to determine how much progress we've made. And I think going back to Representative Fishbein's point, we lowered it, we raised it a couple of years ago, and we've made significant progress. We've increased investment in diversionary progress, and we're making progress. Will we get to 100? I don't know, but that's what I'm working to do.
But Jordy, would you agree with me that potentially the reason that you're having the high success rate at JRB now in the cooperation is because it's the alternative to arrest? Can't we make a good argument that, listen, if kids came in today and parents and said, hey, do JRB or you're going to get arrested and go to jail, they're much more incentivized to cooperate. No?
I would say they're buying our product because our product is good.
Okay. Well, I'm glad that you have that level of confidence. And I'm not doubting what you do in your work. I have look, I agree with you that arresting a kid under 14 for shoplifting, schoolyard fights, etc., without providing them a diversionary option is unreasonable. Okay. And frankly, I think that's what happens, and the data shows it in this state now. Those minor offenses are getting referred to JRBs or at best non-judicial in juvenile court in huge numbers, except for your multi-time offenders or those very few significant offenses, right? I'm all for that, because I've always said that the way we need to approach juvenile justice is a healthy balance of opportunity and accountability. And I'm happy to work towards that. But in my opinion, as drafted, this bill removes accountability. And when you can't put accountability on that kid, and you allow him to choose the opportunities that he wants to take advantage of, and not with no accountability or no backstop to multi-time offenders, I don't think you're doing him I think you're doing him an injustice, in my opinion. But more importantly, you're doing society an injustice. If you have a kid that shoplifts from the same shop every week, that shop owner is at a loss while we try to figure out what we're doing. If you have kids that are getting beat up every week on a playground, while we try to figure that out, we have to consider them too. So I'll give you an opportunity to respond to that.
Yeah, and that's what our mediation program does. And for me, that's when I hear accountability, I always wonder what folks' definition of accountability is. And I think a lot of time, and I'm certainly not saying about you because we've had, interactions, but, some people accountability equals arrest, right? For me, again, as somebody who's raising teenage boys, who was a teenage boy who had some issues, I steal from a vendor, right? A shop owner, a small business owner, and I have to sit across the table from them and hear the impact on them and the increased cost from the loss, from the security, but also the investment that they have. That hurts a lot more than a ticket or an arrest, because you're sitting across the table from somebody that you've caused harm to. And when you're repairing harm, when you're sitting across, that stings a little bit more as a human being. And you see the body language when kids are doing it, they cower a little bit. They're not peacocking. They're not, proud of it. You got parents sitting next to them, sitting across from that shopkeeper. This is powerful accountability. And again, when we have programs that work, I think that's the opportunity. We have this group of nonprofits working with these young people that would be happy is the wrong word because we still have young people making mistakes, to create programs for the most intense young people to prevent them from getting to the gun violence that is plaguing some of our cities.
Thank you. Thank you, Mr. Chairman.
Thank you. We're gonna go to Representative Roberts, followed by Senator Ciccarella. I'll just say this because this is a good time to just remind folks, this is not directly to the last exchange or any exchange before it, but if folks are here and they get asked a question that they don't know the answer, I've observed that folks will try to answer the question anyway. It is fully appropriate to suggest that you may not know the answer. Just want to make sure that we are all aware of that. Representative Roberts.
Thank you, Mr. Chair. Mark, thank you for being here today. I'm hearing a lot of hypotheticals today, and that's what really is getting to me. But to hear you say 81% success rate, I think that we need to understand, what that means as well. For me, I do just want to simply just ask the question, because it's a lot of hypotheticals. It's a lot of, you're going to shoplift again and again and again. How often does that come across your table? That's one. Another question to you is, when it does come across your table, I'm loving that you just dumbed it down for me, because you actually said that the shop owner may sit across from you and the parent. So I think we need to understand, can you dumb it down for me to understand and teach me what goes on in that room for a certain situation of mediation, whatever it is? Because I'm hearing a lot of JRB, I'm hearing a lot of, dumb it down for me today and tell me the process. And I'm not going to give you a hypothetical. I want you just to pick whatever it is that you want to pick, but tell me the process today, because I need to understand. I don't want to hear hypotheticals no more. We're giving hypotheticals of assault, but it's never happened across your eyes, correct? So I want to hear a serious matter for me, please, if you can.
So the process, especially with our mediation, is really important. So you heard me say about 96% success rate. That's based on those who choose to come to mediation. So especially, lawyers who worked in mediation know it can be challenging to get folks to the mediation table. 91% of the cases that are referred for mediation agree to mediation. Right. That's a phenomenal number. And I think too, when we talk about systems, we want to create systems like this across the state. And when we see the 91%, right, as a nonprofit who could get public money, like right now, my obligation is to my private funders. I have to say, this is 91%, and this is what I'm trying to do to get to the 9, right? We have an obligation for that. So literally, so they agree to it. It's sessions with just the parent and just the child to talk about mediation, talk about their role in it. And by the way, if they refuse to take, ownership of any of it, then we have to choose plan B, which might be JRB, it might be our street safe program, it might be, you know, an outside mentor. I know, and I'm not as familiar with their program, but Connecticut Renaissance has a link program that deals with car thefts. So we do a lot, and then we do a lot of work with the shopkeeper, right? Because the shopkeeper has been harmed and they may not want to sit at the table. So that might be where the work is. And again, 91% agree. So that shopkeeper's agreeing. Then you're literally sitting across the table and the shopkeeper has an opportunity to talk about the harm. When you steal from me, I have to raise my prices. I have to increase my security. That's increased costs. But you know how it really gets me, right? I'm here trying to make a living, right? And you come in and steal from me, right? And that's where the power is. And then that young person says, oh, I just wanted to steal Skittles. I wanted to steal. That's teenage appropriate behavior. I mean, young appropriate behavior. Is it right? No, but it's what we do as kids, stupid stuff. Sometimes we do stupid stuff over and over again, right? And that's where I think arrest is not the solution. So we're fortunate that we have a range of programs within Catalyst. And I think, again, just referring back to the group I responded to Senator Gadkar Wilcox with, right, they have services too. And if we can work together to plug all these gaps that we went back and forth with, we still might get those hypotheticals. And we've closed that gap. We've built that safety net more and more.
Thank you. So now I understand it. And it hits me to understand more. You said the services were 2,000 to 3,000, correct?
Correct.
So if we arrest a child, do you think that your program would be more cost effective than going to jail, court fees, the state of Connecticut more money? I just need a clarification on that.
Yeah, and so when I say 2,000 to 3,000, that's per case. So we're talking typically 2 to 3 young people, 1 to 2 victims. So if you break it out by individual incarceration, court processing, you know, and again, we're talking about just the case savings. Break that out into 3, incarceration. I can't remember what the numbers are. We used to look at them frequently. It's, you know, it's economically feasible, it's socially feasible, it's child development feasible.
Thank you so much, Mark. Thank you, Mr. Chair.
Thank you, Representative. Senator Ciccarello.
Thank you. Thank you for coming to testify today. I just have a couple of questions. You spoke of an 81% success rate when the mediation actually happens. Was that what I heard?
So 91% is getting people to the mediation table, right? So that's you agree. So the shopkeeper has to agree and the child and the parent have to agree, right? If they don't, then we refer them to one of our other, because we have a lot of in-house programs. And then once we get them to the table, 96% of those hold 4 to 6 months after. So when we talk about like the incident recidivism, not necessarily incarceration, 4 to 6 months, it hasn't happened again. And typically that happens a lot when it comes to youth fights, the playground fights, stuff like that. The 81% is in regards to our JRB program.
Thank you. So 91% of the individuals that are victimized are participating in the mediation process then with the child and the
correct.
And is that true across the state? Because I know you're primarily working in New Haven.
Well, no, for the mediation program is Bridgeport, Norwalk, Torrington, and Stamford.
And is that every crime that's happening in the areas that you're covering? Is that every time a child commits a crime, stealing something, child, school fight?
It's based on capacity because that program's privately funded. So we don't have a ton of capacity. I've got 1.5 workers that are privately funded. So we generally do, we would love to provide the services for many more crimes issues. I think, when we talk about the narrative around car thefts is massive. And we would love to, again, love's the wrong word, but we would like the opportunity to work with a victim of a car theft and the young person who did it. Because I guarantee you that would greatly reduce the recidivism of that. Because they're sitting across, you stole the car. right? I couldn't get to work. Now I'm distrustful, right? You have violated me as a human being. That hurts, right? And a young person, that's more meaningful, and especially in the developmental frame, they're much less likely to do that.
Sure. And I could see how that would work. I was just trying to determine if all of the crimes that we were seeing committed, whether it's the fight, the theft, the stolen vehicle, is getting that process to see the real data, to have those great numbers, which is successful. It's amazing. And that's a consequence to me, right? If I stole a candy bar or if I got in trouble at school, I was going to have a consequence. I got my consequence at home and I didn't steal a candy bar again, or I didn't, get a call home, and I made sure of that. And that is a consequence. When you talk about what is a consequence, that is one. But when somebody doesn't respond to that, or individuals aren't participating in that, or they're not referred to your program, maybe they're referred to a JRB or something else, the statistics kind of might not be taking a picture of everything that's going on with all of the different crimes with the juveniles here in Connecticut. And Representative Howard mentioned, we also have to keep in mind that there are victims of these crimes. We talked a lot about hypotheticals, and it's hard to work on that scenario, but we'll talk about certain facts. Are you familiar with the risk screener when a juvenile gets arrested for certain crimes?
So I'm familiar with it. Have I seen it? No, because it's proprietary and I'm not a government agency.
Understood. So speaking to not only officers, juvenile probation officers, but some of the kids that are committing these crimes, it's my understanding that 2 additional crimes, we passed a juvenile justice bill, and it would say after a certain amount of car thefts, a child would go in front of a juvenile court or an adult court, and maybe the consequences that they were getting with the programs, diversionary programs, weren't working, and then there would be an opportunity for that child to get some type of a corrective measure, not always jail, but some type of a corrective measure. And one of the crimes that were added to qualify for a risk screener is the car thefts. And we're seeing children stealing cars 6, 7 times, getting caught and having no consequences, none. There's all of those victims, right? But what are we doing for that child that stole the car 6 times, which is extremely dangerous? Extremely dangerous. What are we doing for that child when they're just not listening?
Yeah, so out of respect for Senator Winfield's comment, I can't speak as much to the car theft because that's not one of our program. The car theft, from my understanding, gets referred to the LINK program. So, if I were in your shoes or if that were happening under me, I would be looking at each case to determine why. And I know that those young people, they steal a car, right? They might go to the LINK program, they steal a car again. I know those kids are not coming to me. 1, because I don't have capacity, and 2, maybe the provisions aren't in place. And then I think I would hazard to say that, somebody who steals a car once goes to the LINK program, somebody who steals a car twice that goes to our mediation program and sits across the table, then I think we're talking about making that number get lower and lower each time.
And I do appreciate the work you do, and, making sure these kids have mentors, credible messenger, great program, is so important, right? We have to make sure these kids are going to see another way, right? Because continuously committing crimes with no consequences, you turn 18, you commit a crime, you have a consequence. I just don't see how we help those kids. And the programs like you're doing with those numbers, that's great work. And these kids hopefully won't commit these crimes again. But we have to pay attention to the reality that certain kids are not going to be affected by these type of consequences. And what are we doing for them? And then the victims that are getting victimized over and over again, and all of those consequences that affect everyone. Our insurance rates go up. The convenience store raises its prices. At what point do we have to start finding a middle ground? I am totally open and willing, and I had conversations about this piece of legislation, completely listening and willing to find some solutions, but we need to figure out what those non-judicial corrective measures are. My cousin Dylan wasn't really doing the right thing. He went to Job Corps. It worked out for him. He got out of the element, got away from the distractions, and that worked, right? But my question, when I spoke to individuals before this came before our committee for a public hearing, we don't have those right now in a way that will completely affect the concerns of the constituents that are victimized over and over again, especially with the car theft. So I appreciate you coming up. I appreciate the work that you do. I'd look forward to talking to you more about your success and what's working and see where we could expand on that. But I just think that we have to be mindful that we have to take the general public's consideration in mind when we're voting on this. Thank you very much.
Thank you.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you very much for joining us this morning. Melissa Gomen.
Hi, thank you for the opportunity to testify today. I'm here on behalf of the National Youth Justice Network. I'm the Senior Policy Counsel there, and we're here in support of SB 1542. We are a membership organization comprised of 73 state-based organizational members across the country, including in Connecticut. As you know, this bill would raise the age.
One second. Pause.
Yes.
1 second. It's difficult to hear you, so if you can get a little closer to your microphone, that would be helpful.
Is this better?
Slightly.
Okay. I'm sorry. My laptop does not have a very good microphone, so I'll try to speak up a little more. Let me see if I have it on the highest volume. Okay. So as you know, this bill would raise the minimum age for arrest and prosecution, and this is in line with best practices and international standards. This is because young children simply lack the developmental maturity to be held criminally responsible. They have less impulse control, are more susceptible to external pressures, and importantly, they do not fully understand the consequences of their actions. Additionally, there are serious concerns about the competency of young children to stand trial. So if you look at a study that they did in 2003, looking at the competence of younger children, they found that about 1/3 of 11 to 13-year-olds and 1/5 of 14 to 15-year-olds were as impaired as seriously mentally ill adults who would likely not be found competent to stand trial. So I think we have a due process issue when we're talking about prosecuting younger children. Additionally, research shows that early involvement in the justice system actually compromises our public safety. So early legal system contact increases the likelihood of future justice system involvement. So it's basically creating a pipeline that perpetuates rather than prevents delinquency. This bill, as you've heard, would establish alternatives to prosecution of young children by creating pathways to the youth and family-centered interventions that you have here in Connecticut. I think the benefit of these interventions are that they get to the root cause of the child's problem and support the child and family's well-being in a way that the delinquency system is just not designed or equipped to do. So I will add that momentum has been growing across the country to establish and raise the age of juvenile court jurisdiction. If you look in the past few years, California, Delaware, Massachusetts, New York, and Utah have all raised their minimum age for prosecuting children to 12 years old. Maryland, Minnesota, and New Hampshire have raised their minimum ages to 13 years old, and New Jersey has recently introduced a bill to raise the age to 14 years old. In sum, we would urge Connecticut to pass this bill and establish a humane and a rational minimum age for prosecuting children. Thank you.
Thank you. Comment, question from members of the committee? Comment or question from members of the committee? If there are none, I want to thank you very much for joining us this morning.
Thank you.
Ramon Garcia.
Good morning. Could you hear me?
Yes, we can hear you.
Yeah, so I know from experience that, that locking kids up, it doesn't make it any better, and it only exacerbates the problem. And I say that, from experience. Now, as an adult, I can't believe, that I did, most of the things that I did when I was young. I went to the juvenile detention center at 13 and pretty much spent my whole youth, locked up, from a range of crimes from, selling drugs, stealing cars, robbing people and the more that they locked me up and beat me, the worse, it made me. And I would ask myself, like, why? Like I didn't want to feel, how I was feeling. I didn't want to go through what I was going through. But, at that age, it was hard to understand, why. And as I was housed with probably hundreds, of other youth, I would hear, a lot of the same similarities in their lives and what they were going through, aside, next to mine. And had, I had more resources, or my family, they say a recipe for disaster is pain and poverty. And, if communities, such as mine growing up, had more investment, then, it could have prevented, the course that my life took at an early age. And I had the pleasure of working a couple of years ago with a lot of middle school youth that were considered and deemed, at risk. And it was sad to hear, again, a lot of the same similarities and issues that I was going through at that age, that, currently that they're going through. So, the real, they spend a lot of time at school, but we don't know what happens at home. And so we have to work with the families, we have to work with the youth, invest in all of these things to eliminate these root causes, instead of investing and just being more aggressive and forceful to the youth, which is not going to help them, and it's only going to have adverse effects. So thank you for your time, and hope you guys do the right thing.
Thank you. Comment or question from members of the committee? Comment or question? There are none, and thank you for joining us again, and thank you for your continued work. Kemnisha Boyd. Kemnisha Boyd. Okay. Denise Paley.
Hi, Senator Winfield. Hello, Representative Staffstrom and members of the Judiciary Committee. My name is Denise Paley, and I'm here in support of SB 1543 because the requirement that persons who are incarcerated be immediately provided evidence-based mental health interventions upon initial assessment and intake is long overdue in the DOC. If the law was in effect when my child Ellis was arrested in 2020, it would have spared him 3.5 years of psychological torture. Our legal system left my son to languish, teetering between reality and his innermost fears. This is what Ellis was left to face. He had haunting hallucinations and delusions that terrorized him. He had believed in a metaphysical being that stalked and controlled him as well as others. And at times, he was convinced it disfigured him. Sometimes he was commanded to sit in distorted positions, and he would stay like that overnight. He wouldn't even be able to move the next day. The being showed its power by causing the walls in Ellis's cells to bleed on occasion. It controlled and it possessed others. It commanded what he could or he couldn't do. My son spent 3.5 years like this in prison. And I know my son isn't the only person to be arrested in the throes of a psychotic break. So currently, our system is just simply not resourced to assess and to treat someone with a new onset of psychosis. We should employ mental health providers with the ability and the time to assess if someone's in the prodromal state of psychosis and know how to take appropriate action to address it. The majority of people with psychosis will have something called anosognosia, or lack of insight. This is a biological condition, and it prevents people with a severe mental illness from knowing that they are experiencing symptoms of a brain disorder. Ellis's mental health counselor never heard of anosognosia, and as well-meaning as he was, he just didn't have the qualifications to treat it. So imagine how much more medication adherence would improve if all mental health providers were capable of convincing people with psychosis in our prison system that they were sick. How much could this reduce the torment that people with serious brain illnesses live with? How much would it reduce how often medication refusal escalates into violence in the DOC, or chemical sprays, sometimes death? So Ellis did finally receive effective medication treatment, and it took only a few weeks before his mind was completely clear. So it's been 1.5 years. He hasn't had one hallucination or delusion since he had access to effective treatment. Ellis was tortured for 3.5 years. Then effective treatment cured him in weeks. This is a failure by our state. It's tragedy. So please pass the bill so we can do better.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, I want to thank you for joining us this morning and sharing your story. Edgardo, Patron.
Thank you to the committee for having me here today. I'll be able to speak on behalf of my community. My name is Edgardo Patron. I am from Hamden, Connecticut. And I'm in favor for increasing the age of arrest in Connecticut and the use of handcuffs on minors. Coming from a standpoint of experiential, I like to just start off with, imagine a day the unthinkable happens to your 10-year-old family member. An untrained police officer in child services has the authority to decide whether your child should be handcuffed and taken to jail or not. I am living proof that placing cuffs on a young person may may have detrimental effects to their life. Let me explain. At 5 years old, I was expelled from kindergarten due to being unmanageable and as a result of child abuse. At 12 years old, I was placed in handcuffs for the first time. At 13, I fathered a child and was arrested again. At 14, my son was born and I was arrested one more time. At 15, I was legally married. On my third child, arrested again. I was on the run at that time, and I was placed in solitary confinement multiple times, ultimately committed to Long Lane in Middletown, Connecticut. At 16, I was also arrested again. At 18, I was sentenced to adult prison for 4 years, leading to being labeled a career criminal after a few more long-term sentences. The trauma of those cuffs on my wrist had caused me to be desensitized to arrest. They hurt my little wrist. I was 110 pounds when I was placed into cuffs and forced into taking a 2-minute shower. I was ultimately placed in a single cell. To cope with that situation, I went crazy, counting the cinder blocks over and over again to pass the boredom. And just for the record, I wasn't a violent child. It wasn't so bad the second time, and even less the next few times. I was indoctrinated into a system from an early age, and it all started with the cold steel of those cuffs on my young wrists. A diversionary program would have saved the state of Connecticut millions and millions of taxpayer dollars had they given me help like a jail diversion versus cuffs. After 30 years of everything from child abuse, child imprisonment, IV drug use, alcohol use, smoking a pack of cigarettes a day, and practicing destructive behaviors, I stand before you today in complete abstinence of everything that could harm me, my family, or my community for over the past 6 years. I'm a changed man who shows his remorse by coaching other people to get better who had similar experiences to mine. At 47 years old, I still reflect on the harm those handcuffs had on the young me and many more like me. I am in favor of increasing the age limit on the arrest of a young person so a guy like myself can never be created again. Please help us.
Thank
And
you.
unfortunately, it seems to me that it would be an easier conversation to get Sammy the Bill or Tekashi 6ix9ine off of all those felony murder charges than it is to help a
Edgardo.
young adult. Thank you
Appreciate
so much
that.
for having me.
Yep. Comment, question from members of the committee? Comment or question? I know it's not easy to come here and tell your story and talk about all the things that happened. So I just want to say that deeply appreciated.
Thank you so much.
Thank you. Barbara Fair.
This is the guy that needed the help too. Right here,
Thank you, Edgardo.
2017.
Welcome back.
Good morning. Good morning, members of the Judiciary Committee. My name is Barbara Fair. I'm a director of Stop Solitary CT. And I'm submitting testimony on several bills, SB 1309, 1541, 1542, 1543, and HB 7133. I submitted written testimony, so I'm going to try to do the best that I can in 3 minutes. SB 1309, I totally oppose. I see this as more robbery for people, families of incarcerated people, because people are already in prison. They have all kind of disciplinary things to do for people. So why do we now seek money, which is going to come from families who are already struggling? So I'm totally opposed to that. And I hope it don't get written into another bill. In support of 1541, strongly support 1542. The reality is if we can't find a way to support our children and utilize restorative justice as a policy on the front end, we will pay the price of neglecting them on the back end. By the time many children have stolen a car or picked up a gun, they have been failed by so many systems in their lives, be it their family, undiagnosed, untreated trauma, schools that fail to educate while placing police in their schools who criminalize the behavior, to youth recreational programs and job opportunities, beginning with summer jobs that no longer exist for them. I'd like to see the age raised to 14. I wish we could have done it 4 years ago, but here we are again trying to do what could have been done 4 years ago. But I notice we do baby steps to justice in this place. And then talking about diversionary programs, I think the children most likely that won't get the diversionary programs would be children who live in New Haven, Bridgeport, Hartford, and Waterbury, where resources are scarce and poverty is high. 1543, although I strongly support this attempt at transforming DOC, I'm not optimistic that even if the law is passed, there will be compliance. There's been too much history of passing legislation and the law is violated with impunity and no one holds the administration accountable. DOC scandals, scandalous audits, and scandalous overtime leaves me questioning why they're able to violate the law with impunity. How things like pay to stay and continuous lockdowns continued even though Protect Act was passed in 2022. I look at the strip search policy that could be changing now. We've had many conversations about body scanners, and I totally for the body scanners, but I think we need to take seriously what we need to be doing right now. And right now, we could be looking at strip policy that shows that almost every place a person goes inside of the prisons, they're being stripped. Over 350,000 of those. This is something we can work on now.
Barbara, hold on a second, because we'll get to that. Comment or question from members of the committee. Senator Kissel.
Thank you very much, Chairman Winfield. Apologize. Barbara, I just think it's great that you came and testified, and I definitely took to heart what you and your brother Tim talked to me about, especially about the first bill, 1309. And I hear you loud and clear. And I'd like to see that we can do something with the body scanner issue and the strip searches too, but we'll see what we can do. But thank you for coming to testify.
Thank you, Senator Kissel, for taking the time to sit with us. I really feel that we were heard.
I want you to talk about the strip search portion of what you were going to talk about, and the number of strip searches in a single year that you've been made aware of.
Well, the report that we got from DOC for 2024, in that 1 year, there was over 350,000 documented strip searches. And speaking to people who have been on the inside, and hopefully some of them will be here today, if they can describe how different the strip search is depending on what prison you're in. Take, for instance, the case of J. Allen Jones, and I hope everyone will acquaint yourself with that case. This is something that happened 7 years ago. Allegedly, he was beaten to death by correctional officers. And in your report, you will see, because they harp on the schizophrenic and having a break, but the reality is the clinician said that she ordered him to go for monitoring. He agreed to it. He was calm. This is all in the investigative report. He was calm until he got it, and they shackled him and all that stuff that they normally do. And it was when they said, get on your knees, he said, I can't do it. And they told him, do it or we're going to force you. And he said, I can't do it. And then he left out of that room in a wheelchair, slumped to the side with a bag on his head, and later pronounced dead at Danbury Hospital. And it was all the result of the demeaning strip search that he just could not find himself doing. If you look in the report, and I suggest that you look in it, and it states right in there that Garner is just one of those places, which is the medical facility, where people have to get on their knees for these strip searches. They're disgusting. They're sadistic. I don't know how we ever got away from just squatting and cough, but that's where we are now. And I wonder how much of this actually affected the people who work there, because we've had a correctional officer arrested for voyeurism, going inside a women's dress room and filming women getting undressed.
Okay.
We also had, I just want to say this one more, it's very important because this is about kids. We also had one who was arrested, and he worked with our kids in NYI, and he was actually talking online to a young girl about having sex, what he wanted to do to her and all that stuff. So I think we need to really pay attention to this sadistic policy that we have, and we need to look at that now, not next week.
Thank you. The number alone is just shocking, given the number of folks we have in the system over the course of a year, right? And so it seems to me that I'm sure I could basically tell you what the department would say about the need for strip searches, but it seems to me that there has to be a way in which that multiplier is not what it is, given the number of people in the system. So I don't think this is, maybe I'm wrong, somebody tell me, but I don't think this is a partisan issue when it comes to the number of folks we have versus the number of strip searches. I think that indicates there's an imperative to figure out a better way for both the people incarcerated and the people who are over them.
Mm-hmm.
Comment or question from members of the committee? Comment or question? Senator Gaggar Wilcox.
Thank you, Barbara, for being here and for all your work. I just wanted to follow up on what Senator Winfield just mentioned. We did have a day of testimony in government oversight on this very issue. And I think what's important to note is there's an alternative now that we're looking into, which just requires an investment in what a much more dignified process that gets to the same security end. And it was very hard to listen to all the testimony, and the process itself is just so undignified and it's humiliating. And we have an opportunity now to invest in body scanning machines that will provide again the same end but in a much more dignified and humane fashion. And so I look forward to that legislation going forward. And thank you for your support on all this work.
And I just wanted to add, as I did in that hearing, is that I don't want us to get lost on body scanners is the only answer, because we can look at the policies that they have now to strip you wherever you go. They actually added to the policy that people who are having video visits, they will now be strip searched as well. What is really behind that? So it seems to me it's not about safety and security, as they always say. It's more about power and control and degrading the very people that are vulnerable in their custody.
Thank you. Comment or question from members of the committee? Comment or question? If not, thank you very much for joining us again.
Thank you.
Josiah Schlee. Sorry, I didn't even notice that. Sarah Eagan.
Good morning to the committee. My name is Sarah Eagan, and I run the Center for Children's Advocacy, which is a nonprofit civil rights firm representing low-income children throughout the state of Connecticut. Here to testify on behalf of a few bills, including, excuse me, let me get my glasses, 1542, which would raise the age of arrest from 10 years old in the state of Connecticut. I have, in my time as a child advocate and continuing to be a child advocate, I have reviewed hundreds, if not more, arrest reports and police reports related to children 12 and under. I have helped conduct investigations where I read police reports that involve, even without an arrest, the handcuffing of a child as young as 8 years old by police because of their, quote, out of control behavior. So I think it's clear to me that we need different alternatives for our young people, and no child, much less an 8-year-old or a 9-year-old. It is important to know that children, even without being arrested by police are called to the school, for example. Children as young as 8 years old can and have been handcuffed in that encounter with police. That just can't happen, right? Sometimes then put on a stretcher and sent to a hospital. There are better ways to respond to the behavior of children. I also wanted to testify on the JJPOC bill as well, which is a number of important things, including ensuring participation of community stakeholders and young people in the process, increasing transparency and accountability, very important for efforts to address chronic absenteeism of students in school, strengthening reentry services, and ensuring accountability for children in DCF licensed youth shelters called Star Homes, which are also gateways and part of the revolving door of youth arrest and hospitalization. I do appreciate the discussions that have gone on about responding to the persistent maladaptive behavior of young people, which can be serious, and it can seriously affect them. It can seriously impact their community. As an advocate and as a lawyer, I always start with what is the end I'm trying to achieve and work backwards, right? What happens if we send these children into the prison system? I mean, the outcomes, they don't look great there either, right? The recidivism and rearrest rates for kids that touch the justice system are high. Even the boys at MYI who are there for the most serious transferable offenses, which would be exempt from a bill like this, right? Both because of their age and the nature of the offense. They're not there that long. They're there less than 36 months. They come out, are frequently rearrested. So incarceration is also not necessarily an effective response to the type of behaviors and concerns that we're talking about here today. I spent 2 years looking at every single arrest for children 12 and under in the state of Connecticut. Most of this is not what we're talking about, right? Most of this we're talking about the fights in the schoolyard, which get characterized as anything. We need to have a better response for these kids, and I think we can do it in the community. Thank you.
Thank you. Comment or question from members of the committee? Representative Fishbone.
Thank you, Mr. Chairman. Good morning, sir.
Good morning.
Are you aware of instances where adults utilize juveniles to commit crimes because of the penalties?
I'm sorry, because of
Are you aware of incidents where adults utilize children to perpetrate crimes because of the lesser penalty?
I'm aware of that allegation. I haven't reviewed any cases where that's been the case.
Okay. Have you looked for those cases?
Look at the cases that come across our desk over the years, but I'm aware that that's a concern that's been that's a concern of folks. Yes.
Okay, because I know it happens. Well, I'll leave that at that. The in 7250, I agree, and at a certain level, our educational system is is broken. But what is the intent if the Department of Education knows about kids not going to school?
Yeah.
What is the intent of, if they aren't doing something with it, what is the intent of getting it to JJPOC? And
Yeah.
that's the question.
Yeah, thank you. I think what we're trying to accomplish is more scrutiny on what are there's a lot of efforts that are mandated by law, right, at the local level and at the state level. We need to be able to dig in on a much more granular level on what is working and for which age groups and what is not working. So some of it is just transparency and accountability, right, for what are folks doing. And some of it is to be able to create a clearinghouse of strategies that are most effective at working with kids at different age ranges. That would certainly be the CCA, my organization, is a statutory member of the JJPOC and a participant in the education subgroup. And what we would be looking to do in part with that information is to be able to say, all right, how are we doing with our 10 to 12-year-olds, our middle schoolers? How are we doing with our early high schoolers? What are the interventions that are most effective? Are we doing the things that that's sort of mandated to do at the local level? Is the use of the data effective? And if not, why not?
So why isn't the Department of Education doing that?
I can't speak to all of the activities of the Department of Education relative to the chronic absenteeism data. I know they interact with that data, but I couldn't speak to the scope of all of their activities and the efficacy of those activities. But I do know, sir, that we clearly have work to do at the state and local level to improve our interaction with that information and our strategic response to that information.
No, I understand. It appears there's a disconnect. So there is a responsibility, Department of Education,
correct,
because of their title, their mission, all that stuff,
yeah,
to make sure that our kids that are constitutionally provided with a free public education, that is of some value. And if they were doing their job, this wouldn't be needed, I would think. Because I would think, kids not going to school is something that Department of Education, I would think, should be concerned with and should be looking into why that's happening. And then my concern from there is, so JJPOC makes some recommendations. What power does it have to implement those recommendations upon an entity that isn't getting the job done? So that's the disconnect that I'm recognizing.
Yes. So having spent 11 years as the state's child advocate, looking at where there's room for improvement along the lines of what you're talking about, an entity, state, local, may be mandated to do something, but there's room for improvement in how they're doing it. I do find that sort of intergovernmental multi-stakeholder bodies can be extremely helpful in bringing core issues and responsibilities of that state or local agency into starker relief for folks to work on cooperatively, collaboratively, voluntarily, but also to help inform additional recommendations that may come from that body to this body, let's say. So I think an entity like the JJPOC is positioned to both, through the process of meeting and focus, create greater accountability for those mandates, as you well phrased them, look at what can be improved in sort of in between legislative sessions through partnership and administrative advocacy and collaboration, and where there are gaps or more resources that may be needed to support some of the efforts that are more effective, bring those recommendations back to this body. So it allows a process for that offline 12-month of the year work to be done on a critical issue where we need to improve.
Well, thank you for that. Shifting to 1542, the raise the age situation. Am I to understand that you, as the child's advocate, that's your title, correct?
Well, now my title is, I'm the former state child advocate and the current executive director of the Center for Children's Advocacy.
Okay, so you've left the state role and now you're in the
private, not
private
role. Correct.
But so certainly within your private role, you don't have access to sealed court files.
Not unless they pertain to my client, no.
Yeah. But in your role as a state child advocate, because it'd be news to me, do you have access to all the juvenile court files as that advocate?
If sought, yes. The
Okay.
child advocate, Office of the Child Advocate, which I know I believe is also the interim child advocate is also testifying here today, I think, on the same range of bills. But by statute, the child advocate office has access to any record necessary to perform their statutory functions, notwithstanding other confidentiality provisions.
Okay, and I'm just trying to ask you, because you did talk about reviewing all of these records as the child advocate.
Correct.
Did you seek all of the files from juvenile court that?
So at times, we had done a couple of different projects there. One, we had looked at, in a particular Waterbury Public Schools, there's a public report, which is why I could speak to all of that information now, looking in depth at all arrests of children 12 and under, all calls to police for children 12 and under in a 6-month period by Waterbury Public Schools. In the process of doing that, we reviewed, and I personally reviewed, every police report, every 911 call, and reviewed all of those with the city and the police department. So, and then following that, we looked at the Office of the Child Advocate. I just don't want to create role confusion or speak out of turn. The Office of the Child Advocate, under my leadership, I just left last fall, continued to collect from Court Support Services Division reports, not the police reports, but information related to every arrest of a child 12 and under, where, what for, if disposition, race, ethnicity, grade, school, et cetera, for a process since the Waterbury report, so a process of several years.
And in your review of those records, how many of those children went to jail?
So the disposition wasn't always timely available. So I don't know that because I was getting the arrest information in real time or with a slight lag. Many were nollied or diverted or disposed of. But I couldn't speak off the top of my head to what percentage may have been detained. I don't have that.
Well, detention and incarceration, two different operative situations, but so then shifting to the 12 to 14-year-olds, which is the legislation that's before us, in your experience, how many 12 to 14-year-olds actually go to jail in this state?
That's a good question. I don't have that data at my fingertips. Certainly we do detain/incarcerate children under the age of 14. So I don't have the data in front of me right now to say how many 12 and 13-year-olds were detained last year. I mean, that's easily gettable data. I just don't have it with me.
Yeah, detention being, incident to an arrest, perhaps it's a domestic violence case, somebody gets stabbed in the home, you don't have a place to put the child, you're going to detain them and figure out what you're going to do. But I'm talking about children being sentenced at the end of the case to actual incarceration. I mean, do you have any data with regard to that?
So in our juvenile system, that would be how many kids wind up in the secure regions programs broken down by age. I don't have that with me today.
Okay. Well, thank you. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question, Representative DiCaprio.
Thank you, Mr. Chair, and thank you for your testimony, Sarah. I just had maybe a basic question about the handcuffing that you mentioned. Can you just talk about that a little bit? What you've seen and some of the concerns there. We had a gentleman earlier in the meeting here that testified just how that affected him in a negative way. So I just wanted to just get your perspective on that.
I can. Thank you, sir, for the question. As I was preparing for this testimony, I looked up some of the incident reports from the Office of the Child Advocate's report on Waterbury Public Schools. And some of those incidents, they typically were triggered by a behavioral health crisis the child was having. Child's out of control, hiding under the desk, scratching, really dysregulated behavior. But several of those incident reports included children being handcuffed by police when they responded, regardless of whether the child was ultimately arrested, though some of the children were arrested. So there were, just to give you one example, officer dispatched to school. This is from a police report. This isn't a public report. on a medical assist for out-of-control student. Upon arrival, I met school staff outside of the school on the side of the building. They were restraining a student, child, age 8. Child did not want to go back inside the school after recess. Child was trying to run away and had to be restrained. Child was aggressive and swinging his arms. I placed handcuffs on child and placed his arms in front of him to deter him from swinging at staff and myself. Eventually, an ambulance was called and he was brought to the hospital. So there were several incident reports that read similarly to that. And again, police they come with the tools that they have, right? So I understand that. And that's the tool that they had to respond to multiple 8-year-old children in distress. I think most people would agree that's not the optimal tool to interact with an 8-year-old. I'd also add that that type of intervention, a school relying on a 911 response and police to respond to that behavior and then handcuff the child with or without arrest, have them go to the emergency department, is also about a $3,000 intervention for probably trauma and a poor result. And for the same money, a community provider, some of which we'll hear for today, could probably work with that child and family for a year at that rate. So it's a gratuitous aside by me, but worth thinking about.
Thank you for that. Now, just, when you have someone that can't be restrained or someone that's in, that kind of situation, is there another way to handle that in your opinion?
Yes, thank you. And thank you for that question. Yes, 100%. I mean, there is so much research on how to prevent the use of restraint and seclusion with really vulnerable kids and adults, and how to do so in a way that's safe. In fact, study after study after study shows that institutions for children or adults that work with people who have complex needs, like some of these 8-year-olds, like some of the adults, but that program is in institutions that use restraint and seclusion or isolation have higher rates of injury, both to the patient, the client, the child, the adult, and to staff, worse outcomes and worse behaviors, because there are lots of evidence-based strategies to de-escalate children. In this OCA report, which again is a public report, none of the programs that schools that were calling police and asking for this response, none had a school social worker based in their schools, none. So I think there were a lot of better ways to handle that.
Thank you very much for
Thank
that.
you.
Thank you, Mr. Chair.
Thank you. Question or comment from members of the committee? Question or comment? If not, Sarah, thank you for joining us again. Thank you for your work. Christina, Coranta.
My name is Christina Coranta. I'm the Executive Director of the Connecticut Justice Alliance. We are a youth-adult partnership and a statewide advocacy and public policy organization that works to end the criminalization of youth. I'm here today in support of Senate Bill 1542, an act raising the age of arrest of a child and the use of handcuffs on young children. The testimony that I'm going to read before you today reflects what the Connecticut Justice Alliance has heard throughout the state of Connecticut in the past year or so concerning crime, young people, solutions, and safety. The Connecticut Justice Alliance fully supports this bill. However, there needs to be some changes to the language. There were some unintended consequences here. You'll hear later today from Attorney Renee Cimino, who has in her testimony what the suggested language changes should look like in terms of not allowing the arrest of under 10-year-olds, since that's what we changed the age to a few years ago. And there's a couple other pieces that need to be worked on that weren't clear when the bill was drafted. So we're willing to work with the committee chairs and others to make sure that all of that's ironed out. So when we look at the outcome data of children under 14 that go through the legal system here in Connecticut, we found that very few of them had an end result of a residential placement or community supervision. And so that just really begs the question of, why did these young people have to go through the legal system process to begin with when their needs could have been addressed pre-arrest? After all, if the purpose of an arrest is to improve community safety and teach children not to do wrong, we should probably be choosing the less traumatic and expensive way of doing that, and that's the diversionary programs. Now, there's a couple helpful stats listening to some questions that you all had. In 2024, the number of unique clients referred to court that were 10 years old, there were 22. 11 years old, there were 78. 12 years old, there were 192, and 13-year-old, 421. In terms of recidivism rates for kids that went through diversionary programs throughout Connecticut in 2023, only 20% of the young people that were diverted were rearrested. Young people that were referred to court in 2023, the rearrest rate is higher. So I have that broken down by age if people are curious about that, as well as we talked about cost. I heard questions in terms of how much do things cost. So last year we had some estimates coming out of folks about what it costs for an average stay inside of detention. Looking at an average stay of 18 days, that's $24,344.46. Average stay in regions or a youth prison is 207 days. That's $279,000, $961.29. So I also have the data before me of the regions and detentions admissions to talk about how many kids and for what, along with top misdemeanors and felonies. I think it's important to point out that in 2024, most of the young people referred to court were for misdemeanors. Thank you.
Thank you. Question, comment from members of the committee. Representative Quinn.
Thank you, Mr. Chair, and thank you for being here. So quickly doing the math in my head, it was roughly about 800 kids who would not be arrested now if the age 14 was in effect. The question I would have is, of the 800 that you cited in your stats, how many of them would have fallen into one of the exceptions and still gone to court?
Okay, and so in taking a lot of time breaking down the data on the fact sheet that I can hand you a copy of actually. So we figured out there'd be about 475 additional young people diverted if you raise the age today, or last year rather, 2024, to 14. And just to keep in mind that we'll start with 12 and then go to 14. Okay. So how many children you're asking would be arrested?
You'd have done something
not?
so severe that they'd fall into one of the exceptions. and
There are
still-
27.
Okay,
Yeah.
so about 27 out of 800.
Mm-hmm.
Okay. All right, thank you.
You're welcome.
Representative Roberts.
Thank you, Mr. Chair. Thank you, Christina, for being here. Quick question.
Thank you.
I think I asked it earlier. If you can, do you have the cost per child, per diversion cost for court and incarceration? Any chance?
Sure. Thank you, Representative Robert. So in terms of the numbers that I just spoke about within my testimony, we have a cost. Now, the cost needs to sort of be clarified and broken down because the cost per bed per day also includes clinical services, education, personnel. There's a lot that comes under that can be discussed and broken down. So it's not necessarily apples to apples, but I think it's fair to say that when you talk about how much money is spent on incarcerating a young person in a Regents program in Hartford or Hamden today, you have $1,352.47 per bed per day, average stay of 18 days. That runs you about $24,000 for that young person. And mind you, it's $19,000 a year to educate a kid here in Connecticut. And then for Regents, the average stay there is 207 days for a young person in 2024. So that takes you to about $280,000. Now the cost for diversion, the CEO of Catalyst was up here a little while ago talking about mediation program that they run there. And that looks like $2,000 to $3,000 per case. And he has the cost at $6,000 to $8,000 per case for the whole court process for that young person. So there's a $3,000 difference. And I think just to add to the cost question is, it's not only dollars, but sort of the human cost of trauma, the mental anguish, the parent cost, the family cost, what everybody else has to go through, and the ripple effect that arrest, handcuffing, incarceration, any of this has to do with a young person, how it affects all of us in this room. Thank you for your question.
Thank you so much. Thank you, Mr. Chair.
Comment or question, Representative Howard.
Hi, Christina.
Hi.
Good morning still.
Good morning.
So just a follow up to that, because this is starting to get conflated a little bit. Do you have the numbers of kids that are arrested that are actually incarcerated? What percentage of kids that are arrested that are juveniles actually make it to incarceration that are under 14?
Well,
If you know.
I do, well, I'll have to shuffle through here, but I'm going to say, which is under 20% that are actually, under 14 that are actually, so if we look at, hold on, I have it right here. So when a young person is referred to court, which we have a whole delinquency map of how it works, the process. There are 3 different sort of tracks that they can take. And
Right.
I'm looking at data of 10 to 13-year-olds, so they can go after their cases looked at through risk-based case handling, which not everyone qualifies for. So there's some nuances there which can be broken down. But 10-year-olds, it looks like here, kids who actually go the judicial route, so who are going in front of a judge for a plea hearing or taking the route being transferred to adult court, that is about, so 1 second. 10% of those young people. And then we've got kind of what the outcomes were. Like once they went on the judicial route, what happened to them? So you've got 10 to 11-year-olds handling decision, adjudicated, found guilty, 4. 10 to 11-year-olds who went through that process and went the non-judicial path on this map here, and they were found in need of a probation officer. There were 90 young people. And then 10 to 11-year-olds, there were 62 that were not accepted. So that means that they were diverted. For 12-year-olds, those that followed the judicial path and then were later spent some period of time in detainment is 23. And the non-judicial path for probation officers, 112. And then I have the numbers for the rest. And I think it probably would be important to have further conversations about after you follow a certain path in this map here of the legal system. If you're incarcerated, you get a probation officer, you get discharged. What happens to you then? What are the outcomes? Because we saw that children who come all the way down the map and are either transferred to adult court or go through a plea hearing, they have some period of detainment. At the end of the day, sometimes their case is nollied or disposed of. They're not. So we need to just look at that and say, what was the point in trauma and cost? Thank you.
So what I heard there was of all the kids that are arrested, right, that didn't go JRB, YSB, something like that, that got arrested, only 10% of them went judicial. And an even smaller amount that of the ones that went judicial actually got incarcerated.
Yep, it gets small. Yeah, it gets smaller and smaller as you go down the funnel.
Well, right, because there's a representation being made here that we're going to compare cost of diversion to cost of incarceration. But 90% but the bill doesn't talk about lowering the age of incarceration. It talks about lowering the age of arrest, right? So if only 10% of juveniles from 10 to 14 that are arrested are ended up in judicial and a much smaller amount goes into incarceration, how is comparing the cost of diversion to incarceration really a fair analogy in this context?
I think that it's fair because if you look at, and it's not even my opinion, if we look at kind of peer-reviewed research and the outcomes of kids in Connecticut, and that Sarah Eagan was just talking about, kids who are arrested, though there may be fewer of them, there's a lot more interaction with either the prison system, police, other child welfare system that costs money that could have been avoided by meeting the need, addressing the root cause with a diversionary program. And I think sometimes I've been before the committee talking about diversion, and I think it might get, it's not that it's confused, but it's not always actually explained in the way that might make the most sense. But there's a whole map that occurs when somebody is diverted to a coordinating hub or a youth service bureau and where they go. So whether they're going to mental health, substance use, behavioral health, all of that. And yes, all of that could be happening after an arrest, but all we're asking for is, can it just happen before? Because we also hear about the revolving door, right, of so-and-so is stealing a car, stealing candy bars, committing crimes, coming and going, right? We've even talked about that. So the issue is, hey, I want the door to close too, and so does the kid and their family. So let's get them the service faster instead of making them wait through that legal process of getting connected. Let's just do it now.
Right. And as you know, I'm in agreement with that, right?
Yeah.
I'm in agreement that diversion is the best way to do it. And if the state needs to make more investments into diversion, I'm all for that. 100%, because I think before we go arresting kids for these lower level offenses that are under 14, we should exhaust all opportunity, right? Conflicted with accountability, like I always say.
Yep.
I think as drafted, this bill falls short of that.
Yep.
And I think it needs work. Would you agree with me?
I agree with you. I think that you and I and others on this committee, public defender's office, chief state's attorney, some other police officers I've worked with, we can all sit together, and within the next week or so, there will be sort of a convening of folks that are going to look closely at what the diversion process will be in Connecticut, how it will change, so it's standardized in terms of funding, in terms of assessments, all of that. And the idea for the bill is that by 2026 for the age of 12 and 2028 for the age of 14, all of that's in place so that it all makes sense in terms of we can look at it on a whole sort of like perspective or menu, that there's not all of these little nuances. Everybody can have a good understanding of what success means, what carve-outs we have in terms of capital felonies, A, B, C, et cetera. We really wanted to get this bill before the committee to have the conversation about that this is necessary to do to avoid, further harm, but agreed on the work.
All right, and let me just, so my final question conceptually, are we in agreement then that we can't have an all-out ban on arrest of kids under 14, right? It would be as a last resort when all other diversionary programs and opportunities have been exhausted.
We are in agreement that this bill does not say an all-out ban on arrests. And I have been receiving questions saying, wait a minute, is this an all-out ban? What's going on? I said, no. We clearly state for capital offenses A and Bs, and like you and I have just said, we can talk about other offenses and what that looks like. Also, if on the third car theft, I heard someone ask a question about that or make a statement. Just based on statutes that are already in existence, on the third offense, that is a felony and that would be arrestable. So that's not like we'd be ticking up car thefts. That's not true.
Well, it would have to be an A or B felony, right?
It becomes a B felony on the third arrest.
Okay.
Yep. Automatically. And so that would be arrestable. And your point of, yes, we have to exhaust all diversionary options. And I know that I have had discussions with folks in what we will kind of standardize over the next 6 months to a year is, what does success look like? What interventions are the kids getting? How are we going to be sure that what they're getting is working? And how are we sure that just because someone had 2-3 chances at a program, it wasn't necessarily working? What does that mean? Do they need more? So just being a little bit more individual instead of cookie cutter and more flexible. And people hear flexible and get nervous, but it should be a comforting word of, we are going to figure out what you need so we don't have to see your face again in this instance.
So to that point, I agree with you. It's not an all-out ban on arrest for certain A, B, and open to discussion on some Cs. We've already vetted that out.
Yep.
But I would say to you that beginning of line 44 with section 2, there is an all-out ban on every other. So if you have 40 misdemeanors, right, it's an all-out ban on arrest as it's written. You would agree with me?
Yes, but we should also talk. Here, go ahead. Yes, do you have more?
Okay, and do you think that that's appropriate, or do you think that's part that needs work?
I think that we can talk about it. I do think that looking at the data that came out of the judicial branch that was presented in November to look at what are the top misdemeanor charges, how many are there, what's going on, would help, drive and inform that conversation with just the statement of, wait a minute, did you say 40? That leaves 40 out? 40 misdemeanors?
Yeah, I mean,
or whatever, roughly. Yeah. Instead of just saying that, I think it would be good to look at, wait a minute, how many are actually happening? And it's somewhere here. I'll find it while I'm talking. But we have that listed and we know. And so we know what the court has done because they can look at the records and see like what the interventions were, what the outcome was. Here we go. So we have and if anyone's interested, the top felony charges by age, the top 5, as well as the misdemeanors. So,
all right. So I guess what I'm just getting to is, I think we're in agreement conceptually.
We are.
And I just think the language needs a lot of work.
I think it does.
Okay. All right. Thank you. Thank you, Mr. Chair.
Thanks.
Good news for both of you. April 11th is coming, so you got some time. Senator Ciccarella?
Thank you.
You're welcome.
Thanking him, but thank you for coming as
Yes.
well. So you referenced about the motor vehicle thefts,
Mhm.
and you made a statement that that wasn't true. Can you touch on that for a second?
In terms of having a revolving door?
Yeah, for the motor vehicle thefts, you said that what I said was incorrect, and if somebody steals 3 cars, it's a felony.
Yes. I can pull up the.
No, you are correct.
Yes.
It is a law, but the problem is it's not being utilized because a stolen vehicle qualifies for a risk screener. So if they get the risk screener,
Mm-hmm.
they answer the questions correctly, and I've talked to these kids, they know how to answer the questions. And even
Okay.
if what they are saying may be incorrect,
Mhm.
there's an officer that experienced something, whether it's using drugs, whether it's hanging out with other individuals they shouldn't be. Even if they know that, it's strictly on the response of the child. So if an individual steals a car, answers the risk screener correctly, they're referred to a juvenile review board.
Mm-hmm.
They could continue to do that over and over and over again. And that law won't apply because they're not getting put in front of a judge to get the first one on the record, the second one on the record, and then be held accountable for the third one to be a felony. That's the problem.
Well, as we can talk about this more, but as I understand it, the third car theft that you or I commit, we are going to court. So if anything like that is happening, it shouldn't be happening.
So, okay, so we could work on that then because it is happening.
Okay, so yeah, we can.
Excellent.
We can do that.
Very
Be happy to do that.
Thank you so
And
much.
you're welcome.
Representative Fishback.
Thank you, Mr. Chairman. Want to stay focused on the motor vehicle theft. You know, in 2019, we created a diversionary program for juveniles that got caught stealing a car, which ended up with a dismissal. Since that time, the JRB situation has loosened this up. But the fact of the matter is, presently under our law, the first arrest, or there's an arrest, the first interaction with law enforcement when somebody who's 13 years old is believed to have stolen a motor vehicle and they don't go to the JRB, because the only other place could be juvenile court, although they're going to JRB. What happens to that case?
So are you talking about the suspended sentence motor vehicle theft program that kids go through, whether they're the driver or the passenger?
That can only be assigned by juvenile court. Yeah.
Right. And so what do you mean? What happens to it?
What happens to they successfully complete that?
Yes.
Yes. What happens to the case?
It's like it didn't happen.
That's right. It gets dismissed.
Yes.
So now the youngster, 13 years old,
Sure.
steals their second car. Obviously, the diversionary program was not successful. That becomes their first offense, and that's a Class E felony. So under this language, they would not be arrested for that second offense, right?
Yes.
You agree?
As it's written, yes.
Okay, well, that's all I'm dealing with. Somebody put the language in as written, yes. So now it's their second time they've stolen a car and they're still not going to court. They can't even be arrested. So now what happens to that case? There is no case, right? So the victim who their car was, lit on fire, left in the woods, something like that. Is there restitution through a JRB?
Yes.
Okay.
We have that.
And then what if the youngster doesn't, because 13-year-old has no way of making the money, right? It's going to come from the parents.
Yes.
So the parents don't pay it or they don't want to be cooperative. What's the process?
So the process, which if it's not clear in the bill, it should be in as it stands now. If a young person doesn't follow the agreement that's made at that juvenile review board with the panel of people, they are referred to court and they go through the process on that map there that I was holding up earlier, which they will go before a judge, and that is what happens to them.
And
yeah.
And then what happens to the case? They can't, how does it get to, if the law before us says they can't be arrested,
Okay.
they are then charged with larceny of a motor vehicle and it resides in juvenile court?
It will stay in juvenile court, but they are arrested because they did not follow their agreement.
Okay.
If someone is unsuccessful under the age of 12 or 14 and they don't follow the agreement, there's different definitions of unsuccessful. There's the possibility of a court referral. What happens is the person that is working at that youth service bureau or the juvenile review board that's under that refers it back to the police. And so they will look at that again and say, what's going on here? And then it's up to them to decide, are we going to kick it back to that JRB? Are we going to throw it to a different diversionary program that's under that youth service bureau that might be more effective? Are we going to send them to court? It's up to them. We haven't taken that part away.
Well, that part's not in this language, but on the next offense,
Mm-hmm.
what happens to that case?
And which, on the second one or the third one?
Essentially, it would be, yes, the second one.
Yes.
Which then, but there's no conviction, right?
No.
So,
Or adjudication. Mm-hmm.
so now the first stealing of a motor vehicle is disposed of as dismissed because they did the diversionary program.
Okay.
The second one, the JRB says do pay restitution, which has got to come from the parents, I guess.
Mm-hmm.
It doesn't happen.
Mm-hmm.
How does the juvenile court dispose of that case?
I think I'd have to look to see where that is in statute of what the next step is in the map. What happens if somebody can't pay for something? Are people's wages garnished? What goes on? Is there a different agreement that's made with the person who you harmed? I know that in the past, some people have come back to the table and said, we cannot pay for this. We recognize the harm and damage. We are sorry. What can we do to help you? Fill in the blank. And that's the point and the beauty and the restorative process of that panel and that circle that the young person works with.
Well, that's the frustrating part about it, because we don't have debtors' prisons in this, and I'm not advocating for that, right?
Yeah.
But if somebody says a 13-year-old owes a victim because the car is gone $15,000,
Mm-hmm.
and the family can't afford that
Yep.
for the bad act of the child,
Mm-hmm.
the system doesn't address that. So you can't convict the child then of larceny with a motor vehicle. You can't arrest him under this language. It doesn't even get to be a felony until it's actually the fourth offense, because the first one is a diversion, right? The second one is a low-level felony.
Mm-hmm.
The third one is a low-level felony.
Mm-hmm.
The fourth one becomes a felony that is a B.
Mm-hmm.
I got 4 cars.
Yeah, 4 cars. Mm-hmm.
4 cars
Mm-hmm.
that have been stolen before the system is able to engage. So, that's practically speaking what's before us, and I have a lot of difficulty getting there.
I think that if you're willing to sit down with me and others to talk about that, which it would be great if you would.
The conversation is very quick.
Okay, all right, hold on.
We could do that.
Hold on. Let's make sure we've got a clean transcript here. Let's do a question and then an answer to the question, and then we'll go from there.
Mm-hmm.
I think, Christina, you were trying to answer the question. Go ahead.
Oh, thank you. My answer to that question, Representative Fishbein, is those that I have drafted this bill with are in agreement that the bill needs work in terms of the language. And I have tried to meet with you in the past before this bill was drafted to talk about the family with service needs that you're interested in and how this could kind of meet you halfway, because I know you're interested in that in your personal work as an attorney. That's important to you. It's important to me as a person who has 2 kids and who's worked with kids in the past and recognizes that we're not doing anyone any favors, most importantly the child, if they are not learning a new skill and have some type of meaningful and lasting consequence on what happens, right? And they're able to repair. So I would like to talk with you about that so we can do that in terms of the language of the bill.
And in all candor, it's virtually impossible to have that conversation. And the reason is in 2018, I think it was 2018,
Mm-hmm.
the language that was before us was the bill.
Mm-hmm.
Very, very close to this. And I was assured that when we did the 12, that we wouldn't be right back here again. And in the wake of raising it from 10 to 12, your group advocated for getting rid of the Family with Service Needs program. So now how can I have a conversation about rolling that back when that's what I had to go with, and all we're dealing with here is incremental? Because even if this passed, I'm going to guarantee you within the next 5 years, somebody's going to be at that microphone saying, we should raise it up to 16. And that is way too far. And this is way too far. So,
I
thank you, Mr.
I don't know what well, if you would be willing to talk, it's not impossible for me to talk to you, so
All
we
right.
should do that.
All right, at this point, I'm going to step in on this. I think we've exhausted the line of questions. I believe the two of you probably should have a conversation in the hallway, and we're going to leave it at that.
Thank you.
Further questions on the bill for this witness? If not, thank you for being with us.
Thank you, Representative Safstrom.
All right, next up will be Kelly Heilman.
Hi, yes, good afternoon. Co-chair is Senator Winfield, Representative Staffstrom, ranking member Senator Kissel, Representative Fishbein, and all the members of the Judiciary Committee. My name is Callie Heilman, and I'm the co-director of Bridgeport Generation Now. I am also a Bridgeport Public School parent of 3 children. We are a grassroots member-based organization with over 300 members working to end corruption and racism and build the just, equitable, democratic, and livable city that we know is possible. I'm here today to testify in support of Section 8 of SB 1543, an act concerning the Department of Corrections, which directs the commissioner to study the relocation of the Bridgeport Correctional Center and propose alternative sites. Bridgeport has 2 correctional facilities, the Bridgeport Correctional Center, which sits in the middle of our city, and the Bridgeport Juvenile Correction Center, which is located on our city's waterfront. Neither of these locations are appropriate or in line with anyone's vision for their town or city. The Bridgeport Correctional Center is located in the heart of our city, just outside of our downtown and directly across the street from Central High School, where my son will attend next year. It's also across the street from our brand new Wakeman Boys and Girls Club and Southwest Community Health Center, and it's directly off 2 major commercial corridors of Madison Avenue and North Avenue. This location is inherently wrong. Our children should not have to go to school across the street from a prison. Our children should not have to attend after-school sports and enrichment programs across the street from a prison, and our families should not have to run their daily errands around a prison facility. We understand that relocating BCC won't be a process that will happen overnight, but we appreciate the legislature for raising this issue and for initiating this study. While we support this proposal, we have some suggestions to make the language stronger and more specific. One is that community engagement of the neighborhood, the school, and other community anchors that surround BCC should be a priority of this study, so the state has an understanding of the impacts, and it should be explicitly named in the bill. 2, our understanding is that in its current form, BCC holds hundreds of people in pretrial detention because they can't afford bail. Cash bail reform should be researched and recommended as part of the study so that the footprint and size of the facility can be drastically reduced when it is eventually relocated. And 3, relocating BCC provides the state with the opportunity to research global best practices into facilities that prioritize human rights, restorative justice, and rehabilitation. The study should include a new vision based on research for what a relocated facility could be. Thank you so much.
Thank you. Kelly, let me just ask real quick. So, I mean, just describe for folks a little bit sort of the setting, because I mean, we've spent a lot of time this morning sort of talking about youth and incarceration and, you know, when and if youth should be arrested, incarcerated, and the like. You know, I think it's important, and it strikes me as we're having that conversation this morning, that what you're referring to is a correctional facility that literally sits across the street from not just our city's largest high school, but frankly, a brand new Boys and Girls Club that serves, you know, kids down to preschool age. Juxtapose that with across the street, you have a dilapidated barbed wire wall. can you just maybe talk a little bit sort of about, from your experience and your interactions with folks in the community, sort of what that image is?
Sure. And my co-director, Jameem Davis, will be testifying a little later, and she is born and raised in Bridgeport. So I know she'll have an even more detailed picture for the committee. I am originally from Hartford, born and raised. And so when I moved to Bridgeport, I remember being shocked that there was a prison in the middle of the city. The high school is, like I said, directly across the street. And so if you live in the surrounding neighborhoods and you walk to school, children are walking, young people are walking along a chain link fence with barbed wire that has like green material along it so that you can't see through. You know, I think that there was a testimony given about like desensitizing, right? The nature of the culture of incarceration, desensitizing people to like how bad it is that a school would be across the street from a prison. You know, not having been raised in Bridgeport, I was not desensitized to it. So to me, it was shocking. Additionally, the juvenile detention center on our waterfront is shocking to me as well. So, you know, I think that when we talk about the school to prison pipeline, you know, it's a step-by-step process that is failing children, and having a prison right in the middle of the heart of a city is failing children and all of our families and the city of Bridgeport.
Yeah, so you mentioned Hartford, for example. I mean, Hartford, we know the correctional facility is not located in a residential neighborhood like it is in Bridgeport. It's located in a very industrial part of town, you know, set away from residential neighborhoods. You know, you know, in a lot of our correctional facilities, they're up in suburban areas and they're set back from the road, as opposed to this being literally right on the road. So appreciate you being here and referencing this. Representative Fishman.
Thank you, Callie, for coming here. It's an interesting issue. You know, I guess on the other hand, you know, we hear that a lot of people that are incarcerated do come from the cities. And I'm always concerned about family members being able to visit those that are incarcerated. And I haven't seen where this is. You know, I heard about a dilapidated wall. Do you concur that the wall is dilapidated?
Yes, yeah, the fencing that lines the prison is not kept up well. Yes.
Okay, and I guess that's a state situation. So I'm just trying to figure out, you know, if it was, let's say the wall was restored and it was painted bright colors, would that ameliorate the concern here? Or is it, you know, that people are pointing to it and saying, well, you know, you're in high school now, in another 5 years, you'll be across the street. I'm just trying to figure out, because, you know, a manufacturing facility could be there with the same dilapidated wall, barbed wire to, you know, to keep people from breaking in and stealing stuff. I'm just trying to get the perspective here.
Yeah, I think my perspective is a perspective that Bridgeport residents share. And I think it's a perspective that all of us share. I don't think any resident of Connecticut would want a prison facility across the street from their largest high school or their only high school in towns that only have one, right? I don't think that we see that as a vision for our communities and our children. And I think that we've learned a lot over the last decades around the issues of mass incarceration and criminal justice. And we've progressed. We've made so much progress in those areas, and we're safer now than we were before because of it. And so this is just another step in that forward momentum. I will say that I went to Hartford Public High School, and on my walk to high school, I actually used to cut through the Mark Twain House grounds, the Harriet Beecher Stowe Mark Twain House grounds. And what a lovely thing to do on your walk to school, walk through two of our world-renowned authors, their writers, their homes. And so that's like a way of juxtaposing, right? Kids notice their surroundings. Families and children are well aware.
Well, I appreciate that. And, you did mention that I think you mentioned that it's not a today sort of situation. It's a long-term planning thing. So, I would urge the powers that be to, make the area look a little bit nicer, and perhaps fix the dilapidated wall as a step forward. So thank you, Mr. Chairman.
Further questions or comments? If not, Callie, thanks for being with us. Next up would be Sher, Habibi. Sher Habibi with us?
Yes, there we go. Okay, well, thank you so much to the committee for allowing me to speak today. My name is Sher Habibi, and I'm the Research and Policy Director at In the Public Interest. In the Public Interest is a national nonprofit research and policy center that studies public goods and services. My organization testifies in support of Senate Bill 1328. While Connecticut does not currently rely on private prisons, this bill ensures that the state does not engage in future prison privatization. I want to share a bit of the research around private prisons, and I encourage you to take a look at my written testimony for additional details. First, private prisons do not necessarily save money. For example, cost comparison studies from the federal government, Arizona, and Mississippi found that private prisons did not produce cost savings. Second, understaffing is a common problem in private prisons. Private companies that are able to operate prisons at lower costs are often able to do so by reducing operational costs. This includes the hiring of fewer staff, lower compensation levels, and reduced staff training. High staffing turnover is a significant issue. So, for example, there is 2021 data from Colorado that shows that turnover rates at 2 private prisons in the state were 107% and 126%. The lack of a highly trained and dedicated workforce in private prisons often directly translates into less safe prison conditions, which can endanger both prisoners and staff working in the prisons. In 2016, a DOJ study found that private federal prisons had higher rates of assaults than public federal prisons. Additionally, the private prisons had more safety and security-related incidents per capita. Many horror stories have flowed out of private prisons in recent years. For example, the Department of Justice opened an investigation last year into the conditions at a Tennessee private prison, citing allegations of staffing shortages, high staff turnover rates, murder, and physical and sexual assault. In 2018, an audit of a private prison in Mississippi revealed that the facility was so understaffed that the warden relied on gang leaders to keep fellow prisoners under control. The facility experienced at least 4 gang-related homicides in a 2-year period. In response to these types of horrific conditions and outcomes, many states do not use private prisons. Between 2000 and 2016, 8 states, including Arkansas, Kentucky, Maine, Michigan, Nevada, North Dakota, Utah, and Wisconsin, eliminated their use of private prisons due to concerns about safety and cost cutting. Other states, such as California and Nevada, have joined the list in more recent years. So we really encourage the committee to support Senate Bill 1328 to protect the state against the negative impacts of private prisons. Thank you so much for your time and consideration.
Questions or comments from the committee? If not, thanks for being with us. All right, next up will be Jordan Wilson.
Good afternoon, Senator Winfield, Representative Stastrom, and members of this committee. My name is Jordan Wilson, and I am the Director of Community Engagement with the Connecticut Justice Alliance, a youth-adult partnership working to end the criminalization of youth. I'm here today to express my strong support for Senate Bill 1452. One of the many benefits I have in my role is speaking to currently incarcerated youth at Manson Youth Institution on a pretty consistent basis. Over the past few weeks, we've been reflecting on raising the minimum age of arrest and what addressing behaviors they've done at the age of 12 could have done for them now at 15, 16, and 17. Many of them support this bill, and testimony provided by them will be available in the coming weeks. I'd like to share with you one of the quotes from those sessions that we've had. When asked if they support raising the minimum age of arrest, one of the young men quoted, "If you're 12, you need help. My mindset at 12 isn't the same at 17. I wish I listened now." When asked, what would you have done differently, a young man stated, "I would stay in the house and play the game." I urge this committee to reflect on the experiences they've had at 12, and then at 14, and then now. We've all made mistakes we've often learned from as time moves forward. My ask to this committee is to better serve those mistakes with developmentally age-appropriate, community-based services that can get to the root of that mistake and ensure lessons are learned in an effective way. A way that minimizes the chance to reoffend, as we know the legal system and the legal process is timely and oftentimes ineffective at getting to what we really want: young people in their communities living successful and safe lives. I provided written testimony. My team and I are reachable for any questions, and most of them will be testifying today. Thank you.
Thank you. Questions or comments from the committee? If not, thanks for being with us. Devon Ward.
Representative Stastrom, ranking members, Senator Kissel and Representative Feshbein, distinguished members of the Judiciary Committee. I've submitted testimony in support of SB 1543, 1542, and 1435, and testimony in opposition to SB 1309. I'm going to spend my time discussing SB 1541. This legislation represents a significant and long overdue step towards enhancing transparency and accountability and fairness within the Connecticut correctional system. Each provision of this bill addresses longstanding concerns related to oversight, civil rights, and systematic reform. Section 1 extends the term of the correction ombudsman from 2 to 4 years, aligning it with the governor's term. This change promotes continuity, reduces short-term political shifts, and aligns with my counterparts around the country. For instance, New Jersey's ombudsman is appointed for a term of 5 years. Maryland's ombudsman is appointed for a term of 6 years. And here in Connecticut, the Office of Child Advocate already operates on a 4-year term. Section 2 of the bill, it codifies existing practices between the Office of the Ombudsman and DOC. Commissioner Kuros has been a cooperative and transparent partner, but future administrations may differ. So codifying these practices is essential to us preserving institutional integrity and public trust. Given the office's oversight of 13 facilities, more than 6,000 employees in DOC, this section also protects the office's independence by shielding it from budgets, from executive reductions in budgets. I do, in my testimony, note a suggested amendment just to align the confidentiality and sharing of records between myself and DOC. This provision mirrors the ability that the Office of Child Advocate currently has with the Department of Children and Families. Currently, my office has to obtain individual releases to access DOC records for each complaint. This causes a significant delay in terms of oversight, and it's inconsistent with some of my counterparts in other states that have access to custody files and case management systems, and in many cases, medical records as well. Section 3 really is a section designed to create parity between correctional officers and our police officers here in the state of Connecticut. It clarifies that collective bargaining agreements can't prevent public access to disciplinary records or investigations of misconduct. Section 4 talks about establishing some clear obligations for correctional officers to intervene and report excessive force or unlawful uses of force. Currently, the language is a bit ambiguous in that it requires a CO to report to a supervisor. At times, that could be a lieutenant, that could be a captain. This language would require that they submit directly to a warden. Just to summarize, you know, the bill is it's pretty sweeping, but I'm happy to take questions on it.
Sure. Yeah, no, I understand 3 minutes, particularly on a multi-section bill, but that's why we do allow written testimony, and
Sure.
I think we have it, and I'm sure there's some questions for you, Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon.
Good afternoon, Representative Fishbein.
Nice to see you again.
Likewise.
Yeah, there's a lot of problems in here.
Okay, let's talk
you
through
know,
'em.
so yeah, sure. So starting on page 1.
Okay.
Of 13. Why is it good public policy for the correction ombudsman to have a term of 4 years as opposed to the present statute that's 2?
Yeah, thank you for that question. As I mentioned in my written testimony, my counterparts in other states actually have longer terms. The Office of the Child Advocate, which is another oversight agency we have here in the state of Connecticut, is a 4-year term. With the 2-year term, it really does prevent some organizational challenges in that, by the time you're through your first year, you're essentially preparing for reappointment. And just noting how the process is played out recently, the governor wields significant power over that process, right? And that he selects from the Correction Advisory Committee's 3 candidates. And so I just think just to align with other state statutes and to allow the person who serves as the ombudsman to have a complete term to actually bring fruition their objectives, I think a 4-year term is appropriate.
So I appreciate the answer. I'm just trying to think, have you ever been appointed to something before that you had to be reappointed to?
No, sir.
Okay, so, I would think, first of all, we sit as 2-year terms, and about 4 months, 5 months before our next election, we are preparing for reappointment. Sort of, I would think that as an appointee doing this job, that you continue on doing your job. The governor's office finds out this thing's coming up for expiration, looks at what you did, calls you up and says, Attorney Ward, you're doing a good job. I'm going to reappoint you. What do you envision that you would have to do that would take you off that track? That it would be necessary for this 2-year thing? Because certainly running for office is a lot more, I think, a lot more work than looking for a reappointment.
Yeah. So, the governor obviously has been a collaborative partner in bringing about transparency. But if let's say we have a different, governor and the ombudsman comes out with a report that is not favorable to DOC, that person can be terminated, right, within a 2-year term. I think a 4-year term really does give someone the ability to, put forth their plan and execute the plan and then have the option to be reappointed. But I think a 2-year term is just such a short period and does yield the position to a considerable amount of political influence in an office that is supposed to be somewhat of an independent watchdog.
I guess it's a give and take because certainly those that are incarcerated as well as DOC may think you're doing a bad job too.
Right.
And, for a governor whose entire term is 4 years to not have that ability, because like firing someone of your position, it takes a lot of temerity to do that, whereas I think the flexibility of 2 years is more appropriate. Looking at and you have the language?
I do.
Looking at lines 24 through 26, it talks about communications. And it creates, in effect, a right. You- Says, one of your duties is to receive communications, including telephone calls, and electronic mail from persons who are incarcerated, who shall be permitted to make such telephone and electronic mail communications free of charge. Setting the cost aside, it appears that creates an unfettered right. Do you agree or disagree to be able to make that call whenever the individual deems it to be appropriate?
Yeah, and that's the intent. And this codification, it just codifies an existing agreement that I have with the office has rather, with the Department of Correction currently, and that folks who are incarcerated should be allowed to call the office from a secured line, from a prison phone at any time. And that is a communication method that I've worked out with the department, that the department feels comfortable with executing. And so I don't believe it'll create a unnecessary burden for the department. It actually, was a communication method recommended by the department. And so it would just codify that agreement and understanding that we already currently have.
Okay, when you say this is suggested by the department, I note that Commissioner Quiros is not on our list to testify.
Correct.
Are you saying that was asserted by his office or the union?
So when I assumed this position, one of the first things I did was meet with the DOC leadership and specifically discuss with them how were my office and folks who were incarcerated going to have a line of communication. And one of the things that specifically the security professionals and DOC developed was that folks would be able to call me from the there's blue phones affixed to each housing unit. They'd be able to have a secure line that only calls directly to my office. And so this provision would just codify that understanding that we've developed with the department.
Okay, so it's 3 o'clock in the morning,
Mhm.
and one who's incarcerated desires to exercise their right, as well as everyone else in that particular cell area,
Mhm.
as a way of protest.
Well, so those phones have to be turned on. So just so you know, they can't just pick up the phone
Okay.
and call. CO has to turn those phones on in a particular unit, and the individuals have to be out of their cells. If it's a dorm setting, the phones have to be turned on.
None of those criteria appear in this language, though. So as written, DOC staff would have to drop what they are doing and turn the phone on and facilitate the communication because we have created this unfettered right.
I would disagree with that.
Okay.
The language doesn't say it's unfettered. The language doesn't say at any time. It doesn't say whenever. It just says that receiving communications, including telephone calls and electronic mail from persons who are incarcerated, who shall be permitted to make such calls. It doesn't express that it's an unfettered right and that an individual is allowed to exercise that right at any time. However, certainly open to working with the committee to amend that language if they want to put in language that says it's subject to some type of administrative directives or rules within the department. I'm happy to do that. But the intent of that particular provision was really just to codify the ability for folks to be able to call and communicate confidentially with the office. But I would disagree with your interpretation that it confers some type of unfettered or or any type of right upon any individual to contact my office whenever they wish within a correctional facility.
Well, I believe it does create a right, and certainly an unfettered right, or a right without statutory limitation, that is given to one who is not as, we'll say, free as I am. I think we have to be careful there. And I'm in support. I mean, I'm in support of the communication, right?
I know you are.
But
Yeah.
it's the balance.
Sure.
It's certainly the balance. Looking at line 78 through
Sorry, 70.
78
Uh-huh.
through 85.
Uh-huh.
I've never seen anything like this, and it appears to be some sort of a constraint upon the budget process. If
Yeah,
you can explain to me, what is the intent of line 78 through 85?
Sure. So this language actually mirrors what we have for our state elections enforcement. And that's where the language is actually taken from. And that when they submit their budget to OPM, OPM does not reduce or modify that amount. That is the amount that is placed in the budget for the legislature's consideration. And so that was the intention behind that section. And that, this office is intended to be an independent oversight agency. And I think everybody's aware that those efforts can be stymied if the office isn't funded appropriately. And so the intent of this provision was to make the funding for the office independent and be the office allowed to set its budget and the legislature to consider that directly without any interference from OPM.
I understand the intent. I'm just having a problem with the separation of powers issue, right? Because ultimately, the governor signs the budget.
Sure.
So what this language basically says is no matter what, it can't be, because OPM is the governor essentially, that's the executive branch.
Correct.
So this legislation is saying to the executive branch, you can't touch this. Isn't there? You can't touch it. And I don't know. I don't know if there's an issue there. But I'm looking at the two together, and it says the first part has to do with OPM, and then it says, and recommended adjustments and revisions of any such estimates shall be recommended adjustments and revisions, if any, transmitted by the correction ombuds to OPM.
Correct.
So how does that work?
My belief is that this provision essentially says that whatever the budget that I recommend is the budget that OPM ultimately submits to the legislature for consideration. That it's not reduced, it's not adjusted, that the amount that I think is the appropriate amount for expenditures to operate my office is the amount that the legislature receives in the governor's budget proposal for their consideration.
Okay. In line 80, we're talking about estimates of expenditures.
Correct.
Right?
Correct.
And those are estimates made by you.
Correct.
Your office.
Yes.
In line 83, we're talking about adjustments and revisions.
If any, right, follows that provision.
Okay. So aren't they one and the same?
Well, no. So as you're aware through the budget process, if my office submits a budget of estimated expenditures and we submit that to OPM, there may have to be revisions and adjustments to those estimates based on a number of factors that could happen. And so that's why it says the recommended adjustments and revisions of such estimates shall be recommended adjustments, if any, transmitted by my office to OPM. This essentially takes the budget recommendations of my office and allows the legislature to consider them directly without interference from the executive branch.
Okay.
And the intent behind that is that this office is supposed to be an independent oversight agency. And inherent in that is that my boss is the same boss as the agency that I am overseeing. And so, Governor Lamont has been a gracious partner in this effort, but should we get another administration in the future who doesn't see the utility in the Office of the Correction Ombudsman, they could essentially flat fund my office or zero fund it, and that budget would never make it to legislative consideration. And so what this does is remove the executive branch from that and allows my office to directly submit its budget in the governor's budget proposal, exactly whatever the number that I believe or the future ombudsman believes is the necessary expenditures to operate the office for the legislature to consider.
Why is it, so, I mean, I guess it's a constitutional question, but should the judicial branch have the same language?
I know the state elections enforcement does. That's where this language is from.
But SEC is not the judicial branch, they're under the executive, but it would appear that the same rule of thought should come forward through for the judicial. You know, we hear that there's not enough marshals in the courts because they don't have funding.
Sure.
It's the same sort of situation. So it's an interesting question, whether or not.
I think it's an interesting question. Look, you know, my concern about this particular provision is that, you know, it gets this provision gets this bill referred to appropriations and it ties it up. And so, you know, it may be a longer conversation for another year or another time. But, you know, it's something that the independence of this office and the funding for this office is become an immediate challenge. And so that's the intention behind this provision, is that this office be allowed to submit its budget for the legislature's consideration without interference from the executive branch.
Understood. Looking at lines 89 and 90, you're given unfettered power to accept or reject a complaint. That's what those two lines talk about, right?
Well, it says the line says the ombudsman need not investigate a complaint if the ombudsman determines such an investigation is not warranted. And so, you know, my interpretation of that particular provision is sometimes there are complaints that come into the office that are not worthy of an investigation. For instance, someone may complain to the office that I have a loved one who'd like to get on my visitors list and is not able to get on my visitors list. Right? That doesn't require an investigation. That requires the office communicating with the Department of Correction and figuring out why that particular loved one is not allowed on that particular person's visitor list. You know, other instances come up where, you know, someone says, hey, I have a medical condition and I'd like a specialty mattress. That's an instance that doesn't necessarily require an investigation, right? And so the intent behind this particular provision is just to outline and express, make clear that there are some matters that are going to come to the attention of the ombudsman that are not going to require a full-blown investigation. And it is the ombudsman's judgment and discretion which complaints do require a full investigation. If the office was required to conduct an investigation for every single complaint it received, it would likely be impossible. Just in my short time in this role, the office has received hundreds of complaints, and not every one necessarily required a full-blown in-depth investigation.
Okay, so I've got an individual who's in a position that they can't be removed during the term that is empowered to reject complaints with no overview, right? You're the end. No court can step in and investigate and order you to investigate, right? That's also in this language.
You're referring specifically to lines 89 and 90?
No, I'm referring to further on. It's not an administrative appeal. There is no review from your determination. So would you be comfortable with a probable cause standard in there? Because I got to tell you, the specialty mattress situation that you brought up, that may be something that needs to be investigated, quite frankly. I mean, I'm not looking to micromanage, right? But you know, I would hope that complaints are made in a good faith basis. And we know that not all complaints are made, right? In a good faith basis. Some people are looking to get attention, some people are mental health issues.
Or some people are just looking to be heard, right? Some people
Yeah.
sometimes lodge complaints,
Amen.
not necessarily because they need a resolution, but just because they want somebody to know what's happening. So you know, that really was the intention behind that provision, is just really to articulate that every complaint that comes into the office is not going to be necessarily worthy of an investigation. And so it really is up to the ombudsman to determine that. You know, it's very similar to the discretion that you know, police officers have, right? Every call, it's not going to result in an arrest, right? Or even a prosecutor, right? Every referral doesn't necessarily result in a warrant. And so it's the discretion of the ombudsman whether or not something requires a full-blown investigation based on the nature of the complaint. And I believe the office should have that discretion.
But I can tell you with the issue of the police officer, I've been involved in, I personally was involved in a case that I thought the rank and file officer did a poor review, determined didn't need investigation, and I was able to go to the chief and get that case reassigned. No such process with this.
Well,
you are the only determiner as to whether or not something is going to be investigated.
Well, that's investigated, but you know, the individual would also have all their remedies available to them in the court of law. They'd be able to file a complaint. If it's something that's an assault, they'd be able to file a complaint with the state police. They'd be able to file a grievance within the correctional facility. So there are a number of different avenues for an individual's complaint related to whatever the nature of it is to be heard. The ombudsman is really one of many conflict resolution measures for individuals who are incarcerated, but it is not the only avenue. There are several other avenues that folks can pursue to have their complaints addressed.
Looking at lines 107 through 109, and this is new language, you're being empowered to make a finding with regard to DOC staff. Is that fair to say they did something bad?
Sure. It's language that says the office shall make a finding whether an administrative directive, state or constitutional right has been violated by the department or an employee of the department. Correct.
And what rights do the unionized individuals have to notice, perhaps for their union counsel to be involved in those proceedings? I don't see any language in here.
Sure. And that may be an oversight. You know, I certainly would welcome that. You know, I had a pretty brief conversation with representatives from the correction union. I would hope that we can amend this language to expressly state that their garrity rights will be preserved. They're allowed to bring a union representative should they be subpoenaed. They're allowed to have counsel should they be subpoenaed. And I've also extended that. If they choose to exercise their Fifth Amendment right, you know, during that hearing, they won't be held liable for non-compliance by the department. So, you know, look, this is in terms of, you know, subpoenaing somebody and having them sit for an investigative hearing. I do believe in due process. I do believe individuals should be afforded counsel and should have their union rights preserved. So happy to work with the committee to add that language in.
In line 147, it indicates that mail that you receive, and you're permitted to receive mail from anyone in a prison facility. Is that fair to say?
Correct.
That those are all privileged communications. Now, we have understanding of privilege as attorneys. But my concern there is that somebody makes a complaint about a corrections officer, and that investigation ends up in something going sideways. And the complaint was not based upon actual fact and knowledge, but trying to get somebody in trouble. Under this language, you can't disclose anything about that communication. Do you read that any differently?
No, I don't read that differently. The communication is privileged, and that it's protected. And I think to ensure that when folks are contacting the office and lodging complaints, that the confidentiality and that privilege should be preserved. And I strongly believe that, because, you know, the office, you know, largely does serve for individuals who are in correctional settings to, or, incarcerated individuals to make complaints. But, my office does also receive complaints from staff, right? And we wouldn't want whistleblowers to suffer any retaliation for lodging complaints against my office or in my office as well. And so, I strongly believe that the mail to my office should be privileged, specifically also because of the strong fear of retaliation for incarcerated individuals when they're reaching out and making these complaints. I'm sure you're aware that all of the mail that enters the correctional setting is read, unless it's noted as privileged or legal communication. And even in some of those instances, sometimes it's read. And so, the intent behind this provision was really to make sure that folks can contact the Office of the Ombudsman without fear of retaliation and with assurance of confidentiality.
Does the process require a complaint to be sworn to?
No, it does not.
Why not?
I guess I would ask, why do you believe it should?
Well, because these are serious cases for most of the complaints, I think, as not perceived, contemplated under this system would more than likely be from those that are incarcerated complaining about conditions or individuals negatively impacting them during their incarceration.
Correct.
And I mean, I take allegations of those instances very seriously.
Sure.
And if they are true, I would want some sort of something behind it. So, I think we've already recognized that some people just want to be heard. Not everything would necessarily be investigated. Some things there's an administrative process for.
Well, so the office really encourages individuals to exhaust the internal grievance and administrative process in the facility before they contact the Office of the Ombudsman. Again, the Office of the Ombudsman is really it's another conflict resolution tool, but it is not a workaround around the existing internal grievance process in our correctional facilities. And the office really does strongly encourage individuals to avail themselves of the process within the facility before they reach out to the Office of the Ombudsman.
I had two other areas. The line 303 has to do with formal statements regarding a use of force incident. Now, this is a formal statement that's outside of the context of the regular process. I'm trying to figure out, how would this get initiated? So have you had any of these situations?
No, and so I just want to be clear, this language is adopted verbatim from our police accountability bill that was passed in Connecticut in 2022. Or 2020, excuse me.
Yeah, so is this outside? I mean, I was part of those discussions. So is this bringing corrections officers in line with the requirements of a police officer, and it's not necessarily in the context of your work?
That would be my belief, is if an officer is giving a formal statement and is the subject of a disciplinary investigation. So, the way my understanding of this provision would be, similar to the police accountability bill in the context of a criminal investigation or a disciplinary investigation or security investigation within DOC.
So that this would not apply to any investigation that you are conducting. I couldn't tell from what I was looking at.
Right. No, I don't believe that was my intention.
Okay. And then in the very last paragraph, it says, and it starts line 355, in any claim involving a fatal injury, so somebody is dead, right, suffered by a person while incarcerated, or an injury that resulted in a person who is incarcerated suffering permanent disability, the attorney or pro se party So what pro se party, so I guess it would be maybe the executrix of the estate, administratrix of the estate would be attesting to the fact that there was a real case there?
So, no, a pro se party, so the section also talks about somebody who suffered a permanent disability. So let's say, you're someone in a correctional facility who suffered an Achilles tendon injury, and you didn't get proper medical treatment, and then you had to lose your leg as a result, right? And now you want to seek, you want to file a lawsuit against the state of Connecticut in Superior Court. You would file your claim with the claims commissioner, and you would obtain an affidavit from my office that says that you have a legitimate claim, and you would be allowed to proceed directly to Superior Court if you wish. You also could choose to continue in the claims commission process and seek to resolve your claim that way, but you also would have the ability to get an affidavit from my office that says, yes, this person does have a legitimate claim. I've looked at their medical record, and they have a legitimate claim, and they should be allowed to have their day in Superior Court. So when you're talking about a pro se litigant, that's a kind of an example of a scenario where that would move forward. But it also could be a pro se litigant who's litigating on behalf as an administrator of an estate, certainly.
Yeah, no, I understand. And no, I thank you for that permanent disability, because that's perhaps what the intent was. But ordinarily, like right now, somebody slips and falls in the shower and, Achilles tendon, don't they go through the administrative process?
So they do, and
Okay,
so that would be a defense that the state of Connecticut could certainly raise in Superior Court, is that, if they hadn't exhausted their administrative remedies in the facility, that would be a reason for the state to assert a defense under the prison administrative PRLA, excuse me. So that defense would still be available to the state of Connecticut if they did not exhaust their administrative remedies.
Okay, so where's the language in here that requires them to still proceed with their administrative process?
It's not enumerated in the statute, but that is the law. Is that's the Prison Litigation Reduction Act, and that that's federal law, that a person does have to exhaust their administrative remedies before they're allowed to proceed in court. And so that's a defense that the state can certainly assert in state court. It's a defense that they often insert in the claims commission process.
So why would we, through statute, bring a incarcerated person down a process that leads them to a pitfall?
I would disagree that it's a pitfall. So I'll give you an example. Currently, right? If you're an individual under the scenario I just stated, where you were in a correctional setting, you tore your Achilles, you didn't get proper medical treatment, they had to amputate your leg. If you obtain a letter from a medical provider, a similar medical provider, saying that they believe that medical malpractice occurred, you're allowed to proceed, and you file that with the claim, you're allowed to proceed directly to state court, right? The state will still have the ability to assert defenses and say, hey, this person, when they were in the facility, never filed a medical grievance. So those defenses are still available. But this is a similar situation where if somebody dies in a prison setting, I believe the ombudsman, or what I'm seeking is the ombudsman's office to be able to issue an affidavit to allow that individual to proceed directly to state court. It's very similar to the authority that the legislature has granted incarcerated individuals in instances of medical malpractice.
So first of all, the problem with that is it does not require you to conduct an investigation. Nowhere in there does it say you're going to conduct an investigation. After the investigation, you believe the case to be legitimate, that you issued the affidavit. The second thing is that ordinarily terms of the claims commissioner are reviewable by the legislature, right? So this totally circumvents this. This says if such an affidavit is submitted, permission to sue the state shall be deemed granted by the claims commissioner. That's an unreviewable action.
Yeah. I think you're misunderstanding. So in instances where somebody's injured from a medical condition in a correctional facility, the legislature is not reviewing that. If somebody submits an affidavit from a similar medical provider saying that they believe that medical malpractice has occurred, the legislature doesn't get an opportunity to review that. Currently, that person is allowed to proceed directly to Superior Court with their lawsuit and have their day in court.
On a medical malpractice case, that may be, but I was talking about the slip in the shower. So a slip in the shower, because I've seen them.
Right.
I review the claims.
I guess
okay?
my question to you, to the committee, and would be, what would make that situation different than medical malpractice, right? If the person has a slip and fall in the shower and the ombudsman, I certainly appreciate your suggestion that the language should reflect that the ombudsman's office shall conduct an investigation, and if they believe that a reasonable claim is warranted, they can then submit the affidavit. I certainly appreciate that friendly amendment. But if that amendment is included, I think the person should be allowed to proceed directly to Superior Court and have their day in court.
I understand your perspective. Thank you, Mr. Chairman.
Thank you.
Any, on that exhaustive review of the bill, any other questions? Senator Chicarella?
Just a couple of quick questions.
Sure.
When we're talking about the mail, and you'll have the ability to make sure that it's privileged. Just a quick question on that. In the event that they inform you, for whatever reason, frustration, they're going to be doing something either to themselves, another inmate, or possibly even a CO, would you be able to then let someone know so you could help the inmate, the other inmate that may be threatened, or staff?
I believe so. So I believe in the statute already is a provision that requires the ombudsman to notify the Department of Correction if there are safety and security concerns like the ones you just mentioned. If somebody is threatened, staff or another individual, I believe in existing language the ombudsman already does have that ability, and so I would believe that if the office did receive a mail communication, that they could report it. And I will just share candidly, in my brief time in this role, I have had those instances where someone has made, a complaint to my office that has threatened staff, and I have reported it to the department.
Excellent. Thank you. And that was just my concern, just, which one you go by, or is it discretion? So that's what I want to try to clarify.
Sure.
And then to the same vein, if somebody maybe committed a crime prior to being incarcerated, and they tell you that, and they haven't been charged for that crime, would you be able to disclose that? Technically you're not their attorney. I know you are an attorney, but
I would believe that would be privileged.
that would be privileged.
I would believe so.
Okay. All right. Thank you for answering those questions. Just on the next section, when we're talking about the subpoena powers, I know you are an attorney.
Sure.
And, if this is passed in this form, you would have the ability to have subpoena powers. My understanding, the criteria to be in the position you're in, you do not have to be an attorney. Is that correct?
Correct.
Do you see any issue with just an average person that doesn't have the understanding of the law and how this works? Would that be an issue in your opinion?
My hope is that the office maintains a staff attorney that does have, an understanding of the law, and that the office is equipped with a staff attorney. The office is kind of getting a 2-for-1 with me, right? And that I'm an attorney and I'm serving in the role as an ombudsman. But the hope is that the office maintains a staff attorney, or at least is assisted. If they don't have a staff attorney on staff, they're assisted through the office of the governor, or potentially maybe the office of the AG, maybe depending on the situation. But to your point, I believe an attorney would have to draft the subpoena, certainly.
Got it. Thank you for answering that. But at the end of the day, it would be the full discretion of the position you hold, not of counsel that would be assisting, correct?
The ombudsman to issue a subpoena, sure. So yeah, it would be the office of the ombudsman issuing the subpoena, but I think you'd have to have an attorney draft it. There are numerous state agencies that have subpoena power, and I don't think it's envisioned that the director of Revenue Services is going to be individually drafting subpoenas, right, for Department of Revenue Services, right? It's envisioned that there'll be an attorney in his office that'll draft those, and so it's a similar situation with this office.
Sure. And thank you for that answer. And there are other ombudsman positions, not just within the Department of Corrections, but there
Sure.
are other ones. Do
Sure.
any of those, if you do know, I'm not trying to stump you on this, but do you know if any of those positions have that authority?
For ombuds, I do not know, but I do know that the Office of Child Advocate does.
Thank you. And then just my last question, just to get some clarification on it, when we're talking about the use of force and the duty to report if there is a corrections officer that may be using excess force, but it's something that is, I'm trying to use the words correctly. I don't want to say minor, right? Because, you know, someone that is using excessive force, doing something wrong, should be held accountable. But there may be times where it's the discretion of somebody watching, like saying, okay, the person was going to get back up if I didn't jump back on top of the person. Is there any concern that, you know, another officer that's there would get wrapped up when they see they thought it would be a reasonable reaction to something that was going on, and the other officer may get caught up after a review of it? Supervisors look at it, you look at it, you say, wait a minute, this may have been excessive. The other officers didn't. But the way this is written, they would then get jammed up if you guys determined it was excessive use.
Yeah, you know, that's a concern that I briefly talked with, you know, correction labor with. You know, the intent is not to take away prosecutorial discretion, and do want to leave it, you know, as permissible language to allow for some discretion for folks who are reviewing this to make a determination on whether or not the officer who witnessed the use of force and their reaction to it, whether or not it was justified. My intention is not to make it mandatory that anybody who witnesses an act of excessive force is automatically swept into being prosecuted. And so I, you know, my intention is to leave that to the discretion of prosecutors, and you know, happy to amend the language to reflect that.
I appreciate that. Thank you. Because again, you know, individuals that are in any profession that are acting in a negative way shines a negative light on the whole profession, whether it's a doctor, an attorney. I hear a lot of stories about attorneys not being so great. So I completely get that, and I appreciate you answering that question and willing to work on that. Thank you for taking the time to answer my questions.
Thank you for the questions.
Further questions or comments? Devon, let me just super quick on the budget constraint language. I mean, that's obviously not something this committee generally deals with. There's
Understood.
Other committees in the building that do, but
Yes.
are you aware of any other than election enforcement, which obviously has a role in enforcing sort of the work of the governor himself or the legislature themselves?
Right.
Is there any other agency that you're aware of that we have similar language for?
No.
Okay. I'm not saying it's a bad idea. Frankly, you know, your dialogue with the ranking member about the judicial branch, I think is a timely one. I mean, we see right now, literally today, as we sit here, there is an attack on the judiciary happening in Washington, where one party that is in control is trying to essentially defund the judiciary because they don't like certain decisions. So it is something that I think maybe we need to have a conversation about, but I was just wondering whether there was anybody else who did it. So thanks for being with us today, and thanks for your work on this.
Thank you for the time.
Next up will be DeAndre Brown.
Hey, how you guys doing? I just want to say what's up to y'all guys. Glad y'all here, whole committee, and yeah, I'll start. Hi, my name is DeAndre Grundy Brown. I'm Executive Director of Evolve Love and Fallen Angels Music, an affiliate of BLM 60. It's Stop Solitary. I'm here in support of Bill number 7133, an act concerning parole eligibility. I want to say I'm famous for throwing that metal detector off every time I walk into the building. And it's because of this. I've had this for about 3 years and a half once it hits June. I'm currently on special parole for 4 years, and after 4 years of incarceration, I have to be on this bracelet for 4 years. Because of something that happened years before I don't think I was even born, but Cheshire home invasion, if y'all guys know. I was charged with a burglary first degree. The definition of a burglary first degree is a person that is guilty of burglary in the first degree when he enters or remains unlawfully in a building with intent to commit a crime. Therein, he is armed with explosives or a deadly weapon or dangerous instrument. Or two, in the course of committing the offense, he intentionally, knowingly, or recklessly inflicts or attempts to inflict bodily injury on anyone. I don't know if y'all saw my TikToks, but I was not put on this earth to put harm to nobody but myself when I skateboard. So I'm gonna just go on with that and just look at the evidence. I did not have a weapon. But as I go, I'm gonna say it again. I'm not gonna stop saying it every time I come up here. Hopefully I'll stop coming up here, but this is the cop-out state. Half of the people incarcerated took what they took to go home or to stop taking court trips because they're tired of being strip searched. I'll say it again just for this one. Half of the people that are incarcerated for what they're incarcerated for are not even doing the crimes that they're in there for. We're never taking that into consideration when we're looking at parole. And I think we need to start doing that, especially we need to start taking that into consideration when it comes to the laws. But to summarize and put into deeper perspective, I was 20 years old when this happened.
Let me just.
Also schizophrenic.
Yeah, so that was the bell. Let me just make sure I understand your testimony. I assume, I don't think you said it at the beginning, but just for the record, I assume you're here in favor of.
7133.
Okay, okay, great.
And also bill number 1541.
1541 strip search provision.
An act concerning the Office of Correction Ombuds use of force and body cameras in correctional facilities.
Okay, great. Further questions or comments from the committee? Further questions or comments? If not, appreciate being with us today.
Thank you.
Next up will be Joselyn Paneda.
Good evening, or good afternoon, actually. Senator Winfield, Representative Patron, and members of the Judiciary Committee. My name is Joselyn Paneda, and I am the Program Associate at Emerge, Connecticut, and a resident of Waterbury, Connecticut. I am here to testify in support of SB 1542, an act raising the age of arrest of a child and the use of handcuffs on young children. As of right now, the minimum age of arrest of a child in Connecticut is 10 years old. This makes Connecticut one of the last states in the Northeast to have a minimum age of arrest that is lower than 12 years old. The exposure to arrest at such a young age not only creates a traumatizing experience to the child, but also perpetuates the cycle of incarceration in the child's life for many more years to come. There are many reasons why a child engages in criminal behavior, such as academic failure, lack of positive role models, environmental factors, and many other reasons that we know. But arresting a child for their behavior does not address or solve the root cause of crime. We need to take a deep look at how many institutions have failed a child first, further leading them to criminal involvement. As stated, I'm a resident and a product of Waterbury Public School System. And during my time in school, I was exposed to many of my friends and classmates being arrested by law enforcement and stripped from their school environment. My city, Waterbury, has the highest number of student arrests in Connecticut. A 2020 report by the Connecticut Office of the Child Advocate highlighted that during a 6-month period in 2017 to 2018 school year, Waterbury Police responded to 198 incidents involving children under 12. Of these, there were 36 arrests made for misdemeanor charges with 9 children aged 11 or younger. And this is unacceptable. Removing children from their peers, labeling them with criminality, and exposing them to the legal system is unacceptable. And it's really disappointing that this is one of the options that children under 12 can be subjected to. Not to mention the over-surveillance and over-policing within our urban inner cities that criminalizes Black and brown children at a higher rate than their white counterparts. I have also been working at Emerge Connecticut for the past 3 years where I assist individuals returning home from incarceration. I deal with men and women from all ages and walks of life. Many of the people I've worked with have been in contact with the legal system since their juvenile years, even before some of the juvenile justice reforms have been enacted in Connecticut. I have realized that if individuals were given a stronger support system in school and in their communities, they would possibly have a different outcome. Arresting children at a young age can have negative psychological effects due to the lack of cognitive capacity that these children have. And it also increases the risk of recidivism because studies have shown that children arrested before 14 years old are 3 times more likely to reoffend as adults. So I strongly support SB 1542 to raise the age of arrest in children, and this will charge everyone to look at alternatives to arrest and implement data-driven programs and intervention techniques that can support the well-being of our children. Thank you.
Thank you. Questions or comments from the committee? If not, thanks for being with us. Corey Betts.
Good afternoon. Senator Winfield, Representative Strathstone, and members of the Judiciary Committee. As you know, my name is Corey Betts, and I serve as president of the Greater Hartford branch of the NAACP, and I'm also criminal justice chair for the state conference of the NAACP. I'm here today in strong support of SB 1541 and SB 1542 because both bills reflect the kinds of justice Connecticut should stand for. One rooted in fairness, accountability, and humanity. SB 1541 strengthens the office of the Correction Ombudsman by giving it the authority and the independence to investigate concerns inside our correctional facilities. Through unannounced visits, independent access and communication, and oversight of use of force incidents. The requirement for body cameras to be worn and operational during interactions protects not only incarcerated individuals, it protects correctional officers too. Documentation promotes fairness for everyone involved. Equally important is SB 152, which would raise the minimum age of incarceration to 14. Right now, children as young as 10 years old can be incarcerated in Connecticut. That's unacceptable, especially when we know these children are overwhelmingly coming from neighborhoods dealing with concentrated poverty. In Connecticut alone, there are 64 census tracts identified as concentrated poverty, with the majority located in Black communities. These are neighborhoods that have experienced decades of disinvestment, trauma, under-resourced schools, and over-policing. When we criminalize children from these communities instead of investing in them, we reinforce generational cycles of incarceration. We cannot claim to care about justice if we're still incarcerating babies while failing to confront the system that failed them. SB 1541 brings transparency behind the walls. SB 1542 protects children from ever entering those walls too soon. Together, they're about changing the trajectory, not just for individuals, but for the entire communities. I urge this committee to move forward with these bills. Let's show that Connecticut values truth, restoration, and equity. Thank you.
Thank
Any
you.
questions?
Questions from the committee? Senator Grilla, followed by Representative Roberts.
I'll be quick. I know you have to get to Wake Up Wednesday where you do great work in your community. On the first bill you testified with the body cameras, I agree. I think it's transparency. I think good officers wouldn't mind having the body cameras on them. It's going to be able to have transparency, which I think is important. I do hope that we could work on other parts of the bill that are concerning. But I just wanted to make that comment that I'm totally open to that piece. And the second part, I know you spoke about the children that are being incarcerated. When you think about handcuffs on an 11-year-old child, I have a 10-year-old son. So, that would, I get it, it's traumatizing. And I think when, kids make mistakes and, I probably made a lot of mistakes after I was 14 years old, right? So, individuals that maybe are going down the wrong path, they're getting in trouble. I think everybody up here would agree that we want to have a diversionary program. We want to make sure these kids are finding a better way, another path. But when there's individuals, and I think you and I had some conversations about this, that there's just, maybe one or two kids that are really corrupting the group, right? They're just continuously getting in trouble, doing the wrong thing. What would be a good way to address those concerns? A, stopping the one or two bad apples from spoiling the bunch, and also help those two kids that may not be able to get any corrective measure if this is passed. How can we really do both of those things?
So I'm just so open when it comes to this type stuff because again, I'm in these areas every day and I'm looking at the root cause of these issues, right? And this is my thing because you have a lot of these young kids who just their mindsets, right? They're exposed to stuff that's just not good. So how do we shift that mindset and giving them different exposures so that they don't have to make those choices? So I think we have to work on what are we doing to shifting their mindsets, because if we're not working on that, you could lock them up and do all that. But if you're not shifting the mindset, they'll continue to go down that rabbit hole. So.
I appreciate that answer, and I have some more questions, but we could talk offline. I know you have to get to Wake Up Wednesday.
Absolutely.
Continue the great work you're doing down there.
All right, thanks.
Representative Roberts.
No, thank you, Mr. Chair. I just want to say thank you for your testimony. It means a lot to me. Just one question, actually. So with this Wake Up Wednesday portion that you're doing in the capital city, correct?
Yeah.
What do you grasp from the ages currently now of the age of 10 to, let's just say,
Again,
14?
right, we have to talk about exposure. We're talking about communities that has been disinvested in, right? We're talking about not just concentrated poverty, but persistent of poverty, whereas though these communities have been impoverished for over 30 years. So if we're not giving our kids opportunity and exposure, shame on us. Locking them up and making things harder for them. I think, the lawmakers, y'all got to do your job, man. I got to call it out, man. Y'all have to do your job, man. There's root causes to what's causing these kids to act out the way that they're acting out. And if we're not creating opportunity and exposure, we're failing our kids.
Thank you. Thank you, Mr. Chair.
Any more questions?
Representative DiCaprio.
Thank you, Mr. Chair. Just
I got to go, man.
you're almost done. Just when you mention root cause, what do you think are the more significant root causes?
See, now this is gonna take a deeper time.
just-
So this is what I'm saying. So when we're talking about concentrated poverty, right? You got 64 census tracts in Connecticut that's considered concentrated poverty. And then there's a program here, an organization that talks about high opportunity and low opportunity areas. Data shows in the high opportunity areas, you have 2/3 of those kids who are starting preschool. Right now, we come to those concentrated and impoverished areas. You only have 9% of those babies that are starting preschool. That's criminal. So we're not tapping into making sure that they're having resources and opportunity. You got kids who aren't reading at 3rd grade level. Why? These are the questions that you guys have to ask yourself in order to I think what happens is we treat the symptoms instead of eradicating the systems. So.
Okay, thank you for that. And I'd like to have an offline conversation.
Absolutely, I would love it.
Thank you very much. Thank you, Mr.
Further
Chair.
questions or comments? Further questions or comments? If not, good seeing you.
Thanks.
Brian Donahue. Brian Donahue. Okay. How about Gus Marks Hamilton?
Good afternoon, Representative Staffstrom. Ranking Member Senator Kissel. The ACLU of Connecticut has submitted testimony, a number of the bills that are up for a hearing today. I'm just going to read the testimony from this gentleman right here, who's Juan Vasquez, if you don't mind.
Okay.
My name is Juan Vasquez, and I'm writing to express my strong support for House Bill 7133. I sit before you today with a heart full of gratitude and hope. Just 4 months ago, I came home after serving 27 years and 7 months. Today, I am proud to say I am working as an alternative to incarceration and policy and community organizer at the New Britain Racial Justice Coalition. HB 7133 is more than just a bill, it is a second chance. It has already made a difference in my life, and I am living proof of what redemption and opportunity can look like. Because of this bill, I've been able to come home, reunite with my family, and give back to my community in ways I never thought possible. I mentor youth at the Boys and Girls Club. I work to bring awareness about violence and how to de-escalate conflict, and I help others understand that there are real opportunities out here, that the streets are not the only option. I also hold my CNA license and am enrolled at Goodwin College studying phlebotomy and EKG. These things wouldn't have been possible without the opportunity this bill provided, and I'm not the only one. There are many others still incarcerated, men who mentored me, who guided me, helped shape me into who I am today, and they are still waiting for their chance. They are missing pieces in our communities, and they are ready to come home and be a part of the solution. If we raise the age limit in this bill, we are not just changing individual lives, we are restoring families, rebuilding communities, and investing in futures. These men are not threats, they are assets. And just like me, they are ready to prove it. I believe in second chances because I've lived one, and I'm here to ask you to help extend that same chance to others who have earned it. Thank you for your time and for considering the impact HB 7133 can have, not just on those inside, but on all of us outside who are ready to welcome them home. And I'm sure Juan would be happy to answer any questions that folks might have.
Thank you. Questions or comments from the committee? No, thanks, Milos. Mike Vargo. All right, so I think what we're gonna do is I think we have several of our union presidents. I think they're gonna come up and split their time, their 3 minutes, but be able to answer questions together. Is that correct? Okay, so just for the
Yes, Mr. Chairman.
All right, so just for the record, we've got Mike Vargo, who's number 22 on our list. We have Robert Beeman, who's number 28 on our list. And we have Jeremy St. Pierre, who's number 48 on our list. Is that correct?
Yes.
And they're joined by Brian Anderson, who was number 46 on our list. So, all right, Brian, whenever you're ready.
Thanks, Chairman Staffstrom, Chairman Winfield, members of the committee. I'm Brian Anderson, Legislative Director for Council for AFSCME. As you said, with me are Mike Vargo, President of Local 1565 Corrections, Robert Beeman, President of Local 391, and Jeremy St. Pierre, President of Local 387. They're all working corrections officers. They represent 5,000 correction employees. There are 4 bills we'd like to comment on briefly. We strongly support Senate Bill 1328. This bill prohibits the private ownership or management of a prison by a private corporation or person. There are some things that are sensitive enough that they should be run by the government and be directly accountable to the people. Prisons are one. The private prison industry is fraught with stories of corruption. In Connecticut, Governor Rowland's chief of staff was convicted of soliciting a bribe from a private prison operator. Private prison corporations have been found to have higher levels of assaults on inmates and staff, higher levels of inmate death, and have been found not to save taxpayers any funds. We support Senate Bill 1309. It allows a warden to find the commissary account of an inmate who engages in assaultive or destructive behavior. This is a small deterrent, but it's important to give staff tools to deter bad behavior. We oppose or have concerns about some sections of Senate Bill 1541. Section 4 seems to go against the trend of giving discretion to the state police and prosecutors in terms of prosecution. This takes away the may and replaces it with a shall for prosecuting a correction officer who fails to report another officer committing a force offense. We're aware of no situation in which an officer accused of not reporting has not been prosecuted or punished. Such a change sends a message to our members that the state does not trust them when morale is already low. In New York, bad morale resulted in a corrections disaster. We urge you to consider the morale of an already exhausted workforce. Commissioner Quiros recently reported that staffing in the 5,900 employee Department of Corrections is already short by 600 employees, or more than 10% staff short. This bill also gives extraordinary power to the correction ombuds. Our legal staff is concerned that it might not have adequate due process protections for employees. We want to make sure that our members' guarantee rights are protected during any interview or appearance before the ombuds. Thank you for adding language allowing an officer to view video showing their presence prior to any disciplinary proceeding. We support Section 9 of Senate Bill 1543, which calls for increased staffing. Section 10 provides for more productive use of inmate out-of-cell time. Currently, inmates milling around out of cell in facilities not designed for such is a security problem. We'd be happy to answer any questions.
Thank you. Let's start with Senator Kissel.
Thank you very much, Chairman Staffstrom. Brian, thank you so much for coming and testifying with these wonderful men who are foot soldiers or boots on the ground in our correctional system. Mr. Officer Beeman, I haven't seen you in your capacity as head of 391, but please extend my very best to all the officers, men and women in 391 up in my neck of the woods, North Central Connecticut. And I stand with you. I've talked to Brian about this notion of privatization, and I certainly have never been supportive of that, nor would I ever be supportive of that. So happy to support that legislation and appreciate your testimony on the other matters as well. So thank you for your service. Thank you, Chairman Staffstrom.
Thank you, Senator. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon. I just want to focus on 1309. How would that work? What's the vision here? So let me just give you a scenario. A food fight in cafeteria. How would, if at all, 1309 be involved?
In situations like that, we do have the option to write a DR, it's called, within the prison system. They do have the opportunity to grieve the DR. Part of the process is, in the past, you would lose loss of phone, loss of rec. Those things have been taken away at this point. You can't do that anymore. Loss of out-of-cell time for a time period. So we're looking, the main issue we have with our members is these individuals will assault the staff member, fight other inmates. Food fights are very rare. Once in a while that happens, but more severe things where there's no consequences to their actions. They can punch a CO in the face, go to SEG for, I believe, less than 15 days. They can come out, punch a CO in the face again. And I think they have to wait 3 to 4 months before they're allowed to go back to SEG.
Okay. And certainly we don't want any of that bad stuff happening, but under 1309, under this, what happens if the incarcerated individual doesn't have any money in their commissary?
My guess would be they would not take that away. If there is no money in the books, then they would not be privy to this.
Okay, so you'd have 2 inmates, one who has money in the commissary and they could be penalized, and one who doesn't or doesn't have enough to pay the fine, and they wouldn't be punished under this process.
If I had to guess, no, they would not.
Why wouldn't this possibly incentivize bad conduct in that? And let me just give you the example. You have 2 inmates, one has $500 in their commissary, the other has 0, and the one with $500 in the commissary punches a corrections officer, pays the $100 fine, and then buys the opportunity to punch a corrections officer again.
I don't look at it like that. We're just looking for a way to deter this type of behavior. At this point in time, over the years, some of the bills that have been passed, these type of loss of rec, loss of phone, loss out of cell time, those things have been removed. There are no repercussions. This was an idea that was brought up. We brought it to your attention.
No, I understand, and I don't want the bad conduct to happen either, right? By anyone. So let me just ask you about the process. So, punching a corrections officer in the face is a crime. Outside on the street, it's a crime.
Correct.
Does the process allow that individual to be arrested for that crime and perhaps time added on to their sentence?
The officer would have to press charges. There's been situations where officers will not press charges in those type of situations.
Okay.
Then state police would be called in and they go through that whole legal process at that point.
And your personal experience, I mean, do you have any personal experience with that? That I'm trying to figure out why one would not want to do that.
I can't speak on, we could talk for days about certain situations. I don't want to speak here about those, but every situation's different.
Yeah, understood. Every inmate, every corrections officer, everybody's different. We come from different backgrounds and all that stuff. Well, no, I appreciate the four of you coming here today. It's a unique experience, and thank you, Mr. Chairman.
Can I just, before we go any further, can I just get you guys to identify yourselves for the record, just so we've got it on the transcript?
Michael Vargo, local 1565.
Brian Anderson, staff for Council 4.
Robert Beeman, local 391.
Jeremy St. Pierre, local 387.
Okay, thank you guys. Yeah, I mean, I knew who everybody was, but I just wanted to make sure we had it kind of clear in the transcript. Representative Howard.
Thank you, sir. Thank you, Mr. Chairman. Thank you guys for being here. I appreciate it. It's nice when you guys come. Absent this piece of legislation that you were speaking with Representative Fishbein about 1309, how are you controlling the population now, right? So I think what I heard you say is this legislature is taking away a lot of the mechanisms for which you could control the population within the facility with repercussions for actions, right? Control may not be the best word, but how are you doing that now? And is it effective?
My personal opinion, I do not think it's effective. There's very little consequences at this point in time within the prison. So there's a lean in, when I started, we heard about the pendulum swinging, for rehabilitation or other things. Right now it's leaning towards programming, which we're for that. Some of the bills that have been passed over the years, we believe is a good thing in the long run. But our members feel much differently. We feel that our rights have been violated a lot, where there's no consequence. You can get urine thrown in your face, feces thrown in your face, and nothing will happen. They will go to SEG for a short period, RHU, restricted housing unit, and then they will get released, and they could be released right back to your unit.
And in some of our facilities where we're rationing punishments. So for example, we gave the example of 15 days for an assault on an officer in segregated housing. So if you see that this person, officer is being assaulted, that person might get 5 days and then released back to his housing unit, knowing that this person is a chronic disciplinary issue. And then the next time he does something, you'll give him 2 days, just so that there is a consequence. So that's one of the ways we're trying to manage.
They're breaking up the discipline.
Yes.
It could be 14 days, but if you give them
If you give them 14 days, they can't receive any more discipline after that.
Not within the 30-day period.
No matter what they do.
So if somebody commits a violation or an infraction, I'm not exactly sure what term you use inside an institution, but if somebody assaults a corrections officer and gets 14 days, if they did say, then basically for the next 16 days, they can do anything they want and there's no ramifications. Am I understanding that correctly?
Yes.
And do we ever charge people? Like, it should be a crime, and it probably is a crime. I'm sure it is a crime to assault a CO, right?
Right.
But do we ever criminally charge incarcerated persons that assault a CO?
Yes, there's times when that happens, but usually when you have a person that is a chronic disciplinary person, their time is so high. So for example, if you have a person that's doing 80 years,
Right.
what's another 5?
Right. So because essentially those are folks who another arrest isn't going to mean anything to them,
Exactly.
right? If somebody's on life without parole, or like you said, 80 years and they're 50.
Right. So we're not talking about the majority of the incarcerated people. We're talking about a small handful who are chronic that are causing most of the problems within our facilities.
Okay. And so the concern is then that absent 1309, just for that small group of people that you're having trouble with consistently because I'm going to say sort of have nothing else to lose, if you will, because, another charge isn't going to matter. They've already hit their 14 days. You need something to be able to, for the safety of your staff and probably the other, other residents in any unit they're in. That's what you sort of need 1309 for. Am I understanding it right?
It's just another tool, another deterrent to help with some of these chronic individuals.
And those individuals, am I correct in assuming that in addition to causing some of those individuals that are chronic problems are in addition to causing a risk to you and your members, your coworkers, your staff members, they also pose risk to other individuals that are incarcerated?
Yes.
Okay. Thank you, Mr. Chairman.
Senator Shkreli?
Thank you. Trying to pick up right off where Representative Howard left off. We talk about or hear from family members of individuals who are going to be incarcerated and they're concerned about their well-being. And we heard that, the officers, have a tough job. They're being assaulted on occasion. But would you say there's more inmates being assaulted by inmates than inmates assaulting staff?
Since the out of cell bill was passed a few years ago, the amount of inmate on inmate fights have increased. We have the numbers. I don't want to misspeak right now, but we can get you those numbers. They're through the roof at this point.
Sure, and I would assume that would be the case. The lack of the consequences. They feel emboldened to do that to officers, and they'll possibly get an additional charge, which I'm assuming would carry a longer or stiffer penalty than just a simple assault on another inmate. But that's the concern that I have, that there is probably a lot of assaults in the prisons, and there's going to be no way to deter that from happening. So we're talking about trying to keep, inmates safe. That's part of, your job. It's in your mission statement. Without having those resources, how are you able to ensure that these other inmates are in fact safe when they're going there, when there's no deterrent?
I agree. I mean, any little thing at this point will help.
Thank you for what you guys do, and thank you for taking the time to testify.
Thank you.
Further questions or comments, Representative Quinn?
Thank you, Mr. Chair, and thank you, gentlemen, for being here. Brian, are you taking a position one way or the other on Section 4E, the body cams?
No, my understanding is this is a study, and I don't think our members object to studying, but we believe a study will probably be redundant because there's so many cameras. I don't know if one of the presidents wants to comment on that.
We've spoke about this. We are for a study, 100%. I do have some questions and concerns. Our entire facility is covered in cameras in these situations where they go into medical or they go into a secure area where there might not be a camera. Everything is done with a handheld. We have to turn on a handheld camera and walk into an area without a camera.
Is there sound on any of the camera systems that you presently have?
The handheld cameras, yes.
Okay, but the general camera in the ceiling, no.
I don't believe so.
Okay. All right, thank you very much. And again, thank you, gentlemen, for what you do as well. I know you have a very difficult job.
Further questions or comments? Further questions or comments? If not, let me echo that. Thank you guys for being with us and appreciate it.
Thanks, Mr. Chairman.
Lori Ladon. Lori Ladon with us? Oh, okay. How about Stella Dugu? Dugay. Sorry about that, ma'am.
Good afternoon, Chair and Judiciary Committee. My name is Stella Duguay, and I work for the Center for Children's Advocacy. I am the coordinator for the Speak Up program, and this program allows me to do youth organizing within the city of Hartford and also to push into the detention centers. I run groups in Hampden Regions at time, and I'm also in Hartford Detention. So I am here to support Bill HB 7250, and specifically, I will be talking about Section 1, the recommendation to allow the Community Expertise Work Group to appoint 2 young people as voting members to the JJPOC. I also am the co-chair of the Community Expertise Work Group in the JJPOC. So we know that it takes a village to accomplish any worthy goal, especially goals regarding the upbringing, the educating, and protecting of our young people. CT has been considered a forerunner in the area of juvenile justice reform and has been recognized by the Office of Juvenile Justice and Delinquency Program in DC for our commitment to implement youth interventions supported by case studies, best practices, and research-based interventions. It is time to continue to be trailblazers in the area of the youth legal system by elevating voices of youth historically, by elevating youth voices in historically adult-only places. So last month, our youth inspired members by the JJPOC by holding a youth-led meeting that included teens from the community, many who were directly impacted by the youth legal system, as well as young men from Manson who participated via Zoom. Committees, organizations, public servants, and lawmakers work diligently and endlessly to do what's right for children in Connecticut. However, at times, the numbers, the graphs, the meetings, and reports overshadow the voices and faces of Connecticut's most vulnerable population. The passing of Section 1 of HB 7250 will help shine light and give voice to this population. Their contributions will be heard on a regular basis, not just at a one-time event. Our youth who have direct involvement with the juvenile justice system know what works, what doesn't work, and most importantly, what has caused them harm and trauma. We now have the opportunity to invite these same people to be part of the solution, using their experiences to ensure that the policies and laws created will help rehabilitate other youth, not induce more harm. This can lead to reduction and break the cycle of failure. Thank you for your time and your consideration.
Thank you. Questions or comments from the committee? If not, thanks for being with us.
Thank you.
Jameem Davis.
Good afternoon. Co-Chair Senator Winfield, Representative Staffstrom, Ranking Member Senator Kissel, Representative Fishbein, and all the members of the Judiciary Committee. My name is Jameem Davis, and I am the co-director of Bridgeport Generation Now. My colleague, Callie Heilman, spoke earlier. I am here today to testify in support of SB 1543, specifically Section 8, an act concerning the Department of Corrections, which directs the Commissioner to study the relocation of the Bridgeport Correctional Center and propose alternative sites. I was born and raised in Bridgeport and come here today not as an expert, but as a concerned citizen. Bridgeport has 2 correctional facilities, the Bridgeport Correctional Center, which sits in the middle of our city, and the Bridgeport Juvenile Correction Center, which is located on our city's waterfront. Neither of these locations are appropriate. The Bridgeport Correctional Center is located in the heart of our city, directly across the street from Central High School, the new Wakeman Boys and Girls Club, the Southwest Community Health Center, and a Catholic church. It houses sentenced offenders from the surrounding towns of Milford, Norwalk, Derby, Ansonia, and others. When I was in elementary school, I walked past the BCC to get to school and remember the footprint of the facility being much smaller than it is now. It is jarring to see how the facility's footprint has grown, and I can't even imagine the psychological effects this barbed wire facility is having on children who have to walk past it today. It's actually quite scary. Children should not have to go to school across the street from a jail. Children should not have to attend after-school sports and enrichment programs across the street from a jail. Families should not have to live or go to church across the street from a jail. At Bridgeport Generation Now, we appreciate the legislature initiating this study as it provides the state with the opportunity to research best practices into facilities that prioritize human rights, restorative justice, and rehabilitation. To that end, we offer the following. 1, community engagement of the neighborhood, school, and other community anchors that surround BCC should be prioritized in this study. And 2, our understanding is that the Bridgeport Correctional Center holds hundreds of people in pretrial detention because they can't afford bail. We should revisit bail reform legislation so that the footprint of the facility will be reduced no matter where it's located. Thank you.
Thank you, Jinmin. Questions or comments from the committee? If not, appreciate your advocacy on this and certainly appreciate you highlighting the long overdue need for bail reform in this state. So thanks for being with us.
Thank you.
Cindy Prizio is next. Cindy Prizio with us? Don't see her. How about Na Thompson? Naika, sorry about that.
Good afternoon, members of the Judiciary Committee. My name is Naika Thompson. I am an attorney with the Center for Children's Advocacy. I'm the director of its Racial Justice Project.
Ma'am, could you just do me a favor? Just pull that microphone a little
Yes,
closer.
sorry about that.
No worries.
Okay. I am here in support of the Senate Bill 1542, which seeks to raise the minimum age of arrest in Connecticut from 10 to 12 and then from 12 to 14. This bill is necessary and overdue reform that aligns with research on child development, racial justice, and effective public safety strategies. Arresting children as young as 10 does not address the root causes of crime. Instead, it exacerbates them. Research shows that early involvement in the criminal justice system increases the likelihood of recidivism, disrupts education, exposes children to trauma, and lowers mortality rates. Time spent in detention or under arrest interferes with healthy brain development, making it harder for youth to develop the coping skills, emotional regulation, and decision-making abilities necessary for long-term success. The younger a child is when they enter the system, the greater the risk of continued justice involvement into adulthood. In Connecticut, 1/3 of all cases of youth ages 10 to 12 are eventually discharged, dismissed, or annulled, often with services in place. However, the physical and psychological impact of arrest and incarceration is unending. Data consistently shows that youth of color are disproportionately arrested and prosecuted, even when engaging in the same behaviors as their white peers. In Connecticut, Black and Hispanic children are significantly more likely to be arrested than their white counterparts, reflecting broader racial disparities along the juvenile justice continuum. Black youth in Connecticut are 4.68 times more likely to be arrested than white youth, and 2.25 times more likely to be detained. Hispanic youth are 1.41 times more likely to be arrested and 3.76 times more likely to be detained than white youth. This legislation is a step towards reducing these inequities, ensuring that all children, regardless of race, are given a fair chance to succeed. Child health groups, including the American Academy of Pediatrics, have called for nationwide minimum age of juvenile justice legal system jurisdiction of at least 12 years, which would prevent criminal legal system involvement and redirect children to community resources rather than criminalizing behavior to ensure children receive developmentally appropriate responses to address their behavior. As you have heard, Massachusetts and California have already raised the age of arrest to 12, recognizing that criminalizing childhood behavior does not improve public safety. Instead, these states have prioritized community-based interventions that address the underlying causes of youth offenses, such as poverty, trauma, and lack of access to mental health services. Connecticut should follow their lead and invest in preventative services rather than punitive responses that harm children and communities. And we urge you to pass this bill. In addition, Section 3 of this bill limits the gratuitous use of handcuffs, and we would ask that you support that part of the bill as well, because it traumatizes our children.
Thank you.
Yes.
Questions or comments from the committee? If not, I appreciate you being with us today. Evilise Correa.
Welcome back. You may testify when you're ready.
I didn't check the speaker list, so I didn't know I'd be up for a while. Okay. Just pulling my testimony up. Here we go. I'd like to thank the Judicial Committee for allowing me to speak today. My name is Evilise Correa, former resident of Broad Street Juvenile Detention Center, Long Lane, and former resident of 2 North at York CI. That's the juvenile wing. I was incarcerated while my father was in prison for cannabis, and with the grace of God, East Hartford Public Schools and OPP in Hartford, I was still able to graduate early with honors and began my early college education by the age of 17. I'm here to support Bills 1309, 1328, SB 1435, SB 1543, HB 7133, HB 7193, and especially SB 1541. You guys met my husband earlier. He's a schizophrenic sponsored skateboarder with poor judgment. He walked in through an open door to retrieve his sister's laptop from her ex-boyfriend during a schizophrenic break. Not quite Stephen Hayes or Joshua Komisarjevsky, but there hasn't been a single reform we've passed since 2007 that would have prevented that awful tragedy. But just like the 1994 crime bill, when a single tragedy happens to the white community, the Black and brown community suffers. Next is SB 1541. When I first entered York, I was almost subject to a controlled strip search. The older women coached me as I cried loudly, and the CO rolled her eyes. Bend over until you can see me and spread them. I was 17. The youngest person with me was 15, and her father was next door at Gates CI. Anytime we moved throughout the facility, pause. Can I just pause my time real quick? I need to breathe. Thanks. Anytime we moved throughout the facility, even for non-contact visits, they made us disrobe. When the bail commissioner came to visit me, I was strip searched before and after. I was strip searched an average of 3 times a day. They never found anything. Body cameras are a fantastic resource, but this doesn't go far enough. COs currently have to use a camcorder while documenting incidents. In this legislation, is a start to bringing about transparency. We have to remember that the AG's office right now is prevent the release of a murder on video. We must protect transparency in the bill, and I'll go even further why. While state law prevents me from viewing the video, it didn't prevent the lawyers from having them describe the incident to me second by second and describing those details as I follow along with the transcript. And that's exactly what happened. I was able to ask questions to former residents of Garner CI about the incident, and taxpayers should know exactly what they're paying for. And I think that accountability will help taxpayers from being other victims of DOC abuse besides the people hidden behind those walls. Thank you.
Thank you, Elise. Comment or question from members of the committee? Comment or question? If not, thank you for coming back again and again and again. It's important.
Not going to stop
wait,
until
hold on.
it passes. So.
I just
Senator
wanted to
Jack
say
Caldwell.
thank you so much for being here. I came in at the end of your testimony, but you know, it's very difficult, and just appreciate you being here and your advocacy.
Thank you.
Thank you. Seeing no questions, appreciate you joining us again.
Thank you.
Next is Brittany Lamar.
Good afternoon, members of the Judiciary Committee. This testimony is in support of HB 7250, an act implementing the recommendations of the Juvenile Justice Policy and Oversight Committee, recommendations that all overwhelmingly passed at the JJPOC meetings in December of 2024 and January of 2025. The JJPOC is unique in its bipartisan nature in that it brings together stakeholders from all aisles, branches, and niches of experiences, and we aim to understand what works, what doesn't, and we seek truth, not an agenda. And the recommendations of JJPOC are the result of extensive work over several years, focusing on key moments in a young person's life and the system's response to them. Driven by data and the pursuit of truth, the recommendations aim to improve outcomes for young people, thereby fostering safer and stronger communities. The JJPOC maintains several work groups that work to research, analyze, and engage critical stakeholders to understand how policies, practices, and procedures at all levels of system response and engagement are affecting or ineffective in their approach to dealing with young people. Many of the recommendations from JJPOC this year are a culmination of 3 to 5 years of work that many stakeholders have put in. And so the recommendations, there's a handful of recommendations before you in this bill. The first are to formalize the appointment of a representative from DESP, the Department of Housing, and change who is responsible for appointing the young people to the JJPOC itself. The education-related recommendations within this bill are a years-long effort and in some sense a multi-year effort to address the critical need to get kids back into schools following the pandemic. The recommendations call for municipalities to report to SD on the utilization and efficacy of those review teams, of the attendance review teams, and whether municipalities are using the intervention plan to determine its efficacy. If these are critical infrastructures that the state put in place approximately 8 years ago, the state needs to understand if we are using, if municipalities are using these chronic absenteeism intervention plans and determine whether they are working or not, and then to evaluate why and where we can go from here. But first, we need the data to understand. The diversion-related recommendations are the JJPOC's fourth renewed attempt to standardize the diversion process. Prior reports focused on mandating pre-arrest diversion, and in conversations with several municipalities over the course of the last year, the diversion work group has reevaluated its approach to standardizing the diversion process. First, understanding through conversations with police officers that not every municipality or police officer in a municipality has the opportunity to divert young people. Right now, approximately 34 municipalities cannot divert a young people because they don't have access to a diversion system. So the recommendations really are meant to first ensure that police can divert and then work through in partnership with Post Council to develop a standard statewide youth diversion policy. And the remaining recommendations from JJPOC 1 is to ensure that the reentry process for youth returning home, that we do have a quality assurance framework.
Hey, sorry to interrupt, but the sound has chimed, so I just want to stick to the rules. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, Brittany, I know how involved you are in this. I want to thank you for that work and for testifying here today. Abraham Santiago. Abraham Santiago. Shelby Henderson Griffiths. Shelby Henderson. Oh, I see Abraham. Abraham, can you? There you go.
Hello, Senator Winfield.
Good afternoon. You may proceed.
Thank you for the opportunity to speak today. My name is Abraham Santiago. I'm a smart justice leader with the ACLU of Connecticut. I stand in strong support of Senate Bill 1542, a bill that will shift the course of hundreds of our state's children. Let's be clear, the laws allowing for the arrest of children as young as 10 are rooted in a history of racial injustice. These laws were never designed to help children, especially Black and brown children. They were designed to criminalize them. This isn't by accident, it's by design, and it's time we confront that truth. The United Nations has made it clear that the minimum age for criminal responsibility should be no lower than 14, yet Connecticut children as young as 10 are arrested. What's worse is that the children are disproportionately Black and brown. Arresting them doesn't prevent crime. It doesn't fix the root causes. Instead, it perpetuates a cycle of trauma, punishes them for the circumstances beyond their control, and ensures that they face a lifetime of disadvantages. Studies have shown that over 70% of the youth in the criminal justice system have experienced significant trauma. Instead of offering healing, we respond with punishment. We arrest children who are already struggling with mental health issues and systematic barriers. That arrest doesn't address the trauma. They don't need to be locked up. They need services and support. Raising the age of arrest to 14 is more than just a number. It's an acknowledgement that our children, particularly children of color, deserve better. They deserve to be supported, not criminalized. This bill doesn't just raise an age limit. It raises our standards as a society, as a step towards a future where our children, especially Black and brown children, are not seen as disposable or criminalized from birth. Right now, Connecticut is one of the last states in the Northeast to allow children as young as 10 to be arrested. By passing Senate Bill 1542, we align ourselves with national and international human rights standards. This bill is a chance to show that we are willing to change course, to stop criminalizing children, to start investing in what we truly need: healing, education, and opportunity. Every moment we allow these laws to remain in place, we are complacent in a system that disproportionately harms Black and brown youth. Senate Bill 1542 is a good start, but it's just the beginning. It's a first step in dismantling a system that criminalizes our children instead of protecting them. We must not continue to let a broken system define the future of our youth. Thank you.
Thank you. And thank you for coming back. Question, comment from members of the committee. Question, comment from members of the committee. There are none. Again, thank you for joining us one more time.
Thank you, Senator.
You're welcome. Shelby Henderson Griffiths, Zoe Masters, Randall Chinnock.
Good afternoon, Judiciary leadership and members. I'm here in support of three bills today. They would be SB 1328, SB 1541, and SB 1543. As a recent payout of $3.75 million settlement to the Talbot family for the homicide of their son Robbie at New Haven Correctional in 2019 illustrates, Connecticut's correctional facilities still have problems that the loved ones of incarcerated people, and ultimately we taxpayers, pay the price for. I sat through the entirety of that February 14th Judiciary Committee meeting about that settlement. I've never in my life heard such compelling and horrific testimony, and it's absolutely galling that the CO found responsible was let off. And as part of the settlement, the state, we, have identified Carlos Padro against further legal action. According to Commissioner Quiros in that testimony, every kind of DOC policy was violated during this incident, yet the blue line held. None of the other officers present stopped Padro or testified against him. 1541 would make it mandatory, not optional, to prosecute officers who witness illegal use of force and fail to intervene. It requires that voice or video recordings be released to the public within 96 hours. And it requires that the Commissioner of Correction appears before this committee and other joint committees with a plan for implementation of body-worn cameras. 1328 relates to private ownership, operation, or management of correctional facilities. Operation of correctional facilities is a necessary government function. It's just like healthcare. The Department of Correction is accountable for health and safety of its employees and the incarcerated people in their custody. They're incentivized towards good behavior, those employees of DOC. Privatizing the ownership injects an insidious force, the profit motive. We don't have to look any further than what's happened with privatization of healthcare in Connecticut in recent years and the resulting closure of facilities and bankruptcy that benefits no one but the private equity investors. There's no reason to think that privatization of prisons couldn't go in the same direction. There's good reasons why President Biden ended the federal government's use of privately owned facilities. His executive order says in part, quote, privately operated criminal detention facilities consistently underperform federal facilities with respect to correctional services, programs, and resources. We should ensure that time in prison prepares individuals for the next chapter of their lives, end quote. Thank you.
Thank you. Question, comment from members of the committee? Question or comment from members of the committee? Seeing none, thank you for joining us again.
Thank you.
To provide us with your testimony. Anderson Curtis. Welcome back.
Thank you.
You're welcome.
Good afternoon, everyone. Senator Winfield, Representative Stastrom, Ranking Members Kissel and Fishbein, and the rest of the Judiciary Committee. My name is Anderson Curtis. I am the son of Albert and Rita Curtis. I'm here to testify in support of Senate Bill 1542, an act raising the age of arrest of a child and the use of handcuffs on young children. The most vulnerable people who become enmeshed in the criminal legal system are the young people under the age of 18 who suffer unique harms due to their involvement in the criminal legal system and are more likely to experience even wider racial disparities than exist for adults. Recognizing these harms and disparities, I believe children, all children, should be supported with services and resources that support them, their families, their communities, rather than criminalized wherever possible. According to a recent state audit, an overwhelming majority of transferred boys and all of the transferred girls into the adult system during 2019 lived in families previously investigated for child abuse or neglect, often multiple times. The audit found that most boys in the system completed few or no programs while incarcerated. Young people will most likely be unable to change behaviors until their root issues and traumas are addressed in a rehabilitative, non-carceral setting. No one can heal in the system, setting, situation where the harm was caused. Because of systemic racism, Connecticut disproportionately incarcerates Black youth and youth of color at significantly higher rates than it does white youth. When comparing young people with similar crimes and past encounters with the justice system, those who entered the adult system were 30% more likely to be rearrested after returning to their communities than young people who remain in the juvenile system. Connecticut is the last state in the Northeast to have a minimum arrest rate that is lower than 12. No coincidence, Connecticut was the last of the original 13 colonies to abolish slavery. Need I say more? Thank you for your time.
Thank you. Comment, question from members of the committee. Senator Gaston.
Thank you so much for coming before the Judiciary Committee on today and for making your compelling case. All too often I've experienced the ease with which young men who look like me, fall under the crushing yoke of injustice by an inherently prejudicial criminal legal system. And to ensure that you have an advocate out there that's ensuring fairness and equity within our system is so critically important. I believe someone much more eloquent and articulate than I said that when you look at the criminal justice system, oftentimes you see just us. And what they meant by that was black and brown people. And I don't care where you look at in the United States, regardless of what state it is, we see that there are more African Americans and people of color behind bars in this invisible institution than in 1860 when slavery was alive and well in this country. We must do a better job. We have forged great leadership in this area with Senator Winfield and also with the great representative from the city of Bridgeport who chaired this committee, Representative Stastrom. And I believe that Connecticut is going to continue to be a state that other states could model themselves after. But thank you for coming today. And I thought that your message was very on point and inspiring to this committee. Thanks.
Thank you.
Thank you, Senator. Comment, question from other members of the committee. Comment or question? Seeing none, thank you for joining us again, Anderson. Good to see you.
Take care. Thank you.
All right, Jasmarie Melendez.
Good evening, committee members.
You may proceed.
Thank you for allowing me to speak in support on raising the age of arrest of a child and restricting the use of handcuffs on children. I am speaking as a city council member in the city of Bridgeport and also as an educator who has worked with children for many years, including the age range being discussed here. Research has constantly shown that children's brains are still developing, particularly in the frontal lobe, which is responsible for decision-making, impulse controls, and understanding consequences. As an educator, I have always seen that behaviors in children are in direct response to their basic needs not being met, and children need care, guidance, and intervention, not handcuffs or arrests, and children should always be given an opportunity for intervention, an opportunity to address the root causes of their behaviors rather than funneling them into the criminal justice system. And we must focus on these ways to support them in expanding on counseling, mental health services, and community programs within our cities to meet their needs. Myself, I am a daughter of two formerly incarcerated parents, and I know that nothing about the prison industrial complex is humane or rooted in rehabilitation. And when we speak around a worry of revolving doors and a lack of accountability, an increase in juvenile arrests will not and never will be a solution to that issue. But this legislation would prevent further harm and would be a measure to address the school to prison pipeline and overall prevent future experiences with the carceral system. Thank you.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? If not, it's good to see you. Thank you for your continued work. Christina Capitan.
Good afternoon, Senator Winfield, Representative Stafstrom, and respected members of the Judiciary Committee. My name is Christina Capitan. I am the co-founder of CT Canna Warriors, and I submit this testimony in strong support of SB 1541 and SB 1542. Regarding SB 1541, this bill is not just an abstract policy, it's deeply personal to me. I was incarcerated for a nonviolent cannabis-related offense, and during that time, I witnessed and experienced repulsive treatment from within the walls of Connecticut's correctional system at York CI. I saw women stripped of their dignity, ignored when in pain, and dismissed when pleading for help. I was subjected to degrading conditions. I myself was treated with blatant disregard and cruelty. There was no meaningful accountability, and there is no real mechanism for redress. SB 1541 takes a necessary step forward. It strengthens the Office of the Correction Ombudsman, ensuring a more robust, independent oversight, greater transparency, protections against retaliation, and a clearer pathway for incarcerated individuals to raise concerns without fear. It begins to create the structure needed to prevent the abuses that I lived through. I implore you to support this bill, not just for me, but for every person inside who still doesn't feel heard. Regarding SB 1542, I want to commend Representative Kadeem Roberts for championing this essential bill. As a mother of a Black son, I have lived in fear for his safety from a very young age. Not because of who he is, but because of how law enforcement might perceive him. From the time he was young teen, I begged him to stay close to home. He was also afraid because he saw the way that police treated and harassed me for years, simply because I help people access cannabis for healing. This bill will prevent the criminalization of children under 14 and limit the use of handcuffs on them, finally acknowledging that they are children and they should be treated as such. Too many Black and brown youth are forced to grow up too fast under a system that treats them like threats before they can even drive. SB 1542 is a step toward protecting their innocence and building restorative alternatives to truly support public safety and community healing. So on behalf of the CT Canna Warriors in my community, I urge you to vote yes on SB 1541 and SB 1542. These are not just bills, they are necessary correctives to decades of systemic harm. Thank you very much for your time and all your hard work.
Thank you. Questions, comments from members of the committee? Questions or comments from members of the committee? If not, Christina, thank you for joining us again, providing us with your testimony. Andrew Feinstein.
Senator Winfield, Representative Stafford, Senator Kissel, members of the committee. I'm Andy Feinstein. I'm the legislative chair of Special Education Equity for Kids in Connecticut. We represent parents, providers, attorneys, advocates fighting for the rights and good education of kids with disabilities in Connecticut. I'm here to speak on three bills. First one, 1542. I'm only talking about the handcuffing provision of that, which we support. Kids with disabilities often communicate through activity, through behavior that appears aggressive to others. Subjecting them to handcuffs shows them that physical force is the way to communicate their needs. It is exactly the opposite of what we need to be doing. Now, we are concerned that the exception in the bill, which reads, when necessary for purposes of public safety, is an exception that swallows the rule, that it allows for handcuffing in virtually every case when in the judgment of the police officer that it's necessary for purposes of public safety. We ask that that provision be tightened up. Clearly there needs to be an exception to the prohibition on handcuffing of young children, but the exception should be much narrower. Second bill we want to talk about was 7071, which is an attempt to return to the old days of using the FWISN Family with Service Needs provision in cases of truancy. It was not a system that worked. It was a system that caused enormous hardship and pain, both for the state and for individuals. There was discussion before somebody raised the issue, I think it was Representative Fishbein, about why isn't the Department of Education doing more about this? Well, I'm not a defender of the Department of Education, as Senator Gadkar Wilcox well knows. But in this case, they've put out this LEAP program. It's had very significant results in reducing the amount of chronic absenteeism, especially in districts where it's been implemented. So things are being done, and it's a program where school staff goes out to the homes and encourages kids to attend school and tells them they belong. It works very effectively. That's the type of things we need to be doing to dealing with absenteeism, not throwing kids into the juvenile justice system. Finally, and just quickly, throw our support behind 7250. We are a member of the Education Subcommittee of JJPOC. And there is a provision in there which deals with absenteeism, that deals with the problem that 7071 seeks to address in a much more effective way. So I thank you for your time, and I appreciate the work you guys do. Thank you.
Thank you. Senator Kissel.
Thank you very much, Chairman Winfield. Mr. Feinstein, good to see you again. I understand I've seen you in the audience at the Select Committee on Special Education. I know you advocate there. In your first concern, I agree with you that the exception would swallow up the rule. Do you have a proposal for modified language something like an exigent circumstances where the health and safety of others are in danger, or something like that. I don't know if,
I'll go with that, Senator.
what?
I'll go with that.
All right.
No, I mean, I think obviously it's up to this committee at LCO to decide the language, but I do think
Something like-
serious threat of injury to another would be a better standard.
Just
than-
tighten it up.
Than one
Okay.
needed for public health safety.
I didn't know if you had a specific.
No, I
one.
did not.
Okay, thank you, sir.
Thank you, sir.
Thank you. I'll just add, this is a public process, and it is not on the public to give us answers, but if folks have suggestions, we take those very seriously. Comment or question from members of the committee? Comment or question? Seeing none, thank you for joining
you very
us.
much,
and
Senator.
Thank you for the work that you do. Erica Bromley.
Hello, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. My name is Erica Bromley, and I'm the Youth Justice Consultant for the Connecticut Youth Services Association. My testimony focuses on 3 bills in support of SB 1542, in opposition of HB 7071, and support of HB 7250. CYSA strongly supports SB 1542 regarding raising the age of arrest. First and foremost, raising the minimum age of jurisdiction is developmentally appropriate. Preventing children from entering the system whenever possible is critical. Arresting a child does not address root causes of crime, prevent the likelihood of committing future crimes, provide space for healing, or increase public safety in the long term. In fact, research shows that even brief contact with the court system increases the likelihood of reoffending. Currently in Connecticut, we have a strong diversion system in our JRBs that serve ages 10 to 17. This system will continue to serve this age group if the minimum age is raised. Our diversion system is rooted in restorative justice, which is an evidence-based approach proven to be successful. The state, along with CYSA, is working to ensure a standardized diversion process is accessible for every child in every community. Connecticut needs to join the rest of the states in the Northeast who already have a minimum age of arrest higher than ours. We know that impulsive, risk-seeking behaviors are the product of normal child development, and that neurologically they lack the cognitive ability to engage in rational analytical reasoning or consider the possible consequences of their actions. This is a straightforward decision. However, I do need to add that meaningful investment in the community for those serving these youth is critical. Simply put, the funding should follow the youth. Next, I would like to touch on HB 7071, an act concerning family with service needs, which CYSA strongly opposes in its entirety. This bill would undo years of reform efforts, which were based on research outcomes and real-world experience. Returning FWISN cases back to court is a major step backwards and one that is not at all warranted. Let's remember that FWISN behaviors or status offenses are not delinquent criminal acts. These youth need services in their community, not a negative court experience. Youth service bureaus, as the point of referral for FWISN cases, often provide the necessary services for these youth, and if not, will make referrals to other appropriate services. This entire bill focuses on the possibility of utilizing court proceedings, supervision, and even potentially confinement for youth who have unmet needs, often related to mental health, special ed, or basic needs, and who haven't even committed a crime. These young people need community-based services, but also need intensive case management, something the court cannot provide in the manner necessary for youth to succeed. I strongly oppose reinstating FWISN, which would criminalize status offenses, unnecessarily involve youth in the court system, make families wait longer to access needed services, and increase the risk that young people will engage in further risky behavior and return to court. And lastly, I'd like to express CYSA's support for HB 7250, an act concerning the recommendations of JJPOC. We support this bill in its entirety, but especially the diversion recommendations. Prioritizing diversion is a necessary step in strengthening the overall process of keeping young people out of the system.
Okay.
And I'm done.
Yep, okay. Representative.
Thank you.
Good afternoon, Erica. Looking at 7071, you mentioned that there's a connection to incarceration with this program, the FWISN program?
You mean in the language? It looked like in the bill language that eventually through the process, if there was violation of court orders and so forth for youth entering under family of service needs, that there was a potential opportunity down the road for possible confinement.
Okay. You're aware that this program was in place until I think 2018 or 19, correct?
Correct. I was part of, yes, I was part of removing it from the court jurisdiction.
Yeah, I'm aware. Are you aware of any individual that ever went to jail over violation of the poison process that was previously in place?
I do not have access to court records and don't provide direct service. So I'd have to look into that more.
Okay, so the answer to the question, you're not aware of any individual that has ever gone to jail for violation of the criteria that's set up in the statute as it previously existed?
Correct. I'm not aware of that, but I don't want to say it never happened.
Okay, no, because I've gotten representations from the chair of a different committee in the building that says that her opposition is because she hears from, she didn't particularly name you, but descriptors that claim that children have gone to jail under this system, and that's just not accurate. So I'm trying to figure out, what does a parent do with a child who keeps on running away, and parents are looking to set up rules, don't want that kid to get in the back of the car with the gun, with the buddies and all that stuff? What program is available to those parents now that this program has gone away?
There is a standardized process of referrals for FWISN behaviors to the youth service bureaus, who, as I mentioned in the testimony, would provide appropriate programming after doing, needs screeners and so forth, and doing an intake with the family, finding out what the issues are. A lot of these youth come with a host of unmet needs. Could be mental health, could be special education, all of those kinds of things. So determining what is needed and then providing that intensive case management that was mentioned, and then providing access to services, which are going to be a little bit different in each community, but matching that youth and that family with potential services, and finding the best way to sort of mediate the issues, at home, or finding a suitable alternative in the meantime, until you can figure out what the next steps are. Because oftentimes it's not just as simple as what, a parent has a rule and a kid doesn't want to follow it. There's often other needs that follow that may paint a little bit of a different picture of what needs to happen.
Okay, so you're saying that program presently exists without
The
police?
youth service bureaus. Correct.
Okay, what's the name of that program?
So it's not a program, it's a system. All referrals for family with service needs, when this law was changed, the referrals, there's a standardized referral form, depending on whether it comes from the school or the community, that if it was a community, that the police officer or parent would fill out and send that referral to the youth service bureau, who would then do their intake and their screening and all of those things, and that provide necessary services or make referrals to appropriate services, and then do case management.
Have you been personally involved in any case since 2019 that's followed that procedure?
I am a consultant for the association, so do not provide direct services, but I advocate for and work along with those who are providing these services.
Okay. It's my understanding that as a removal of any reference to poison in the statutes, which is it's families with service needs, all references have been removed, that programming that you're talking about does not presently exist. So I'm trying to figure out, I've spoken with my Youth Services Bureau, I've talked with my police department, and I'm being told that no, as a result of removing the program, we can't do that anymore. And that's my experience as well. So I'm trying to figure out what's the truth there.
So there was never, quote unquote, a program that was utilized. It was a referral form, the same referral form that existed that people sent to court and then sort of just wash their hands of it and sent it to court is mirrors the form that is utilized now. And it is targeted towards what we call family of service needs behaviors. So whether it's officially FWISN or not, if that is not part of, the statutes anymore, it is those behaviors that are associated with that are often called status offenses. And so there's a list of those status offenses that were previously officially FWISN, and those are the behaviors that get referred to a youth service bureau, either through the school or through the police if it's community-based. And that is something that has been promoted and explained and is part of a process that now exists. When we remove them from court jurisdiction, those same behaviors transferred over through a similar referral process to the communities, to the youth service bureaus. And that absolutely exists across the state through every youth service bureau.
So I recognize that police officers, and we're trying to, I don't personally, policy-wise, I don't think that all things should necessarily go through the police. Are you telling me that, because I'm hearing the direct opposite, the kid that's running away, that a parent can apply, because they were able to, through the statute change, the parent can apply for services similar to FWISN, and that the services would be rendered similar to the program as it existed previous to the change in the statute?
So for school, for truancy and defiance of school rules, the referral comes directly from the school. For the other status offenses, runaway, beyond control, those things, those can come either from a police officer or a parent. And they fill out the referral form. It is sent over to the youth service bureau. And then, as I mentioned, the process begins from there with addressing their unmet needs, providing services and programs, or necessary referrals. Okay. And just as an aside, the programming, the process before, when kids were sent to court, the court did not have any specialized programming for status offenses, as they are more focused on, which is one of the reasons why it was removed, is that the court focuses on high risk kids, and status offenders are not criminal. They're not criminal acts, and they are often high need, but not high risk. And so they don't belong in the court system at all.
Yeah, that's how the system worked previously. A probation officer was usually assigned to the youth. They didn't go before a judge, but there was a process. And I guess I'm at a place that I'm hearing the direct opposite from two different places. So I've got to look at some other stuff. But I had an incident in my town where, now the child's been arrested because he shot a firearm through the back of somebody's car window. But mom had reached out to various entities trying to get this young man help, and was told that she couldn't get those services. So I guess I have some more research to do, but I thank you for coming here today.
Yeah, I'm happy to discuss it more. Thank you.
Thank you. Question or comment from other members of the committee? Question or comment? No, thank you very much for joining us. Madison Reynolds.
Good afternoon, Mr. Chairman and members of the committee. My name is Madison Reynolds, and I reside in New Haven, Connecticut. I am a public health student and a person who had an incarcerated parent. So with these experiences in mind, I'm here today to express my strong support for Senate Bill 1435. This bill is not just about lactation, it's about human dignity, health, and healing. It's about giving mothers and their infants the chance to bond in the most natural and foundational way possible through breastfeeding. Breastfeeding releases oxytocin, also known as the love and bonding hormone. This hormone is key in promoting emotional bonding between a mother and her child. For the infant, the hormone fosters a sense of safety, attachment, and regulation, critical to healthy brain development. For the mother, the hormone can reduce stress, anxiety, and symptoms of postpartum depression. Research from the National Institutes of Health show that breastfeeding enhances maternal responsiveness and reduces the stress response even in high adversity environments. In correctional settings where stress and trauma are often amplified, this neurobiological benefit cannot be overstated. When an incarcerated mother is able to breastfeed her baby, even just during visits, she is reminded of her humanity and her power to nurture. It reinforces her identity as a caregiver, which can be key to rehabilitation. Studies in correctional health journals suggest that mothers who maintain bonds with their children are more likely to engage in positive behavior while incarcerated and are less likely to recidivate upon release. Empowering incarcerated mothers in their maternal roles isn't a luxury. It's a transformative opportunity. It offers them a sense of purpose, agency, and connection that can be life-altering. These babies deserve the comfort of their mother's touch and nourishment, and their mothers, despite their incarceration, deserve the chance to mother. Denying them this opportunity is harmful. There is no justice in stripping away one of the most basic intimate experiences of early motherhood simply because of incarceration. This bill lays out a clear and compassionate path forward, providing a safe and hygienic space, informs mothers of their rights, and posts the policy visibly. These minimal steps with maximal impact. By passing this legislation, Connecticut would reaffirm its commitment to maternal and child health, to rehabilitation over punishment, and to the belief that all people, regardless of their circumstances, deserve the chance to love and to heal. Thank you for your time and consideration.
Thank you. Questions, comment from members of the committee, question or comment from members of the committee? Seeing none, thank you very much for joining us. Olivia Rinkus.
Thank you and good afternoon, and thank you to the Judiciary Committee for the opportunity to testify. My name is Olivia Rinkus, and I'm from the town of North Stonington, Connecticut, and I'm also an undergraduate at the University of Connecticut studying political and cognitive sciences. I'm testifying today in support of several bills. First, would like to speak on SB 1541, an act concerning the Office of the Corrections Ombudsman, use of force and body cameras in correctional facilities, claims against the state by person who are incarcerated. I am in strong support of increasing accountability within correctional facilities as recommended in this bill to include accountability for individuals who witness the use of force and do not report it, as well as updating the terminology to include the use of restraints, chokeholds, canines, and other inappropriate or excessive methods. I am also in support of the increased resources going to the Office of the Ombudsman to investigate occurrence of force or other abuses or malpractices occurring in Connecticut correctional facilities, as well as increasing the ability of individuals to sue or otherwise seek restitution for harms experienced while incarcerated. As state employees and facilities, there needs to be full transparency and accountability for incidents that cause harm. Being incarcerated does not mean an individual has forfeited their right to be treated with dignity and respect. I'm also strongly in support of SB 1542, an act raising the age of arrest of a child and the use of handcuffs on young children. I strongly appreciate legislators taking up the issue of preventing youth from entering the carceral systems at a young age, which can have detrimental impacts and cause an individual to have increased contact with the system throughout their life. I'm also in strong support of the increase of diversion from carceral responses to other support services. Along with the passing of this bill, Connecticut needs to ensure a robust system of support for youth and families, including education, housing, food, family services, and health and mental health services. As others have stated in this hearing, a youth harming themselves or others is a cry for help. This bill will prevent youth in distress from further traumatization through entry into the legal system. It's also a step towards preventing the disproportionate impact of the carceral system on Black and brown youth. By prioritizing diversionary and individualized response to youth activity rather than a carceral response based on policing, community policing, surveillance, and punitive reactionaryism, Connecticut can begin to address the root causes rather than perpetuate cycles of reactive incarceration. I would also like to quickly testify in favor of SB 1328, an act prohibiting the private ownership, operation, or management of state correctional facilities. While incarcerated laborers do not have the same rights as non-incarcerated employees, it is important to prevent private ownership of carceral facilities and the profit off of incarcerated workers. It is also important to keep these facilities state-operated to ensure full transparency and accountability. Thank you again for the opportunity to testify.
Thank you. Question or comment from members of the committee? Question or comment from members of the committee? Not Olivia, thank you for joining us again to provide us with your testimony. Nancy Peters, welcome back.
Thank you. Hello, committee members. My name is Nancy Peters. I'm from Norwich, and I'm regularly in touch with over 200 people who are incarcerated in Connecticut, most of them with lengthy sentences. I and virtually all of my incarcerated associates strongly support HB 7133, which would remove the requirement that people whose offense happened when they were under age 21 would only be eligible for that earlier parole if the offense happened before October 1st, 2005. I submit there's no magic to that date. According to recent brain science, adolescents and young adults' brains are still developing through their early 20s, and so they act impulsively and make poor decisions, whether they were in that age group in 1998 or 2008 or 2018. And these behaviors are greatly reduced as they get older, regardless of the calendar year when that happens. I also support extending this special consideration to people who were under age 25 at the time they caught their case, again, because the emerging brain science supports this. Adolescent brain researcher Elizabeth Scott has written that people are not magically different on their 18th birthday. Their brains are still maturing. And furthermore, I believe a fair and just sentencing system must consider the conditions under which a person develops. We can't assume that the brain of a 25-year-old growing up in chaotic, violent, deprived circumstances has reached the same level of maturity as one raised in a safe, nurturing environment. And I wonder whether this legislature thinks that sentencing laws were lenient enough after 10/1/2005 so that no one sentenced after that time deserves a second look. So I looked at the records of some of my incarcerated correspondents. One was 21 in 2013 when his offense happened and has an 80-year sentence. Similarly, for many others, I found 13 of them were between age 19 and 23 and got between 30 and 90 years between December 2005 and 2020. Surely it doesn't take that long in a functioning corrections system for someone to have aged out of criminal behavior, turned their life around, and be ready to rejoin society. Finally, here's a tiny slice of what I found in the stories of these overly sentenced, mostly Black and brown brothers and sisters. These are quotes, I lost being a young little girl at 12 years old and also lost my baby at almost 13. I had to grow up without my parents and ultimately was captured by the system early in life. Raised by a mother who cast you out of home when you're 12 years old to roam the streets going from house to house, hoping to find stability that's only a dream of a neglected child. There'll be more on the written testimony. Please support this bill with the enhancement of under 25. Thank you very much for listening to me. And do you have any questions?
Thank you. Question or comment from members of the committee? Question or comment? If not, it's good to see you and thank you for the work you do. Barsha Jara. Welcome.
Good afternoon, chairs and members of the committee. My name is Varsha Jorwar, and I am a justice advisor with the Connecticut Justice Alliance. The CTJA is a statewide youth adult partnership working to end the criminalization of youth. I'm giving this testimony today to communicate my strong support for Bill SB 1542, an act raising the age of arrest for a child and the use of handcuffs on young children. We all know that many systems in the United States are deeply broken, and the legal system is no exception. For far too long, our justice system has prioritized punishment over rehabilitation, which leaves families and individuals, especially those that are the most vulnerable, deeply harmed. There's already an overwhelming amount of research that shows the negative impact incarceration has on adults. Now imagine how much more damaging that experience is when it happens to children. Young minds are still developing. They need care, they need guidance, and they need support, not handcuffs and prison cells. When we put our kids into environments that are not built to nurture them, we aren't just punishing them in the moment. We're setting them up for long-term harm that ripples out through their families and their communities. So it's not just the individual, it's just the community. Arresting kids or arresting children at such young ages does not address the root causes of crime. It only reinforces cycles of trauma and criminalization. As somebody from Waterbury, and as a constituent from Waterbury, where we have some of the highest rates of school-based arrests in the state, this issue is deeply personal to me. As recently as this month, there was a 12-year-old girl that was arrested in Waterbury. So again, this issue is very personal and very recent. It's a very real issue, and our kids deserve better. They deserve opportunities, not cages. This is why I'm here to express my full support for Bill SB 1542. Raising the minimum age of arrest to 14 is just one small step, but it's an important one. My vision is a world where no young person is ever traumatized by systems that are meant to rehabilitate them. This bill moves us just one small step closer to that vision. Thank you for your time.
Thank you. Question or comment from members of the committee? Question or comment from members of the committee? Varsha, you've done this before?
This is my first time.
Oh, you did great. You did really good. Just want to let you know that. Heather Summers. Nick Teeling.
Good afternoon, Senator Winfield, Representative Stastrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Nick Teeling. With me today is Dr. Emily Knox, who will be available to answer any questions. We're testifying today on behalf of Connecticut Voices for Children, a research and advocacy organization working to ensure that one day Connecticut is a thriving and equitable state where all children achieve their full potential. CT Voices is testifying in support of Senate Bill 1328, an act prohibiting the private ownership, operation, or management of state correctional facilities, Senate Bill 1542, an act raising the age of arrest of a child and the use of handcuffs on young children, and House Bill 7250, an act implementing the recommendations of the Juvenile Justice Policy and Oversight Committee. For the purposes of time, I'll be reading a condensed version of our written testimony with a focus on Senate Bill 1542. Senate Bill 1542 seeks to increase the minimum age at which a child can be arrested under certain circumstances, from 10 to 12 years old and in 2026, and from 12 to 14 years old in 2028, and to limit the use of handcuffs on children younger than 14 years old. These policy changes represent a necessary and evidence-based shift in how Connecticut responds to children in crisis, one that centers both child development and public safety. Research shows that early system involvement increases the likelihood of deeper system entanglement. Youth who are detained before adjudication are significantly more likely to be formally processed, incarcerated, and rearrested later in life. Early contact with the justice system also disrupts their education, reducing school re-enrollment and graduation rates, and lowering their chances of long-term success. Incarceration during adolescence was shown to reduce employment and earnings in adulthood, further limiting future opportunities and perpetuating cycles of disadvantage. By raising the arrest age, Connecticut can interrupt these patterns and promote a positive developmental trajectories. From a public safety perspective, this bill ensures that arrests remains available for the most serious and imminent threats, while promoting more effective and proportionate responses for children exhibiting behavioral concerns. Research shows that community-based therapeutic interventions are more effective than incarceration at reducing recidivism. Systems that invest in early support, not surveillance, produce outcomes for youth, families, and communities. Connecticut has made important progress in juvenile justice reform. Senate Bill 1542 continues that progress by ensuring that children are not criminalized for behavior they're developmentally unequipped to control. Instead of reacting with arrest, we must respond with support. We should not treat 10-year-olds like criminals for struggling to manage emotions they have not yet learned to name. We should not pathologize pain with punishment. This bill invites us to meet children with the kind of structure, support, and compassion that real public safety requires. We respectfully urge the committee's support and passage of the bill. Thank you for your time and consideration, and we'd be happy to answer any questions.
Thank you. Questions from the committee? Questions? If not, thank you both for being with. So, Dr. Knox, are you planning to come back up, or you good? Because you were signed up later. So, You're good. All right, perfect. We appreciate that. Thank you.
Thank you.
Thank you both for being with us. Appreciate your testimony. Thomas Burr.
Good afternoon, Representative Staffstrom and members of the Judiciary Committee. My name is Thomas Burr. I'm the Public Policy Manager of the Connecticut chapter of the National Alliance on Mental Illness, otherwise known as NAMI Connecticut. NAMI is the nation's largest grassroots mental health organization dedicated to building better lives for the millions of Americans affected by mental illness. For anyone who's unfamiliar with us, I have included more information about NAMI in my written testimony. I'm testifying today in regarding Senate Bill 1543, an act concerning Department of Correction. NAMI is an organization that firmly believes that all people with mental health conditions who are incarcerated deserve access to quality mental health treatment. We believe in help, not handcuffs. On pages 6 and 7, section 11, lines 159 through 188 in the bill, it calls for a medical professional to incorporate a person's mental health history during the preliminary interview when they enter a correctional institution, as well as a mental health assessment if indications warrant it. If the person is determined at the time to be in need of mental health services, they shall immediately be provided evidence-based mental health interventions delivered by an interdisciplinary team of mental health care providers and mental health therapists, and that such person shall be periodically evaluated by a mental health care provider or mental health therapist and provided such services as needed. Now, you've already heard today from NAMI Shoreline's co-president, Denise Paley, talking about her experiences with her son and her son not getting timely mental health treatment. As an organization, we care about this because unfortunately, people with mental health conditions are overrepresented in the Department of Corrections system and as a direct result of the behavioral aspects of these conditions. NAMI believes that it should not be a crime to have a mental health condition, and certainly people who do have the added misfortune of being incarcerated should be able to get meaningful health care during their imprisonment. All too often, people with mental health conditions exit the DOC system significantly more ill than when they came into the system. This is, in our view, completely inhumane and unacceptable to the citizens of the great state of Connecticut. As taxpayers, we do not want our money to be used, in effect, to torture and dehumanize people by leaving them untreated. We can and must do better, especially when you consider that 95% of the incarcerated population eventually re-enter society. We should not be returning people back to the community broken. So therefore, we strongly urge the committee to support these aforementioned sections of SB 1543. And I should note that I did survey our members before I came up here, so we didn't fill the chamber with testimony and be here till 2 a.m. 100% of them agreed with what I just mentioned. And since I haven't heard the ding, I'm going to say we are also a member and supporter of the Stop Solitary Connecticut Coalition and echo the comments by Barbara Fair, especially around strip searches. They're dehumanizing and inhumane. And I should mention Sarah Eagan's testimony regarding restraint and seclusion. Again, help, not handcuffs, please. Thank you.
Thank
Appreciate
you.
the time and
Way
would
to
answer
get it
any
all in
questions.
before that dreaded ding.
Not my first rodeo as representative.
Got it. Questions or comments from the committee? Questions or comments? If not, thanks for being with us.
Thank you.
Rachel Mirsky. Rachel Mirsky. Okay. How about Kate Rivera?
Good afternoon. My name is Kate Rivera, and I am testifying regarding many of the bills today. The fact that we're handcuffing and arresting children under 14 is unconscionable. And many of the cases are, dismissed or nollied because we give them the wraparound services that they ultimately need. It's just common sense to raise the age to arrest them. And they also lack the prefrontal cortex development to fully understand the ramifications of what they're doing, and I support creating that bill that takes into account the science. And just from a fiscal standpoint, it's ridiculously expensive to incarcerate versus help. I want you to know we should have absolutely no private prisons in the state of Connecticut. So please, let's just stop that conversation immediately. I served on Bridgeport's Juvenile Review Board, and I know that that program, along with others, the wraparound services, are cost effective and help stop crime and serve to stop traumatizing vulnerable children while holding them accountable. I've been in those meetings where they have to face the music with the people they've harmed, and it's powerful. Corrections officers need to have body cameras. We need simple accountability. Human rights violations happen behind those prison walls. I grew up with a girl who was imprisoned in Massachusetts at Framingham. She was repeatedly raped by a guard during her incarceration. She later sued the state and won, but never got over the trauma and died young in her early 40s. We know J. Allen Jones was murdered in custody here in Connecticut. Body cameras will prevent mistreatment and allow for transparency and accountability. Additionally, it is imperative that we invest in body scanners to stop the absolutely excessive use of strip searches. 350,000 is an obscene number based in sadism, humiliation, and power. Policies need to be created to minimize this number now. Fully funding the office of the Corrections Ombudsman is the only way the work Attorney Ward has been appointed to do can actually happen. I don't know why we would establish this office only to set up Attorney Ward for failure by not giving him the tools, money, and staff necessary to actually do the job. Would you ask a janitor to clean a floor and not give them bleach and a mop? Of course not. So please fund the Corrections Ombudsman's office. Additionally, this office must have subpoena power. It's essential to the work. In conclusion, I want to remind you all that the number of people we incarcerate is unjust and immoral. In the US, we have a uniquely American issue of mass incarceration. We jail the most people in the world. Do not allow yourselves to think that incarcerating, I'll wrap it up, that incarcerating children and adults is in any way normal or necessary. Look to Finland and other countries for effective, humane rehabilitation. Please remember, this body can invest in and stop these issues by fully funding our schools, pro-social activities, and wraparound services.
Thank you. For questions or comments from the committee? Questions or comments from the committee? If not, thanks for being with us and thanks for your advocacy.
Steve, can you add some children's voices to this who are actually being affected?
Kate, it's a public sign-up process, so anybody who wants to, and often we do have children who come testify before the committee. So we're always happy to hear from everybody's voice on this.
Okay.
Stephen Casillas. Stephen Casillas. Okay. If not, we'll go back to Josiah Schlee.
Yep. Can you hear me okay?
Yes, sir. Go ahead.
Good afternoon, Senator Winfield, Representative Staffstrom, and respected members of the Judiciary Committee. My name is Josiah, and I'm here today in support of SB 1541. I think it's a vital bill to strengthen oversight, safety, and justice within the correctional systems of Connecticut. I particularly want to highlight and support the bill's provisions around the use of force, mandatory reporting, and body-worn camera implementation. However, I urge the committee to strengthen this area with a simple amendment. I included it in my testimony, but it regards when you start recording. Body cameras, I believe with the technology of memory cards these days, we can record before incidents happen and all the time, because I personally have had to fight a case for 13 months because body cameras weren't on. it seems there already are provisions for prosecution for not intervening in the altercation. I think there should be similar prosecutions for not activating body cameras. I'm not sure if I missed a part of the bill, but I do not see it there. Cameras aren't just about catching, the bad ones. They're about protecting truth, both for the incarcerated and for the correctional staff. But they only work when they're on and capture the entire incident, before it even starts. In closing, I commend this committee for bringing forward SB 1541 with the added amendment to require body camera activation for all incidents and optimally recording all the time when interacting with those in the facilities. Connecticut can lead the way in building a correctional system that is just, transparent, and rooted in human dignity. And I appreciate your time and your leadership on these issues. And I thank you all very much.
Thank you. Questions or comments from the committee? If not, thank you. All right, is there anyone else we missed? I see one person online. Anybody in the audience? Okay. Yes, ma'am. What's your name? What is it? And what was your number? Oh, 2. Okay, then you're up first. Jordy Ojadis, who's number 2 on our list, who will be followed by Lori Ladon, and then finally Heather Summers. Then we're done.
Good afternoon today, Chair, Senator Winfield, Representative Staffstrom, and members of the Judiciary Committee. My name is Jordy Ojadis, and I am a Justice Advisor with the Connecticut Justice Alliance. The Connecticut Justice Alliance is a statewide advocacy and public policy organization working to end the criminalization of youth. Our organization is also a youth adult partnership working closely with the justice advisors who are young people directly impacted by the system. I am here today to express my strong support for raising the minimum age of arrest in Connecticut. As a concerned citizen, I believe it is vital for our state to prioritize development and well-being of young people, ensuring that they are treated with care and consideration they deserve, especially when they come into contact with the criminal legal system. Raising the minimum age of arrest will be a critical step in safeguarding our children and fostering a more rehabilitative rather than punitive approach to youth justice. Research consistently shows that brain development in adolescence continues well into their 20s. Young people, particularly those under the age of 18, are still developing their decision-making abilities, impulse control, and emotional regulation. This means that they are more susceptible to make poor decisions, but it also means that they have a greater capacity for rehabilitation. By raising the minimum age of arrest, we acknowledge that children and teenagers are in a critical developmental phase and should be treated in ways that promote growth and positive outcomes rather than contributing to a cycle of incarceration that have lifelong consequences. Raising the minimum age of arrest aligns with the growing trend in many other states and countries that are rethinking how we treat youth in the legal system. States like New York and Illinois have already raised their minimum age of arrest to help ensure that children are not unnecessarily exposed to harmful effects of being arrested and incarcerated. The stigma of an arrest or criminal record can have devastating long-term consequences for young people, affecting their ability to access education and employment and housing opportunities as they grow older. Finally, this would allow Connecticut to invest in more community-based alternative to arrest and detention, rather than using the criminal legal system as the first response to youth behavior. We can offer resources such as counseling, mental health services, and youth diversion programs that address the root cause of a young person's action. These alternatives are not only more effectively in preventing reoffending, but they also foster a sense of responsibility and empowerment in our young people and helping them make better choices in the future. In conclusion, raising the minimum age of arrest in Connecticut is a step towards more just, compassionate, and effective system for addressing youth behavior. It reflects our belief in second chances and our understanding of our adolescents' development and our commitment to ensuring that all people have an opportunity to thrive.
Thank you, sir. Appreciate it. Questions or comments from the committee? If not, appreciate being with us. Lori Ladon.
Thank you. Hello, Senator Winfield and Representative Safstrom, ranking members of Senator Kissel, Fishbein, and all the esteemed members of Judiciary Committee. My name is Lori L. Ladon, and I'm a resident of Shelton and a smart justice leader with the ACLU of Connecticut. I'm testifying in support of two bills, SB 1435, an act concerning mothers who are incarcerated and breastfeeding their infant, and HB 1543, an act concerning the Department of Correction. I believe that the state of Connecticut should be prioritizing health and safety and the well-being of our most vulnerable residents. And that often includes the people that are held custody in Connecticut's prisons and jails. Connecticut is the only state where the Department of Corrections oversees and operates its own systems. And my biggest issue is, where is the accountability? Access to health care for incarcerated people is a constitutional right under the 8th Amendment. But the quality of care in Connecticut has been negligent and borderline criminal. This contributes to the poor health and outcomes for the incarcerated people and the returning citizens. There's data that estimates that each person in prison takes 2 years off a person's life expectancy. Each year they spend. I've been out for 5 years now, and I'm still suffering the repercussions of the lack of care. I had to borrow money to fix my teeth. I'm still in pain due to the lack of dental care and the blatant disregard for every request that I had to get help. I was denied tools that were to be sent in to help properly clean my dental work because I had to have dental implants put in the back, and it resulted in extreme bone loss, expensive dental visits, constant discomfort, and bills I am still paying. While incarcerated, my next door neighbor was pregnant and in pain. I had brought her to medical, and she was not allowed to go in that day, and they sent her home. They instructed her to go back to her cell next to mine for being traumatic. And an hour later, she delivered that baby in her toilet. I'm sure many of you know of this horrible, horrible situation. I was there. SB 1435 would build on efforts to improve the access to prenatal and postpartum support in Connecticut prisons. And Senate Bill 1435 would require the Commissioner of Corrections to finally develop a written policy allowing lactating parents in DOC custody to breastfeed during the visits with their infant. Supporting and normalizing breastfeeding parents would help people all across Connecticut, and it'll continue to participate fully in society. And I also support the goals of SB 1543, because too often with those with obvious mental health needs.
Thank you, ma'am. Thank you. That was the bell. We appreciate your testimony. Thanks for waiting.
Thank you. Thank you for listening to my testimony today. I appreciate it.
We get it. Thanks for sticking with us 5+ hours into this. So,
well, thank you for calling on me. I appreciate it, Senator.
Finally, Heather Summers.
Good afternoon. My name is State Senator Heather Summers. I represent the 18th District, and I'm here in support of Senate Bill 1435, an act concerning incarcerated mothers breastfeeding their infants. Good afternoon. Thank you, chairs and honorable members of the committee. Allowing incarcerated mothers to breastfeed their children is not just a matter of convenience. It's critically important for both maternal and infant health, psychological development, and family preservation, something that we all strive for here in the state of Connecticut. The act of breastfeeding allows an infant to deal with nutrition, strengthen their immunities, and it also creates a bond between the mother and the child. It also helps reduce sudden infant death syndrome, and particularly RAD, which is something that our DCF is dealing with on a daily basis. That is the reactive attachment disorder that is caused when a mother does not have that close connection with an infant. It's a serious condition. Children struggle with it throughout their entire life. It creates emotional, behavioral, and developmental challenges. In a situation where a mother cannot raise her child full-time or the child's living with a relative, denying her the opportunity to breastfeed during visits is an unnecessary form of punishment that is counterproductive to both the mother and the child's well-being. Allowing breastfeeding during visitation supports the continuity of care and preserves that maternal-child bond and connection, which is critical. It not only provides the infant with the emotional security, but it gives the mother a sense of purpose and identity, reinforcing her role as a parent for when she leaves incarceration. And it's a vital link to her child during the incarceration. It's important to recognize that breastfeeding in prison is not about extending special privileges to incarcerated individuals, but about addressing the fundamental needs of public health, child development, and human dignity. Enabling and supporting this practice will promote family stability, reduce the emotional trauma of separation of a mother and a child, and offer positive avenue for both mothers and children to experience a healthy and supportive relationship during the challenges of incarceration. Incarceration should not be a permanent loss of a mother's ability to bond with her child or to participate in a healthy child's development. Supporting breastfeeding under circumstances is a modest but profound, impactful policy that can change and have a long, positive difference in the lives of both the incarcerated mother and the child. So I urge this committee to pass the Senate bill out, and it would not only promote the well-being of mothers, many of which in our prison system are minority mothers, but children to contribute to the overall health and well-being of our community and our state of Connecticut. And I'm happy to answer any questions you may have. Thank you.
Thank you. Questions, starting with Senator Kissel.
Thank you very much, Chairman Staffstrom. Senator Summers, thank you for coming and testifying and putting this bill proposal forward and having the patience to stay with us to the end. I know that you have a tremendous medical background, and indeed, I think you're just shifting time between here and the Public Health Committee. But I'm just wondering how this issue came before you and what prompted you to propose this bill.
Thank you for that question. I spent, it's a little pun, my summer in prison. And I spent a lot of time at York Corrections, and I am familiar with the case that the woman before spoke about. And I learned a lot, and I learned about some of the positive things that we're doing and some of the things that need vast improvement within our incarceration system, especially with women. I'll give you one example. I learned that the only way that women in York Prison can get a mammogram is for a mobile unit to come down from Hartford Healthcare to do the exams. I think there's 1,300 women there. There was 50 women at the time that had a finding that had still not had a follow-up. I met the doctors. I talked to all the clinicians. The doctors there had shared with me, and this is something we're trying to deal with in public health, that they can have 3 referrals out of 12,000 incarcerated patients to go to UConn every month, just 3. I still haven't figured out why. And when I was there was a doctor who was getting an appointment for a gastroenterology appointment that was requested not this spring, but the spring before. So that patient had waited that long to get an appointment. Then I met with the mothers that were at the prison. Obviously you can't keep your child with you like other states do allow you to keep your child with you until they're about 18 months. And they do have a nice wing, a maternity wing, and they are allowed to pump. But one of the overall issues, we're trying to keep families together in the state of Connecticut. So if they have a child during incarceration, typically the women that I met were giving the child to a family member who would come to visit very frequently. Sometimes they came 3 times a day to see the mom, but they are not allowed to touch their infant. They can't have the touch of breastfeeding where it's skin on skin contact. The warden, I don't want to put her on the spot, so I probably just outed her, but she said she would love to see that be able to happen within her system. She is prevented from allowing that right now. I look at it long-term from a public health standpoint. There's nothing better that you can do for your child than to breastfeed your child and have that kind of close connection. It develops, obviously you heard everything I said, I don't need to repeat it, but without that, the children that are taken away from their parents, from their mothers in particular, that are not nurtured and breastfed, they can develop RAD, which is something that is prevalent within the DCF. And it is something that's a lifetime, doesn't go away. to deal with RAD, you have to have continual counseling forever. It is an attachment disorder. And there's not that many women right now, anyway, when I went to visit, that are having babies or pregnant within prison right now. Currently, that could change. The numbers fluctuate. But we should be able to allow them to touch their babies and hold their babies and nurse their babies during a visit. And that's what this is about. And I hope this committee will see the humanity in that.
Well, thank you very much. And clearly you spent a lot of time in the Department of Corrections studying this issue and trying to help the health issues. I was born a jaundice baby, so nursing was never an option and had to have soy formula and all
Do they
that
put you
jazz.
in the
So
sun? That's
maybe
good
I'm
to know.
suffering from RAD to this day and I just am undiagnosed, who knows? But I will say this, the little that I do know about the subject, certainly human touch is a fundamental issue. And I think that I am vaguely aware that studies have been done on primates where they lacked the ability to touch mother to child. And they had real serious problems as they developed without the lack of touch. I don't have any specialized knowledge on breastfeeding, but clearly this is an issue where, as with many other issues in the Department of Corrections, it would be nice to have testimony from the department either in writing or in person here this afternoon and this morning. But absent that, I don't know why we would forbid just basic human touching between a mother and her child. But thank you for coming and testifying, and thank you, Chairman Winfield and Staffstrom, whomever's in charge right now.
Thank you, Senator.
Questions to the committee. Representative O'Day online.
Thank you, Mr. Chair. Just briefly, thank you, Senator, for your testimony. I didn't think I was going to overshare like the good ranking senator, but I was jaundiced as well. And you know that my nickname was
Jaundice caucus.
Yes, I was nicknamed Little Anthony because I had a full head of hair and I was jaundiced. But in any event, you know, looking at it, do I understand your testimony now? And I'm embarrassed to say I don't know. So women who are incarcerated, they're not allowed, can they pump? Or are they not allowed?
Can pump. They do have a, well, the area that I saw, they can pump and they can keep their milk in a little fridge, but that is just not the same as having the skin to skin contact. Everybody probably here has seen the videos of when a mom gives birth and the baby's screaming and they put the mom, not the mom on the baby's chest, the other way around, the baby on the mom's chest, and the touch and the heartbeat, the baby calms down. So you really need that human touch and connection rather than, I mean, pumping is great. I mean, it's helpful, it's supplemental, but having that skin to skin contact with the mother creates that emotional bond. It creates sort of a reason. It also helps with postpartum and with someone who has just given birth and then has to give their child up. There's all these obviously things that can happen when you're not in that situation. And one of the things that I learned is, and I will say the company that I had, we hired, most of the women had been in prison and they came out and we gave them a second chance. I learned a lot from them. Nobody decides they want to be a criminal. Something usually bad happened in their life, a bad circumstance. They end up in a bad situation and they end up there, you know, because of the way life has given them circumstances. But I do think that we need to bring some humanity into the situations where women are having babies in prison and they have to give their child up. You know, they don't have the postpartum care that we all have access to. And those that are giving their child up to a relative, when the relative comes with the baby to visit, I can only see the benefits of allowing the mother to breastfeed that child during the visit. So I hope that the committee will see that also and push this forward.
Thank you. And I would note, at least according to the CDC study I saw, December 14, 2023, between 74.5 of mothers who identify as Black and 94% of mothers who identified as Japanese breastfeed. You know, so there is, I guess the vast majority do breastfeed, but I guess almost 25% of mothers who identify as Black don't breastfeed. Which I was surprised at, but in any event, well, thank you for your testimony. I greatly appreciate it. Thank you, Mr. Chair.
Senator Winfield.
Thank you. And Representative O'Day, we can have a very long conversation about that point if you would like at some point. But I just wanted to say to Senator Summers, thank you for supporting this this effort. We know way too much about the benefits of breastfeeding, the exchange of oxytocin, how it regulates the baby's heartbeat, their temperature, how the oxytocin itself helps to create that bond. We know way too much to be doing things the way that we're doing. And folks have figured out how to do this in other places. Connecticut is fully capable of doing this, and we should move forward. So I just wanted to thank you for your work.
Thank you for those words. I came up with an idea too. So if we have women that are allowed to breastfeed in prison, we could train other women in prison to be IBCLCs, which are the international standard for lactation consultants. And when they graduate or from that program and they are released from prison, they would instantly have an opportunity to work in our healthcare system. So I think it could be a win-win overall.
Let's look into it.
Thank you. Senator, just super quick, two just real, I mean, obviously great idea, full support, two kind of just nitpick points. One, I assume the way you envision this, there'd be some discretion for either the commissioner or the warden in the very rare, say you have an instance where someone is accused of abusing their child and you know, there would be some sort of carve out, right?
Absolutely.
Okay. And then I guess the other question is, I mean, I know we do this a lot in this building, but why do we need legislation on this? Like, why
Because
can't
they are actually prevented from doing that within the rules of the DOC and that's.
No, I get why
Right.
we should do it,
Oh,
why
okay.
we should force the department to do it,
Sorry.
but what is stopping the department from just doing this now? Why do they need to wait until January 1st of 2026?
They say that there is, when I talked to the warden, and I don't want to put words in her mouth, but she said they are prevented from allowing this to happen. Maybe their rules, I'm not exactly sure. That's why I said I'm
Yeah,
going
I
to
mean,
introduce legislation.
We're not changing the bill as written here. We don't change any statutes. You know, I mean, this is one of those bills that just sort of says, hey, department, go do this, right? We're not repealing anything in statute. We're not providing any additional funding. We're not, there's nothing we're doing other than saying, you should do this. I guess to Senator Kissel's point, it'd be really nice to have the commissioner here today when we're doing all sorts of Department of Corrections bills. We could ask him directly why they're not already doing this. But seems to me they shouldn't wait until January 1st of 2026.
Well, if we could pass this, then they maybe would have to do it.
Agreed. Thank you.